Good morning, everyone. It's a beautiful day here in Colorado. We hope it's a great day wherever you are. My name is Phil Tenser. Mitch and Kelly, who normally do our morning starts, our morning tosses to the courtroom, are out at the 7 News Free Coffee Friday event, so I'm filling in for them this morning. Today promises to be the very last day of the prosecution's case after what has now been 8 weeks of this Aurora movie theater shooting trial, seeking justice for what happened on July 20th, 2012 in Aurora, Colorado. We know, unfortunately, that it has happened again in this country, and so we are all watching very closely what happens today, what happens next week as the defense begins, and then, of course, what the jury decides later on in July or perhaps August of this summer. This morning and at some point today, we expect Ashley Moser to be called to the stand to testify. We know we've discussed this with you for the past 48 hours as the judge was making decisions on what to allow and not allow. She, as you'll remember, was gravely wounded, paralyzed, officially classified as a quadriplegic now because of her injuries in that mass shooting. She also lost her 6-year-old daughter, Veronica, and also her unborn child, who had been confirmed with a sonogram earlier that day, July 20th of 2012. What we'd like to do this morning as we wait for court to get underway in about 8 minutes is replay for you a section of the judge's ruling that will set the stage for what the prosecution is allowed to ask Ashley when she takes a stand, we assume at some point today, but probably this afternoon. So we'll play that for you now and join court as soon as it begins. As it is apt to do, our computer has a hard time waking up in the morning, but it'll play in just a second.
What's probative is that at some point she found out that Veronica did not survive. That's what's relevant. I don't think, I think that conversation with her mother and her mother trying to keep this information away from Ashley Moser, while understandable, doesn't have any particular probative value here. So I will keep that out under Rule 401 and Rule 403. So to the extent that it has any probative value, I find that the risk for unfair prejudice is large enough that it gives me concern, and I will not admit it under Rule 403. But I will allow the people to elicit testimony that at some point she found out that Veronica did not survive. And in fact, if you want to ask, at some point Sunday, I think it was, did you find out that Veronica did not survive? I think that's an appropriate question. And it should be phrased in that fashion. Did she at some point find out that Veronica did not survive? And to the extent that there is a 401 objection to that, the objection is overruled. And same thing with a 403 objection. First of all, the jury already knows about this, so I don't know what prejudice there is. They know that Veronica Moser Sullivan did not survive, and I think it's probative to allow Ashley Moser. I think it's appropriate, I should say, to allow Ashley Moser to say when she found out that her daughter didn't survive. But it's a one-question proposition. In terms of the hearsay objection, I suppose technically it's hearsay, but there's no other way that people can get that information, that at some point she became aware that her daughter is no longer alive. I think she has to be able to testify about that without going into a particular statement that was made to her. So this is based on her awareness that her daughter is not alive. And I think she can testify about that. Next is, Ashley was told at the hospital that she lost her unborn baby. Same type of thing. I think it's technically, I suppose it's hearsay, but the question should be phrased in terms of, at some point, did you find out that you had lost your unborn baby or that you lost your pregnancy? I think that's appropriate. This is her body. Of course, at some point she became aware that her unborn baby was no longer alive. Just as at some point she realized that her daughter Veronica was no longer alive. Whether anyone had told her that or not, she still at some point would have found that out. She still would have realized that. She would have become aware of it. So I'm going to overrule the hearsay objection on that. It has some probative value because this is part of the injuries that she suffered in this case, and the probative value is not substantially outweighed by the risk of unfair prejudice for all the reasons I stated in the record that I made a month ago, or maybe longer, when I admitted the loss of her pregnancy as evidence of her injuries in this case. So it is admissible under Rule 403. Next is that they had to remove the upper left lobe of one of her lungs, and that she now, as a result, has to use oxygen at night. And there's a 401 and 403 objection. The objections under Rule 401 and 403 are overruled. This is consistent with the order I issued earlier in this case, setting the parameters for what's admissible in terms of the injuries suffered by the victims in this case. This is clearly part of the injuries that Ms. Moser suffered, and I think it's appropriate evidence. And the left lobe of one of her lungs is strictly related to an injury, and the fact that she now has to use oxygen at night is part of the permanency or the consequence of the injury. And so that's within the parameters that I have set in this case, and I will allow that. Next is that she still has bullet fragments in her body and spinal cord. The Rule 401 and Rule 403 objections are overruled for the same reasons. These are part of the injuries that she sustained in this case, and part of the nature, extent, and the permanency of the injuries. Next is she had to stay at Craig Hospital from August of 2012 until December of 2013. Again, this comes within the parameters that I have set in this case, but I will not allow any activity in terms of what was taking place at Craig Hospital. It's a one-question proposition. How long were you hospitalized? And then she can answer between August 2012 through December of 2013. That, again, is related to the nature and extent and character of the injuries. And so, and it falls within the parameters that I have set. So the Rule 401 and Rule 403 objections are overruled because I find that it has probative value, and that the probative value of the evidence is not substantially outweighed by the danger for unfair prejudice. In terms of the string of things that she had to learn to do again, that Ms. Moser had to learn to do again, I'm not allowing any of those, and I'm not sure that the people were interested in any of them, with one exception, and that is nerve pain. Neuropathy is a part of the injuries that she suffered in this case. That's part of the consequences of the injury suffered. So to the extent that the people want to ask about that, that's appropriate, and to the extent that there's a Rule 401 and Rule 403 objection, the objection is overruled. It has probative value, and the probative value is not substantially outweighed by the danger of unfair prejudice. And this also comes within the parameters that I said in my previous order in terms of what's admissible as it relates to the injuries. I had a question. Mr. Brockler, I think, wanted to introduce evidence about how Ms. Moser had to learn again how to use a spoon. And I'm not sure I know enough about the injuries to be able to understand the probative value of that. So I need more information. So I specifically need to know, was this a cognitive injury? And that's what the people want to get into? Or is it an upper body, some type of upper body motor skills type of injury, and that's why the people want to get into this? Or is it something else?
Your Honor, immediately after this, she was classified as a quadriplegic and still remains technically a quadriplegic for diagnosis purposes, it sounds like. But in the intervening time since this shooting, because of the location of her paralysis at C7, she has been able to slowly regain limited use of parts of her upper extremities, and this spoon issue is part of that.
Well, I think you can introduce evidence along the lines of what you just said, without getting into specifics like learning how to grab a spoon or learning how to do specific things. I think saying that her upper body was affected by the injuries she sustained is appropriate, and including her motor skills and the fact that she was initially diagnosed as quadriplegic and perhaps technically may still be diagnosed as quadriplegic, but that she has learned or has been able to regain some movement in her upper body. I think that's fair, and I think that's appropriate. It's admissible under Rule 401 because it has probative value. It goes to her injuries. And it's admissible under Rule 403 because the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. These are the injuries that apparently she suffered, and it comes within the parameters that I have set in the order that I issued earlier in this case. So let me see if I can find that order, just so that the record is completely clear. It's Order C-200, order supplementing the court's ruling related to evidence of the nature, character, extent, and severity of the surviving victim's injuries. That's an order that I issued after the trial started on May 5th, 2015. So the last thing on my list is, let me back up just a moment. One of the things listed in the string was physical therapy 3 to 4 times, I think a week or something like that. I'm not allowing that either. I think, saying how long she was hospitalized and generally explaining the extent and character and nature of the injuries is what's appropriate. And so I don't think it's appropriate to go into the specifics in terms of how she had to learn how to use a spoon again, she had to learn to sit because of balancing issues, or to transfer from the wheelchair to the bed, or how to make a sandwich, or that she attended physical therapy after being released from the hospital 3 to 4 times a week at Craig, or how she has fallen, or how she can't use the restroom or get dressed, or how she's had subsequent infections, or anything related to Veronica's funeral. I think those are all excluded. I don't think those are all excluded. But like I said, the nerve pain, I think is appropriate.
Please be seated.
Lastly, thank you. Good morning, everyone. This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Stitch McGuire. We are outside the presence of the jury. Is there anything we need to talk about before I bring the jury in on behalf of the people?
But on the record, Judge, I did give your clerk a copy of our proposed hot mail exhibit after the court's ruling yesterday.
Yes, this morning, right? And I haven't had time to go through it. So if I need to do that, then I'll take another break and I'll go through it.
I understand. We just gave it to you this morning. I also gave a copy to the defense as well.
Okay. Are you intending to introduce it first thing this morning?
First thing, Judge, I think it'll be the second to last witness. So probably later this morning, depending on how the morning goes.
Maybe we'll get started and then take a break and I can review it at that point, and then the defense can review their copy as well. All right, is there anything on behalf of the defense?
Clear.
Okay, let's bring the jury in, please. Please be seated. Good morning, everyone. The record should reflect that the jury is now in the courtroom. How's everyone doing? Good. It's good to have you back. Ms. Stitch McGuire, you may call your next witness.
Thank you, Your Honor. Petra Hogan.
Good morning. Could I have you raise your right hand so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Okay, please be seated. Could you please turn the microphone toward you? There you go. And then please tell us your name and spell your first, middle, and last names.
Petra Hogan, or Petra Ann Hogan, and that's spelled PetraannehOGAN.
Ms. Stitch McGuire, you may proceed.
Thank you, Your Honor. Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and July 20th of 2012?
Yes.
Who were you going to the movies with that night?
I was with my friends Ethan Rodriguez Torrent and the friend that he had brought with him, Stephen Barton.
How did you know both of those gentlemen?
I met Ethan in 2008 at the Horatio Alger National Scholar Convention Summit because we both received the scholarship.
Judge, at this point, I'm going to object as to relevance.
Sustained.
How are those two people visiting you that day?
They were biking across the country from the Atlantic Ocean to the Pacific, and they arrived in Denver, and I offered to let them spend the night at my house. And so they were taking me to the movie as a thank you.
What time did you arrive at the movie theater that night?
We arrived at least an hour before it started, maybe more.
What did you do when you got to the movie theater?
We went in and we found our seats pretty easily.
Where did you find your seats in the theater?
We were sitting in the in the stadium seating. We were in the center, about half to 2/3 of the way up.
And if I may approach the witness with what's been marked for identification as People's Exhibit 1256.
Yes.
Ms. Hogan, I'm going to ask you to please write on that diagram a P for Petra, an S for Stephen, and an E for Ethan on the seats that you were seated in that night. If you could also please write your full name and today's date, which is June 19th of 2015.
I just wrote the wrong date.
That's okay.
accidentally.
You can write the new date. I said the wrong date, so of course you were going to write the wrong date. May I approach, Your Honor?
You may.
Your Honor, this time I'd move for the admission of People's Exhibit 1256.
I have no objection to 1256.
Without objection, P-TR-1256 is admitted.
Thank you, and with the court's permission, I would ask Ms. Hogan to be able to grab the cordless microphone and meet me at the 3D model.
Yes.
Thank you. All right, could you turn that on? Good, great. If you could please show the jury where you were seated that night.
Sure. We were right about here in the theater.
Could you please tell the jury where you were seated and where Mr. Rodriguez-Torrent was seated and where Mr. Barton was seated?
I was in between them, so I was about here. Ethan was on my right, and Stephen was on my left.
Please tell the jury about what happened in the movie theater that night.
I'd had a long day of work, and I was quite tired. And so, as the preview started, I started drifting to sleep. And I couldn't tell you how much time had passed, but I immediately woke up. It came to when I heard gunfire and saw flashes at the front of the theater.
And could you show the jury where you saw the flashes?
Right here.
That front upper right part of the theater, the screen's right up the front.
Yes.
Right, what do you remember after seeing that and hearing the gunfire?
I immediately knew that I was in a shooting and that there was a possibility of being shot. I knew there was the possibility of getting shot. And so, because we were in the middle of a row and the theater was packed, there was nowhere to go. And so, I remember putting my left arm on the seat in front of me as I began to get down behind the seats. And then I blacked out.
What's the next thing you remember after you blacked out that first time?
I remember coming to in face down behind the seats in a pool of sticky, thick liquid.
Could you hear anything in the theater at that point when you came to?
I could continue to hear gunfire, and I could hear screaming and running.
Could you see anything at that point in time?
No.
Please tell the jury about the next thing you remember.
I remember feeling my throat was burning and itchy, and I couldn't breathe through my nose, and I felt like I couldn't breathe at all. And so, even though I continued to hear the gunfire, I was trying to stand up because I couldn't breathe, and I thought that would help me. But Ethan realized what I was trying to do and climbed on top of me to keep me down behind the seats. And I remember after stopping to fight with Ethan to get up, I remember thinking, yeah, it's probably not a good idea to stand up while there's gunfire going on. And then I blacked out again.
What's the next thing you remember after you came to the second time?
The theater was quiet, and Ethan asked if I could get out of the theater, if I could crawl to the end of the row. And I said, I think I can. And so we army crawled to the end of the row.
Can you show the jury what you did, please?
This direction. So I was in front of Stephen, or excuse me, I was in front of Ethan in our army crawl. And when I got to the end of the row, I stood up, which was a little difficult for me. And I didn't realize there was an exit at the back of the theater. So I began walking down the steps of the theater. That's when I saw a body in a seat at the end of the row in one of these lower rows.
What did you do after you saw that body?
Well, the first thought that crossed my mind was there anything I could do to help that person? But the body was just sitting.
At some point in time, did you come to contact with Mr. Rodriguez Torrent again?
Yes. When he stood up at the end of the row, he called to me to come with him to exit out the back of the theater because we didn't know how many people had been firing weapons. We didn't know where they were, and so we walked up the stairs to the back of the theater, which was hard for me to do, and I didn't know why at the time. And we walked out of the exit, and Ethan continued to help me down the stairs, out the back of the theater, into the lobby. And then we walked out of the theater, and I was increasingly having difficulty walking, and Ethan set me down on a median outside the theater and said, "Wait here, I'm gonna go find an ambulance." And at that point, I didn't know what was going on, and I saw a figure that frightened me, and so I thought, I just need to get out of here because I need to be there for my mother.
Okay, thank you, Your Honor. At this time, Ms. Hogan, I don't have any further questions for you at this model. I'm going to ask that you retake the witness stand. Thank you. Ms. Hogan, were you transported for medical treatment?
Yes. A man named Daryl Wilmoth and another man who I don't know his name saw me on the median and carried me to the ambulance because at that point I was not really able to walk.
Was there anyone else in the ambulance when you were transported to the hospital?
No, it was just me, and I remember when I got into the ambulance, I finally felt safe, and I began crying uncontrollably, and I couldn't stop, and I didn't stop until I was in the emergency room, and they gave me meds.
Were you in any pain when you were in the ambulance?
Extreme pain.
Where were you hurting?
It was my left arm, my left forearm. It felt like I believed the time that my arm must have been broken because there was pain emanating from a single location. And at the same time, it felt like my arm was on fire from the inside out.
What hospital were you taken to?
I was taken to the Aurora Medical Center.
How many days in total did you spend at the hospital?
I spent 20 days.
Was that at 2 different hospitals?
Yes, it was.
Okay, please tell the jury what hospitals those were.
I was at the Aurora Medical Center, and then I was at the Spalding Rehabilitation Hospital.
Please tell the jury about what injuries you sustained as a result of the shooting.
I was shot 3 times. I had 1 pellet in my forearm. I had 1 pellet that passed through my like my bicep, tricep are outside of my arm area. And then I had another pellet that entered my nose, traveled through my brain, and stopped at the back of my skull.
How many surgeries did you have, Ms. Hogan?
I had 3.
Right. What was the first surgery for?
The first surgery was brain surgery to remove the pellet from the back of my skull. They had to remove part of my skull to
Objection, Judge,
remove the bullet.
403.
Overruled.
You can tell the jury about what they had to do in that surgery.
They had to remove part of my skull to retrieve the pellet that had lodged itself at the back of my skull.
What was the second surgery for?
The second surgery was to reconstruct my sinuses because the pellet blasted through my sinuses as it entered my brain.
What was the third surgery for?
The third surgery was to remove the pellet in my forearm.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 2035, 2036, and 2668.
Yes.
Ms. Hogan, do these pictures fairly and accurately represent the injuries you sustained as a result of the shooting on July 20th of 2012?
They do.
Your Honor, at this time, I'd move for the admission of People's Exhibits 2035, 2036, and 2668.
Is there any objection, Mr. King?
Judge, I would have no additional objection to 2036, and I have no objection to 2668. I would object to 2035 as cumulative under Rule 403.
All right, give me just a moment, please.
I think 2035 and 36 were subject to the court's order previously.
That's correct. Can I see the photographs, please? Okay, P-TR-2668 is admitted without objection. P-TR 2035 and 2036 were subject to amended order 98 or D98B. And so for those reasons, it is admissible. The question then is whether P-TR-2035 is cumulative. And I find that it is. So under Rule 403, I'm going to sustain the objection that has been made now by Mr. King with respect to P-TR-2035 under Rule 403.
May we approach, Your Honor?
You may. Okay, my ruling stands.
Your Honor, I would request to publish at this time.
Yes, you may publish 2668 and 2036. Both of those are admitted.
If I could please have 2036. Ms. Hogan, if you could please describe for the jury what we see in this photograph. And there's a mouse up there that doesn't work very well, but you could try to point out your injuries for the jury.
This right here is the entrance for the pellet in the forearm. This is the through and through, where there was no pellet lodged in, but this was the entrance, and this was the exit. And then it's hard to see, but the pellet entered my nose right about here.
Thank you. If I could please have 2668. Could you show the jury on this photograph where your injury was?
So the pellet entered right here.
I have no further questions for, oh, sorry, I do have one more question, Your Honor. Ms. Hogan, could you please tell the jury about the lasting injuries that you have as a result of the shooting?
The lasting injuries that I continue to have are all cognitive in nature. At the Spalding Rehabilitation Center, I was diagnosed with aphasia, which is can present, and in my case, presents as difficulty.
Judge, I'm going to object at this point under Rule 403.
All right, the objection is overruled. This goes to the permanent nature of the injuries.
Thank you, Your Honor. You can tell the jury what aphasia is.
Presents itself as difficulty sometimes finding words, constructing ideas, clarity of thought sometimes.
Thank you very much, Ms. Hogan. I don't have any other further questions for you.
Mr. King, do you have any cross-examination?
No, I do not, thank you.
All right, and the jury does not appear to have any questions for Ms. Hogan. Ms. Hogan, thank you. May she be released from her subpoena?
Please, thank you, Your
Is
Honor.
there any objection?
Without objection.
All right, thank you, Ms. Hogan. Call your next witness, please.
Hillary Allen, please.
Ms. Stitch McGuire, do you want to retrieve this? Thank you.
Your Honor, could we request that the model be moved unless it's going to be used with this witness?
Yes, that request is granted. Good morning. Can I have you raise your right hand for me, please? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
All right, please be seated. Could you please tell us your full name and spell your first, middle, and last names?
It's Hillary Faye Allen, Hillary Fayallen.
Mr. Brockler, you may proceed.
Thank you, Your Honor. Miss, would you please tell us what you do for a living?
I'm a graduate student at the moment
Where?
at UC Denver, in the Anschutz Medical Campus.
In what specific area?
Neuroscience?
I want you to take a look to your right here. And do you recognize the defendant in the beard and the mustache and the glasses seated over here?
Mm-hmm.
Tell us how you know him.
Is that a yes? I'm sorry.
Yes, that's a yes.
Thank you, Your Honor. Tell us how you know him.
He was a classmate of mine in the first year program of the neuroscience.
What's his name?
James Holmes.
When did you first meet the defendant?
At recruitment weekend, I believe.
That in 2011.
February. I'm not sure the exact date.
Do you remember having much interaction with the defendant back in February of 2011?
No.
When do you first recall sort of interacting in any meaningful way with the defendant?
Probably our first year once we were actually starting the school year. We had classes every day, core classes from 8 to noon, and then our own neuroscience classes.
Now, we have seen exhibits of class schedules, and we know there are core classes, and then there are a couple of electives. Because you were one of the neuroscience students along with the defendant, would you have seen him in class every day throughout the course of that first year?
Yes,
Okay.
roughly.
Now, you had different labs?
Mm-hmm.
Is that yes?
Yes.
I'm sorry, and the words matter because...
Sorry, yes.
That's okay. Tell me about the first observations that you had of the defendant back when you first started to have class with him in, did you say August or September?
August, I believe, is when the classes started.
Okay, of 2011?
Mm-hmm.
Thank you. Tell us.
Tell you
What were your
what?
first observations of the defendant? What did you observe about him?
It's hard to say. I mean, we're in class. I had little interaction in the actual classroom setting. However, I mean, we're scientists, so I mean, we're not the most talkative people. So, I mean, I don't know how to.
Was he quiet?
Yes.
All right. Early on, did you and others in the neuroscience program try to get together and socialize, or did you all just keep your separate lanes?
No, we had a lot of that at the very beginning, and we had certain groups that would study together or something like this. But James was not a part of that. I think he had his own. The first semester, I think he had his own set of friends. It wasn't until the second semester that I had more, interaction with him.
Now, that first semester, when you said he had sort of his own set of friends, do you know their names?
I know at least one of them, Gargi. I would see them, having coffee together, things like this. So I had little interaction with him outside of the actual classroom.
Okay, no conversations inside the hallway or before or after class?
A few. It was just more kind of an awkward hello or, something like that.
Tell us why it was awkward.
Just because I'm very friendly, and normally if I see someone I recognize, I would strike a conversation with them and say hello. He would keep his eyes down, but I thought that was just because he was shy or, not wanting to talk. So.
Did you find that unusual for the other guy scientists that you interacted with?
No, I mean I've encountered that before. So
you had the opportunity then to observe the defendant in each of his 3 presentations from his lab rotations?
Mm-hmm.
Is that yes?
Yes.
All right.
Yeah.
And describe them for us, the presentations.
So yeah, we were required to go to all the presentations. There's 6 neuroscience students. They were well prepared. They were very different from the interactions, the social interactions that I had with him. He seemed very confident in his presentations, I had to psych myself up for those presentations. It's quite an intimidating thing to do. But yeah, I thought they were well prepared. I mean, he seemed very intelligent, and at least the first 2 presentations, seems like he had a good rotation. I mean, he would tell these kind of like silly jokes during the presentations, which some might interpret as professionally like just inappropriate, but I mean, it's just kind of his style. But it was a lot different than what I knew of him, just from like walking by in the hallway and saying hello. He just seemed a lot more confident up giving his presentations.
Was that true with each of the 3 presentations you saw across the year?
Yes.
Now, at some point during the academic year, that first year, did you interact with him more over a certain rotation that you wanted to do?
Yeah, so initially, I think I struck up conversations with him, maybe like outside of class, because the students would talk to one another to figure out which rotations they were doing and which professors they liked or didn't like. And I wanted to rotate in the lab that James was rotating in. So,
which lab was that? I'm sorry to cut you off. Which lab was that, ma'am?
Achim Klug. That's who I wanted to rotate. And then later on, it was Mark Delacqua. Those are the labs I wanted, and was trying to get his judge of what he thought about the research or, that lab environment. But he beat me to it. Like, I never got to rotate in Nahum Klug's lab. I did get to rotate in Mark Delacqua's.
Now, in those conversations that you would have with the defendant about getting some sort of background or intel on these labs, how was he in talking with you?
Via text, it was okay. It was fine. It was like pretty social.
How about in person?
We did. I mean, it wasn't as kind of naturally flowing. We had a few interactions, like longer conversations, talking in person, but most of it was via text.
Was he different in person than he was in writing?
I would just think it's kind of like more like he was when he gave a presentation. He was more confident and more natural and more. I think that's common with scientists. Like, you have more time to think and like write out something than, I don't know.
You had an opportunity to observe him in class. Describe for us how he was in class. What would he do or not do?
I remember him never taking notes, and that kind of like made me mad because I was like, writing down everything I could to try to get a grasp on the material, and it seemed like he really had no problem remembering the material, or maybe it was because it was review for him. For me, all the material was new, so I would take notes, and that's just how I learned. I remember he just wouldn't take notes, and he seemed to do fine.
How would he sit in class? Would he seem attentive?
Yes and no. Mostly, it seemed like he wasn't paying attention, but then, when a professor would ask him a question, he seemed to do fine, or if he had like an assignment to do, it was okay. But it seemed maybe that he wasn't paying attention, but I guess he was.
But he answered all the questions the professors called on him for?
For the most part, yeah.
And as far as you know, got all the assignments done?
Yeah.
At some point, you guys have a mock grant proposal writing class? Mm-hmm. Is that true?
Mm-hmm. Yes, it was true.
Thank you. And during the course of that course, did you look at each other's work and pass it around and do stuff like that?
So this course is basically, it helps mimic a real peer review, they call it in academia. So like when you submit a grant, other professors from different universities would read your grant and submit a score to the NIH to like on these private committees. So it's called peer review. So we were trying to mimic that in our class. And so we would basically pass around our grants and judge them. So I probably read 2 or 3 different grants from other students.
What was your perception of the defendants?
It was really well written and good ideas, and I was actually quite impressed. It was the best one that I read.
And in fact, it was so good, what did you do with it?
I don't remember.
Did you show it to your dad?
I'm going to object to leading and relevance.
Sustain to leading?
Do you remember if you did anything with it or showed it to anybody else?
Judge, I'm going to object to relevance.
Hold on a second.
Can we approach, actually?
Yes, why don't you approach? Objections overruled.
I'm going to show you something here that's going to talk a lot about that thing that we were talking about. So before I do that, though, let me set the stage for this.
Okay.
Did you, prior to April 9th, 2012, did you engage in any sort of phone calls or outside of class socialization with the defendant?
No.
Did you ever exchange phone numbers or texts or anything like that?
No.
On April 9th, 2012, did you receive a text that later on turned out to be from the defendant?
Yes.
After you were contacted in this case, did law enforcement come and say, we'd like to get all the texts you exchanged with the defendant?
I voluntarily provided them.
And have you had a chance to review those in
Yes.
the past? And by the way, did you delete any of the text, or is what I'm about to show you everything that you had?
I didn't because, I thought it was important. So, they took pictures. I saw them, take pictures. And then supposedly they downloaded, the information from my phone. But I kept it on my phone until I got a new cell phone.
Okay. May I approach the witness, Your Honor?
Yes.
Yeah.
I think so too.
You may. What exhibit is this?
This is going to be People's Exhibit 1046.
Thank you.
Miss, would you take a look at that, please, and tell me, are those the text messages that you had on your phone that were exchanged between you and the defendant between exactly April 9th and July 8th of 2012?
Yes.
One thing I want to clarify on the record, would you look at page one, on the bottom right-hand corner, 1046.7. Oops. Scratch that. 1046.8 and 1046.9. Are those
Yes.
duplicates?
Yes, they are.
Yeah, other than that, just flip through that again and make sure, are those a fair and accurate copy of all the text that you exchanged with the defendant?
Yes. Looks like it's all here.
Your Honor, I'd move for the admission of People's Exhibit 1046 into evidence.
No objection.
All right, without objection, P-TR-1046 is admitted and may be published.
With the permission of the court, what I'd like to do, Miss, is I'd like to go through and have you put in context some of the conversations that are going on, and then I'd like to publish to the jury the individual copies of the text messages. Is that okay, Your Honor?
That's okay.
All right. Ma'am, would you put up 1046.1, please? Can you talk us through, is this the very first text you received from the defendant?
Yes.
Now, do you remember or know how he got your cell phone number?
No.
And is that captured in your response to the first text that you got?
Yeah.
All right. Now, this next part at the bottom that starts off and by the way, I should ask this, who is blue and who is gray?
Gray is James. I'm in blue.
Okay. The gray part at the bottom there, right under April 9th, 2012 at 4:39 p.m., sick of Delacqua yet, he would always linger way too long. Put that in context for us. What is that a reference to?
So I was in the Delacqua lab, so it was the third rotation. And Delacqua, he would come in, like late in the day and just kind of hang around the lab. And it's always awkward. Like if you want to leave and your professor's there, it's like your boss is there. You don't really want to just be like, hey, okay, I'm going to leave now. So,
Right.
yeah.
Okay. Ma'am, 10463, please. There's a great part here that starts off with no bueno. He got pissed at me. What are you guys conversing about here? Talking about Delacqua.
Just how he did in the lab itself. I was trying to figure out if he liked it or not, and apparently he did not like it.
Okay. And did he ever express to you any different feelings about that second rotation?
His second rotation, any different feelings other than that he didn't like it? No, it was definitely clear that he was not going to join that lab. That Delacqua, they just didn't get along, or, yeah.
4, please, ma'am. In speaking about the rotations, down here at the bottom, and ma'am, could you blow up the bottom gray and blue part right there? Do you know what, in talking about what rotations to do, what the defendant is referencing in his gray box there?
That he wanted to join Ahim Klug's lab?
Okay, thank you. Can you go to 6, please? This is all part of the same conversation. Your blue square, tell us what you're referring to here, what you're telling the defendant.
So I was roommates with Yom Puli. He was so he was my roommate. And I found out later that's how James got my number, because they had studied together. And so Yam was Korean, and he had another friend who I couldn't remember his name, like this other Korean guy. That's who I'm referring to. And I was telling him that I was sure which lab I was going to join, and that was my second rotation.
And so by April 9th, when you're having this conversation, you'd already had confirmation that you'd had a lab for the remainder of your PhD program?
Mm-hmm.
Is that yes?
Yes.
Sorry. All right, can you please go to 8, ma'am, and the bottom of that? Now, this is now April 23rd. It looks like there's been a break in the conversation since the 9th. What's going on here?
Okay, it's kind of awkward, but so it's summertime, like I'm wearing shorts in class, and I remember we're in the last class, I forget exactly, I think it's developmental neuroscience, maybe it's still systems, I'm not sure. One of the classes that we were in, we were done with core at this time, and so Carl Fenninger, I believe, was the professor, and he's notoriously he's hard, like he's strict, and so I remember we were having this lecture, and it seemed like, James was there not taking notes, like kind of, off in his own thing. And so Carl called him out to ask a question. And I think he maybe stumbled and then answered. And then after class, I got this text. Apparently I was in shorts, and it was distracting.
Out of the blue.
Yes.
Now, in between the 9th and the 23rd, in between these text exchanges, had you had any more contact with the defendant other than seeing him in class?
No, so that's why I was a bit taken aback. I remember just kind of like laughing out loud when I received that text message, just being kind of embarrassed.
Can you take us to 14, ma'am, please? In the bottom of that, please. Can you please put into and this is from April the 25th at about 4:43 p.m., back and forth. Can you put in context for us what you're talking about here?
Talking about the third rotation that James was in, how it was going, because we were probably preparing to give our third rotation talk, and he didn't have any data, so no really analysis to do.
Is that a problem?
No, it's common, actually. In a rotation, you only have 10 weeks to, have a project and generate data, so it's not always uncommon to have no data. A majority of the rotation talks are background, because takes a lot to kind of introduce the topic you're discussing. So, no, it's not uncommon. It happened.
This is probably a good time to ask you about, since you're a student, and we've had the professor perspective, from the student perspective, what is more important as you go through the neuroscience program, the academic classes or the lab rotations?
I would say the lab rotations. I mean, you have to pass your classes, but if you think about it, in our program, we're going to be in the lab for 5+ years. So, and the coursework is only, a year. So yeah, you have to pass it, but you also have to have a good rotation and a project to work on for the remainder of your thesis.
Now, is there a different skill set in your experience that you need to be successful in a academic classroom setting versus the laboratory setting?
Yes.
Tell us about it.
So, even in the classroom, there's still more work involved than, a regular undergraduate class. There's more responsibility on the student, but still you're guided through it because you have a syllabus and the professors are giving lectures and you know what to study. In the lab, it's definitely, the student has to take control over their project, and they always say, science is your baby. I mean, they say that in this is school, and it's true because you have to take care of it. You have to think about it when you're not in class. You have to think about it when you're not in lab, and it's your responsibility to drive that project forward. So if you're used to kind of someone holding your hand and walking you through what exactly you have to do, in most cases, most labs, that would be hard to, in most labs, professors are not going to do that. So
more self-initiative.
Yes.
Can we get, please, page 17, right in the middle? This is still part of the same text string, but at some point during this, is that the defendant asking you out for a hike?
Yeah.
Now, you hadn't approached him about the hike. He asked you?
Mm-hmm. Yes.
Thank you. And so there's a lot more text that goes on after this, but what ends up happening?
We go for a hike.
Where did you go do that?
In Golden Gate State Park, Golden Gate Canyon State Park.
In fact, can you get us to 22, ma'am, at the top? And is that it? Is that when you solidify, hey, we're going to go on this particular date?
Yes.
All right. Talk to us about what you did on that hike, and you can take that down. Thank you.
He chose the place. Ironically, I had never been there before, and I'm from Colorado. I think that's initially why he asked me, because I like doing things outdoors. So yeah, he chose it. We decided when we were going to go, the time.
Who drove?
He did.
And did he do anything else to prepare for this hike?
Brought snacks, like Gatorade, and.
How would you describe the level of preparation for this short day hike?
I mean, usually if I go hiking, I just bring water maybe, but other people always bring snacks. I didn't think it was over prepared, but just kind of all right, cool. He wants to bring snacks. That's fine.
How long were you guys hiking?
I think we went from about 1, and I had to be back by 6, so around there with the driving time and everything. So a fair amount of time.
Who did most of the talking on the hike?
Me, probably, because I'm a chatterbox.
Nonetheless, did you have decent conversations with the defendant?
Yeah.
And do you remember what you talked about this much time later?
Probably, I don't remember in particular. Nothing stood out like that was weird or just out of the ordinary. Just normal conversation about, what my family did, what his family did, what he saw himself doing in the future, what kind of, job, since we're, in grad school, what we're there for, and rotations probably.
Did the defendant seem to be more at ease talking with you in that setting than either in the classroom or the hallways, anything like that?
Yeah, yeah.
And then after the hike, where did you guys go?
He just dropped me back off at my house.
Was it at all awkward at the end there?
Well, yeah, because I didn't want it to be perceived as a date or something. So, I mean, I think he got out of his car and, we hugged or something and then said goodbye. But there's always that little awkward lingering, like, oh gosh.
Yeah. You're both sitting in the car kind of thing, that sort of
Yeah, a little bit, yeah.
lock the door.
Yeah, yeah.
Nothing like that.
Nothing like that.
Okay. Now, there was something else, by the way, that came up before you went on the hike. Did you, in these texts, and I'm referring now to page 28 at the bottom, ma'am. You told him, it looks like, that your house had been broken into. Do you remember that?
Yes, I do.
Okay, and then can you please go to 29, just the upper 2/3, a little bit down. Okay, now, a little more down, ma'am. Thank you. Does he express to you any concerns about his own safety in any of these text messages?
No.
Has he ever, even on the hike, expressed to you any concerns about his own safety based on what you've told him?
No.
The burglary, the attempted burglary that took place at your place, were you there for it?
Yes, I was.
And can you tell us, was there ever a screen that was cut to gain access to your apartment?
Not that I remember, no, just broken glass. Like, it was in a house, so the back door was broken into.
Thank you. Can you please go to 31, ma'am? Now, this again is still before the hike, but and can you blow up that top portion? Thank you. What kind of conversations are you getting into here?
What we're going to do after we pass prelims and get into the program and choose a lab. Stay here more long term.
Had you given any thought to buying a house or anything?
No. I always wondered how grad students could actually do that on their stipend.
Okay, can you go to 42? Now, I don't want this to be awkward either, but is there more banter being initiated here by the defendant?
Yes.
Would you consider this flirtatious?
Yes.
All right. Keep going down if you would, ma'am. By the way, do you guys ever end up going out again after that initial hike?
No.
Does he, in these texts, suggest that you ought to go on another hike again?
I think there was discussion about it, yeah.
It didn't happen, why not?
Yeah, I just got so busy and stressed out with school, honestly.
In fact, can you go to 48, ma'am, the last bottom blue part? Yeah, thank you. And we're now on May 5th. Is this sort of the last time that you have a conversation about going on a hike until well after?
Yes.
How about 49 at the bottom? It's May 8th now. What's going on here? What are you guys talking about?
Preparing for our third rotation talk.
Okay. And then can you go, ma'am, to 50, right about the middle below the blue part, or including the blue part. Thank you. So it's now June 1st.
Mm-hmm.
Are classes over by now?
Classes are over.
And you've seen that third rotation talk that the defendant gave?
Yes.
In terms of presentation, style, affect, demeanor, was there any difference between that and any of the other presentations?
No.
How about substance?
Substance, yes. It was, I mean, I knew that he had no data. Obviously, we discussed it. It was in the text messages. So that would be hard. I mean, if I was in that same position, that'd be hard to prepare a talk that I had no data for. So it was apparent that it was clear that he wasn't joining that lab because the content of the talk was not there. There was really no data, no analysis. Really, it just didn't seem like he had put much effort into it.
Now, when we go to June 1st here and you ask him about studying for prelims, he gives you this answer, don't really know what to study, and you respond with, yeah, I know everything. Tell us what that means.
Well, prelims is basically a day where you go in, and there's 3 professors, 1 from each course that we took from neuroscience, and it's open-ended. They just can ask you anything from the material that we've covered from that entire year. So, I mean, that is intimidating. You basically have to know everything that you've been taught. So.
They don't give you some sort of a list of here are the topics to be covered, or I'll
No.
ask quizzes, nothing like that?
No.
At the very bottom, we see that the defendant references to you another mountain trip. Was that the last hike that we saw you talking about almost a month before?
Yes, that May 6th, or that text message, yeah.
Now, he says here, Tony the Tigered. Did you know what that meant?
No, I did not.
Can you go to the top of page, ma'am, 51? And what does he tell you that it meant?
Flaked like a joke, yeah.
Tony the Tiger.
Yeah, frosted flakes.
Exactly. Okay, there is. Can you go to page 53, ma'am? Now, this is June the 7th, and you have just exchanged texts talking about each of one of you finishing prelims. I want to, you can take that down for a second, and then I'll have you bring it up in a minute. Where were you in terms of, we've heard already a description that there were 3 professors for 2 different groups, 3 students each, is that
Yes.
right?
Mm-hmm.
And the group that you were in, which time did you present, first, second, or third, do you remember?
Oh, I don't remember.
How about this? In terms of, you presented when in relation to when the defendant presented? Did you know?
Before. I know that much.
And how do you know that?
Well, because I was done and then asked him what he was obviously in my same group, like the 3 same professors.
I'm doing a horrible job of asking this. Let me just ask you, did you see the defendant in his prelim presentation that day?
Yes.
Okay,
Yes.
tell us how that happened.
Because basically there's a room where like a closed door session where the professors are, and then the other students are waiting in another room, before they go in to ask questions, and then the next student comes like 10 minutes early or whatever, and then, so there's some interaction.
My guess is you didn't really hear any of the substance of the presentation?
No, you're not allowed to, yeah, and you're not allowed to talk about it with the other students.
But you could see him?
In the room presenting, yeah.
Did he look to you in terms of physical appearance and attire and hygiene any different than he had at any other time that you'd seen him that year?
No.
In his mannerisms and the way he seemed to be answering the questions and presenting, could you detect any difference between that or any of the other presentations you'd ever seen him give?
No.
Okay, ma'am, if you go back up to the top of 53, you then have this conversation about how he perceives that he's done. You recall that?
Yes.
And then, do you think he's joking here about how he's done?
No, it's hard to tell, really.
Okay.
So, it's like an oral exam, and you can write down something, but, yeah.
Okay.
It's hard to tell, and it's intimidating to be in that room.
Did you know when you left whether you'd passed or not?
Yeah,
Did they tell you?
No, but I studied. I knew if I answered the questions correctly or not.
Okay.
So.
54, ma'am. Now we're 4 days later. Now we're at June 11th. And you ask him how he did. And he says no, and then if you'll go down a little bit more, ma'am, he says that he's probably going to quit, and then go down a little bit more. You don't know if he's being serious again?
Yeah, I thought he was being sarcastic.
Because?
Well, because normally that's not what the PhD program strives for, is to fail out their students the first year. So if you do fail a prelim, you have other opportunities to pass again.
Can you get us to 55, the second gray box? And I just want to ask you for clarification on this. He tells you he's quitting Fave Red. Do you know what that means?
I'm assuming it's talking about me. I have red hair, so.
Favorite red hair,
I
that
guess
kind of
so,
thing?
yes.
Okay, thank you. And then if you could go to the bottom of that, 55, ma'am, you reach out to him again on July the 8th. almost a month later. And you ask him, hey, are you back in California? Do you recall that?
Yes.
Now, before I get to 56, ma'am, can you take that down? Did you also see the defendant in a setting outside of school other than the hike that you did?
Yes.
Tell us where you would see the defendant.
I'd see him sometimes at the 24-hour fitness, the Lowry 24-hour fitness. That's where I sent this message. The last message kind of it popped my memory, like, oh, where's James? I haven't seen him for a while. Wonder what he's doing, like if he's really quitting, like what's happening.
And when you would see him at the 24-hour fitness, over the spring, you would see him there at the 24-hour fitness?
Yes.
What kind of stuff was he doing there?
Sometimes lifting weights, sometimes, on the elliptical. So, I would always initiate the conversation and say hello and, they'd say hi back.
And before I ask you about the text from July the 8th, let me ask you, after the hike, and you'd had that opportunity to have that sort of one-on-one time in the conversations and he dropped you off, was your relationship with him in the hallways or in the school any different than it had been before?
No, it was still more conversational via text, but in person, still kind of shy, and like I would always have to initiate hello and things like that.
Okay. Ma'am, can you get us to the top of 56? You ask him if he's going to California, and he tells you that he's not.
Yes.
And then can you go to page 57? And go down to if you go down a little bit there to, now, these are texts that you're sending him from 24-hour fitness?
Yeah.
He texts you this with the question mark there. Have you ever met someone with dysphoric mania? What did you do when you got that text?
It was really obviously we were talking about what you're doing afterwards, so it was kind of out of the blue. I looked it up, like
on your phone?
Smartphones, yeah. So I was looking it up while I was working out.
And did you look at what the described
Yeah.
traits were and whatnot?
Wikipedia.
Well, so it's accurate, sure.
Yeah.
Did you see any of the traits that you read on the phone in the defendant previously?
Objection. Lack of foundation, speculation, improper opinion, hearsay.
Sustained.
Now, can you go to, ma'am, page 58? This is you and go down a little bit, please. Thank you, sorry. You tell him that you've looked it up, ask him if it's manageable, and then you tell him, hey, look, I've struggled with some stuff too. What does he tell you?
Yeah, I guess that it was manageable.
Okay.
Apparently not anymore.
59, please. You ask him if he's okay, and he responds with,
Yep.
is that the last communication that you ever have with the defendant is just prior to midnight on July the 8th, 2012?
Yes.
Forgot to ask you about something when you're observing him in class. Did you also have the opportunity over the course of the year to observe his eyes? Pupils?
Oh, always when you're in class, like he was always, looking off somewhere. I do remember a couple times that it just seemed like maybe lack of sleep or something, like they were just really big and like dilated, but I didn't think anything of it. It just...
Over the course of that year, from the time that you first really, not February, because you didn't really interact, but from August of 2011 until the last time that you saw the defendant on June the 7th, 2012, did he seem to you to be in any way, in appearance, demeanor, affect, presentation, at all different?
No.
May I have a moment, Your Honor?
Yes.
Anything else? With the court's permission, could I publish these text messages to the jury, individual copies?
Yes, we can. Do you want to do that right now?
With the court's permission, sure.
Yes,
Yes,
let's
sir.
do that. All right, members of the jury, we're gonna publish Exhibit P-TR-1046. And we're gonna publish it the same way we've done other exhibits. We're gonna give each of you a copy, and then we'll retrieve the copies. So if you would give the copies to Ms. Gerlings, please, and then she'll distribute them. Yes,
I'm not sure how long permissible for Ms.
yes. Yes. Mr. Edson and Ms. Spengler, would you approach, please? Okay, the record should reflect that the prosecution has finished publishing People's Exhibit P-TR-1046. Oh, sorry. Now they're done. And please remember, folks, that you'll have an opportunity to review all of the exhibits that have been admitted into evidence. It'll just be one original. You won't have 19 copies the way that we've given them to you now, but during deliberations, you'll have the opportunity to review any exhibit that you wish that has been admitted into evidence. All right, Mr. Brockler?
No further questions, Your Honor.
All right. Ms. Brady, does it make sense to take our morning break before your cross-examination, or do you want to proceed?
I can tell the court it's going to be about 10, 15 minutes.
Okay. All right, I think we better take our morning break, yeah. All right, let's take 20 minutes, okay? Actually, let's take 25, because I need to address a couple of things with the lawyers. So please keep in mind all my advisements during the break. Thank you. Please be seated, everyone. And Ms. Allen, you can go on break. Thank you. All right, the record should reflect that the jury has exited the courtroom now. I've had a chance to review People's Exhibit P-TR-347A, and Mr. Edson, I think, is going to mark as a court trial exhibit the modified exhibit the way it was presented earlier today, and then before a few pages are taken out. Mr. Edson, as I understood his comments, has agreed to take out 4 pages from this exhibit. The page that I read into the record, at least I read the beginning of that page, and then the 3 pages that start with testing a system. Is that right, Mr. Edson?
Yes, Your Honor.
Okay. And so, given the modifications that have been made to this exhibit, and I think yesterday it was marked as P-TR-347 without the A, is that correct, Mr. Edson, or was there already a 347A even yesterday before the modifications?
It has always been 347A, Your Honor, and quite frankly, I've not put a formal exhibit sticker on it because I knew we were going through some of these, but that's how it's been referred to.
All right, I'll leave it up to you to determine what type of record for review purposes you want to make and how many of these you want to mark as court trial exhibit, but in an attempt to make the record clear, let me just state that yesterday the people tendered P-TR-347A, and I reviewed it, and after reviewing it, at the end of the day, I expressed some concerns in terms of the defense's hearsay objection. And I said there are things in the exhibit that appear to be admissible, but there are things that appear to be inadmissible pursuant to the hearsay rule, Rule 802. So in light of that, I sustained the objection. This morning, the people tendered a modified version of that exhibit. The people took out some of the contents of the exhibit to address the court's concerns. After reviewing the modified version of the exhibit this morning, I called Mr. Edson and Ms. Spengler to the bench, and we had a conversation. Based on that conversation, the people have agreed to make a second modification to the exhibit by removing 4 pages. The page that starts out with order number 76379, shipment completed. This shipment completes your order. All products have been shipped and should arrive shortly. Dear James Holmes, order number 76379 has been shipped. That page and the rest of that page, I just read the beginning, so the people have agreed to take out that page, as well as the 3 pages that start out with testing a system, and then S32I, that's a Roman or a capital I, remote firing system instructions. Those 3 pages, the people have agreed to take out as well. And so we now have an exhibit that has been modified twice. So does the defense want to be heard anymore with respect to this exhibit as it stands right now, the way it's been modified by the prosecution twice? Ms. Spengler, any other record that you want to make? And I'm not asking you to repeat all your objections. I'm asking if there are any additional objections that you wish to make or anything new that you want to say.
Nothing additional.
Okay, so the objections are, first, to hearsay. And as modified, this exhibit contains only the defendant's statements and in emails and the defendant's school product, school work that he has done, as well as statements of others, either responding to the defendant in email or statements from others that the defendant is responding to. And so as constituted, I am admitting the defendant's statements as statements or admissions by a party opponent under Rule 801, and so they're not hearsay. To the extent that there are statements from other people, they're being admitted for the limited purpose of placing the defendant's statements in context and making them intelligible. And so they're not hearsay because they're not being admitted for the truth of the matter asserted. So the objection as to hearsay is overruled. The objection under the confrontation clause is overruled because this is not hearsay, number one, and number two, this is not testimonial. The objection as to authenticity is overruled for all the reasons that Mr. Edson stated yesterday on the record, and for all the reasons that I also found that People's Exhibit, what was the exhibit number, Mr. Orman, in which I made the extensive record with respect to authenticity under People versus Glover 2 days ago?
1227.
Was it 1227? Well, Mr. Orman was the one who was up here. That's why I asked Mr. Orman about it.
The note I had, I left in our room, and I trust Mr. Edson to have the correct number, Your Honor.
Okay. Is that your recollection, Ms. Spengler?
It
Okay.
is.
All right. I wasn't sure if it was Ms. Spengler or not who was up here, but now I remember that it was Ms. Spengler. All right. So based on that extensive record that I made, I think 2 days ago with respect to P-TR-1227 and the authenticity of that record, I find that the objection, which is based on the second requirement in People versus Glover, must be overruled. And specifically, in People versus Glover, the court addressed the issue of authenticity, and more specific than that, the second requirement, the court indicated that there are 2 requirements. And the second requirement is that because a person may gain access to another person's account by obtaining the user's name and password, the person viewing communications on or from an account profile cannot be certain that the author is in fact the profile owner. That's sort of the second concern of authentication. And the court indicated that in light of these concerns, several, and when I say these concerns, I mean that one that I just read, which is the one at issue right now, and the one about whether you can establish, actually, let me back up. Let me back up because I'm reading from the wrong place in Glover. Okay, here it is. The court in Glover said to properly authenticate the printouts, and these were printouts from Facebook or Facebook communications. The prosecution had to make 2 separate showings. Number one, that the records were those of Facebook, and number two, that the communications recorded therein were made by the defendant. It's the second prong of that test that I'm concerned with here. Clearly, the first prong has been established through the witness the prosecution called. Was it Ms. Covalesi, who testified about the Microsoft emails.
Christine Cavalici.
Cavalici, okay. It is clear that that's established. Now, the issue is with respect to the second prong, and that's the objection, and that is that the communications recorded were made by the defendant. And so with respect to that second prong, the court in Glover explained that the primary authentication issue posed by the admission of Facebook records appears to be the identity of the author of recorded communications. First, because anyone can establish a fictitious profile under any name, the person viewing the profile has no way of knowing whether the profile is legitimate. Second, because a person may gain access to another person's account by obtaining the user's name and password, the person viewing communications on or from an account profile cannot be certain that the author is in fact the profile owner. In light of these concerns, several jurisdictions have concluded that where a message is posted on a social networking website, additional corroborating evidence of authorship is required beyond confirmation that the social networking account is registered to the party purporting to create those messages. And the court cited a case from Massachusetts, Commonwealth versus Purdy, P-U-R-D-Y, where the court said that a message sent from Facebook or from a Facebook account bearing the defendant's name cannot be sufficiently authenticated without additional confirming circumstances. And confirming circumstances is in quotes, indicating that the defendant was the author. The court in Glover then explained that many jurisdictions have articulated a similar requirement for the authentication of other electronic communications, including text messages or emails. And then the court cited some cases after that from other jurisdictions. I couldn't find anything in Colorado that's on point, but I think Glover offers a lot of guidance, and based on Glover, what I'm looking for in terms of the second prong of the test for authenticity is additional corroborating evidence of authorship. And in this case, Mr. Edson made an extensive record yesterday about that, and I agree with him that there is additional corroborating evidence of authorship here, including some of the terms that are used in the emails that were allegedly sent by the defendant, including some of the photographs in here of the defendant, which, by the way, were sent from his other email account, the CU email account, which I have found was authenticated or had additional corroborating evidence of authentication. When I mention the specific language used by the defendant, I'm talking about things like the nicknames that he used for his mother or the nickname that he used for his father, the way he signed off in some of these emails saying cheers, which is a sort of a unique way he signed off on many emails. The fact that some of the emails contain information that is contained within the CU emails. It's the same work product, which apparently is the same because he was transferring or forwarding some of the emails from one account to the other. And so you would expect to find some of the same schoolwork. I said work product, I meant schoolwork, from one email account to the other account, and so it matches. Let me see if I had anything else in here. There is evidence that some of the, although I haven't allowed some of that evidence, in some of those reports, there were reports in here from merchants confirming purchases that there has been evidence in this trial were made by the defendant. That evidence consists not only of receipts that were tied to the defendant's credit card or some other kind of financial type of device or item, but also through surveillance videos that have been introduced into evidence. And so there is evidence that the person who purchased these items was the defendant. And then there is evidence that these confirming emails were sent to the defendant's email address. Again, I have excluded some of those under hearsay grounds, but for purposes of authentication, I have considered them, even though I'm not letting the jury see them. I think that's all I have in my notes. So for all those reasons, the authentication objection is overruled. The next objection is under Rules 401, 402, and 403. I incorporate by reference the lengthy record that I made in admitting Exhibit P-TR-1227 last week on relevance grounds, and also under Rule 403. The same rationale applies here. These are just emails from a different account. That's the only difference, but they're emails, they're communications, and so the same rationale that I expressed for those other emails applies here. And I think these emails are probative, and I find that the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Let me see if I can address then the specific objections that Ms. Spengler made. Ms. Spengler objected to an application for an apartment that the defendant apparently filled out, and an email communication between the defendant and that landlord. As I understand it, this was an application, but it turned out that the defendant ended up agreeing to a lease with someone else, another landlord. But I'm not concerned that this is going to be confusing or that any of the dangers in Rule 403 apply here. I also find that this is relevant for the same reason that all the other emails are relevant. This is within the time frame that I have said is relevant here. It's in April of 2011. So it's as the defendant is moving from San Diego to Colorado. It's related to the defendant's attending school, the defendant's attendance at the University of Colorado here in Colorado. And it's the defendant making preparations for an apartment. So I think it goes to all the issues that are raised by the defendant's plea of not guilty by reason of insanity, as well as the culpable mental state elements required by the offenses charged. Next is the defendant's schoolwork. And the concerns were that there's no grade, that the defendant's just sending it from one email to the other, that it looks sophisticated, but this is there's been no evidence related to neuroscience, and that this is cumulative to other schoolwork. I'm not concerned that there was no grade assigned to this schoolwork. It's not being admitted to show how well the defendant's schoolwork, this particular piece of schoolwork was, how it was graded. It's being introduced for the reasons that I stated, the issues raised by the insanity defense, as well as the culpable mental state elements of the offenses charged. In terms of the fact that he sent it from one email to the other, Ms. Spengler is right that it was sent from one email to another, but there is an objection to authenticity here, so this goes to authenticity. And so if the defense is contesting that these really are emails in Mr. Holmes's email accounts, and that it was Mr. Holmes who sent these emails and received these emails, then this comes in. And I think it's relevant to show that this really was him and not someone else. The fact that it looks sophisticated, but there is no information on neuroscience or some of the concepts described, these are not being introduced to explain those concepts. I talked about this yesterday. And again, if the defense wants me to give an instruction, I will consider it. But frankly, I think we're better off just handling it the way we've handled it. The jury understands that this is not about neuroscience or the specific concepts in neuroscience. The jury gets that the issue here is the insanity defense. That's the primary dispute in this case, if not really the only dispute in this case. And of course, related to that, the culpable mental state elements of the offenses charged. That this is cumulative, yes, it's cumulative. It overlaps with other evidence, and it is to some extent cumulative to other evidence, but it's not the unnecessary presentation of cumulative evidence, and it certainly does not substantially outweigh the probative value of the evidence, because The defense is contesting that it was the defendant who was the author of these emails, that it was the defendant who received and sent these emails. And so I think it goes to that. It goes to show that it was him who was sending emails from one account to the other, from one email account to the other email account. Then I think there was an objection about a May 15, 2012 email that has classwork. And I think the objection was that it's not clear what the assignment was, and that it could be confusing. I'm not concerned about it being confusing because it's not being introduced to show whether the defendant completed this particular assignment properly. It's being, again, introduced to show some of the work the defendant did, which goes to his mental capacity, his cognitive abilities, and whether he had the capacity to distinguish right from wrong, and the capacity to form the culpable mental state requires by the offenses charged. And to the extent that the counsel is concerned about any of this being confusing, that can be addressed in cross-examination or through other witnesses and or in closing arguments. Finally, there's an email about Diablo 3, and Ms. Spengler, I think initially said that there was no reply from the defendant. I think what happened is that the defendant sent an email to, is it blizzard.com? Blizzard.com, and then blizzard.com responds to him. The fact that the defendant doesn't reply after that does not mean that the email exchange is inadmissible. Again, it goes to all the issues that I have talked about, so I'm not concerned that he didn't reply to that email. Next is an email related to the prescription from Dr. Fenton, but that has been taken out, so that has been rendered moot. And then last is the email related to purchases, including Fandango, and the objection was cumulative, that much of this has been admitted through other exhibits, and the people have excised most of these documents. Now, they've taken them out, not excised the documents, but taken the documents out of the exhibit. Is that from what I see, right, Mr. Edson?
Yes, most all of them, with the exception of ones in which there's specific replies from the defendant.
Right, and as to those, the probative value is the defendant's communication about those receipts or order confirmation notices. It's the defendant's communications that is particularly probative, and I find that that probative value is not substantially outweighed by the danger of the unnecessary presentation of cumulative evidence or about any concerns related to that, so, or any other concerns in Rule 403. I think I have addressed all of the concerns raised by the defense, but if there's something else that I'm missing, Ms. Spengler, you can let me know. Did I miss something?
The court's addressed all of the emails.
Okay. All right, thank you. All right. In terms of Ms. Moser's testimony, I just want to wanted to clarify part of my ruling yesterday because I want to make sure that there are no issues and that we, to the extent possible, that we avoid any objections. There was an objection to a string of things that Ms. Moser is no longer able to do or perhaps has had to learn how to do again, such as holding a spoon or making a sandwich, that kind of thing. I am not prohibiting the prosecution from introducing evidence related to her injuries and the effect those injuries have had in general on her. I think that's fair. So, for example, to the extent that her upper body motor skills have been affected, the people are entitled to present testimony of that. That's part of the injuries that she suffered. To the extent that she has had to relearn some of the daily activities that we all participate in or we all have to undertake, that's fine too. She can testify to that. To the extent that she has been able to learn and been able to do some of those again, but not others, in general, she can say that. What I think is unnecessary is to have her go through and specifically say about making a sandwich, going to the restroom, grabbing a spoon, getting dressed. There was a long list. That's the part that I don't think it's necessary to paint a full picture of what the injuries are. The people are entitled to present evidence of the injuries and to have her testify about the consequences in her life in general as a result of the injuries that she suffered in the shooting. I talked about nerve damage. I also talked about part of her lung having to be removed and the need to use oxygen at night. Those are all consequences of the injuries that she suffered in the shooting. I just don't want the people to get into a list of 20 individual examples of these injuries or consequences of the injuries. Does that make sense?
Yes, Your Honor.
Okay. And I didn't get the sense, by the way, that Mr. Brockler was necessarily intending to go into all those things based on the argument we had. My recollection was that Mr. Brockler specifically was interested in learning to grab a spoon, but wasn't wedded to some of the other things on that list. But regardless, I think what is consistent with Order C-200 is that you present, what's fair is to present a picture of the injuries, and without then going into more specifics than that in terms of every single activity that either she cannot do or that she has had to learn to do again. So I wanted to clarify that to avoid to avoid objections, hopefully. If there are objections, obviously make them, and then I'll rule on them as they're made. Is there anything else at this time on behalf of the people?
Just, when are you gonna want us back, since, you told the jury 25 minutes and we sort of.
Is it okay if we take 10 minutes, or do you folks need more?
That's fine with us.
Is that okay with the defense, or do you need a little more? Fine, okay, let's plan on us taking about 10, actually, you know what, that's not fair to Ms. Martin and my staff. Let's take 15, and we'll just start a little late, all right? Thank you, the court will be in recess.
Good morning again. This is Phil Tenser here in the 7 newsroom as we now take 15 minutes recess from court, which is probably going to add up to about a half hour for the jurors, but the judge needs to give his staff a few minutes as well to stretch their legs. Therefore, we're going to replay some segments. We're going to start with the testimony from the very emotional testimony, I should say, from earlier today, and then we'll replay some of the text messages that we heard discussed and shown on that screen in court. And this time I won't do the zoom in because I know it became very blurry and difficult to read. But interestingly, and we know that there are a lot of you watching today specifically waiting for Ashley Moser's testimony, which we do expect to be this afternoon, potentially one of the last things after they discuss all these Hotmail emails the judge just had that extensive ruling on. The judge did clarify his ruling about what Ashley Moser will and will not be allowed to discuss. We have a complete list of that on the denverchannel.com and your 7 News app today because we know how anticipated her emotional testimony is going to be. We do expect that is going to be how we end the prosecution's case this afternoon after everything wraps up, assuming everything wraps up on time. But for now, for the rest of this 15-minute break, we're going to replay these segments from earlier this morning.
All right, could you turn that on? Good, great. If you could please show the jury where you were seated that night.
Sure. We were right about here in the theater.
Could you please tell the jury where you were seated and where Mr. Rodriguez-Torren was seated and where Mr. Barton was seated?
I was in between them, so I was about here. Ethan was on my right, and Stephen was on my left.
Please tell the jury about what happened in the movie theater that night.
I'd had a long day of work, and I was quite tired. And so, as the preview started, I started drifting to sleep. And I couldn't tell you how much time had passed, but I immediately woke up. It came to when I heard gunfire and saw flashes at the front of the theater.
And could you show the jury where you saw the flashes?
Right here.
That front upper right part of the theater, the screen's right up the front.
Yes.
Right, what do you remember after seeing that and hearing the gunfire?
immediately knew that I was in a shooting and that there was a possibility of being shot. I knew there was the possibility of getting shot. And so, because we were in the middle of a row and the theater was packed, there was nowhere to go. And so, I remember putting my left arm on the seat in front of me as I began to get down behind the seats. And then I blacked out.
What's the next thing you remember after you blacked out that first time?
I remember coming to in face down behind the seats in a pool of sticky, thick liquid.
Could you hear anything in the theater at that point when you came to?
I could continue to hear gunfire, and I could hear screaming and running.
Could you see anything at that point in time?
No.
Please tell the jury about the next thing you remember.
I remember feeling my throat was burning and itchy, and I couldn't breathe through my nose, and I felt like I couldn't breathe at all. And so, even though I continued to hear the gunfire, I was trying to stand up because I couldn't breathe, and I thought that would help me. But Ethan realized what I was trying to do and climbed on top of me to keep me down behind the seats. And I remember after stopping to fight with Ethan to get up, I remember thinking, yeah, it's probably not a good idea to stand up while there's gunfire going on. And then I blacked out again.
What's the next thing you remember after you came to the second time?
The theater was quiet, and Ethan asked if I could get out of the theater, if I could crawl to the end of the row. And I said, I think I can. And so we army crawled to the end of the row.
Can you show the jury what you did, please?
This direction. So I was in front of Stephen, or excuse me, I was in front of Ethan in our army crawl. And when I got to the end of the row, I stood up, which was a little difficult for me. And I didn't realize there was an exit at the back of the theater. So I began walking down the steps of the theater. And that's when I saw a body in a seat at the end of the row, in one of these lower rows.
What did you do after you saw that body?
Well, the first thought that crossed my mind was there anything I could do to help that person? But the body was just sitting.
At some point in time, did you come to contact with Mr. Rodriguez-Torrent again?
Yes. When he stood up at the end of the row, he called to me to come with him to exit out the back of the theater, because we didn't know how many people had been firing weapons. We didn't know where they were. And so we walked up the stairs to the back of the theater, which was hard for me to do, and I didn't know why at the time. and we walked out of the exit, and Ethan continued to help me down the stairs, out the back of the theater, into the lobby. And then we walked out of the theater, and I was increasingly having difficulty walking, and Ethan set me down on a median outside the theater and said, "Wait here, I'm gonna go find an ambulance." And at that point, I didn't know what was going on, and I saw a figure that frightened me, and so I thought, I just need to get out of here because I need to be there for my mother.
Okay, thank you, Your Honor. At this time, Ms. Hogan, I don't have any further questions for you at this model. I'm going to ask that you retake the witness stand. Thank you.
And is that it? Is that when you solidify, hey, we're going to go on this particular date?
Yes.
All right. Talk to us about what you did on that hike, and you can take that down. Thank you.
He chose the place. Ironically, I had never been there before, and I'm from Colorado. I think that's initially why he asked me, because I like doing things outdoors. So yeah, he chose it. We decided when we were going to go, the time.
Who drove?
He did.
And did he do anything else to prepare for this hike?
Brought snacks, like Gatorade, and.
How would you describe the level of preparation for this short day hike?
I mean, usually if I go hiking, I'd just bring like water maybe, but other people always bring snacks. I didn't think it was like over prepared, but just kind of like, all right, cool, he wants to bring snacks, that's fine.
How long were you guys hiking?
I think we went from about 1 and I had to be back by 6, so around there with the driving time and everything. So, a fair amount of time.
Who did most of the talking on the hike?
Me, probably, because I'm a chatterbox.
Nonetheless, did you have decent conversations with the defendant?
Yeah.
And do you remember what you talked about this much time later?
Probably, I don't remember in particular. Nothing stood out like that was weird or just out of the ordinary. Just normal conversation about, what my family did, what his family did, what he saw himself doing in the future, what kind of, job, since we're, in grad school, what we're there for, and rotations probably.
Did the defendant seem to be more at ease talking with you in that setting than either in the classroom or the hallways, anything like that?
Yeah, yeah.
And then after the hike, where did you guys go?
He just dropped me back off at my house.
Was it at all awkward at the end there?
Well, yeah, because I didn't want it to be perceived as a date or something. So I think he got out of his car and we hugged or something and then said goodbye. But there's always that little awkward lingering, like, oh gosh.
Yeah, you're both sitting in the car kind of thing, that sort of.
Yeah, a little bit, yeah.
Lock the door.
Yeah.
Nothing like that.
Nothing like that.
Okay. Now, there was something else, by the way, that came up before you went on the hike. Did you, in these texts, and I'm referring now to page 28 at the bottom, ma'am. You told him, it looks like, that your house had been broken into. Do you remember that?
Yes, I do.
Okay, and then can you please go to 29, just the upper 2/3, a little bit down. Okay, now, a little more down, ma'am. Thank you. Does he express to you any concerns about his own safety in any of these text messages?
No.
Has he ever, even on the hike, expressed to you any concerns about his own safety based on what you've told him?
No.
The burglary, the attempted burglary that took place at your place, were you there for it?
Yes, I was.
And can you tell us, was there ever a screen that was cut to gain access to your apartment?
Not that I remember, no, just broken glass. It was in a house, so the back door was broken into.
Thank you. Can you please go to 31, ma'am? Now, this again is still before the hike, and can you blow up that top portion? Thank you. What kind of conversations are you getting into here?
what we're going to do after.
Please be seated. Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The records should reflect that Mr. Holmes is present with his attorneys, and a couple of the prosecutors are present. We are outside the presence of the jury at this time. I thought during the break, I thought a little more about the objection, Ms. Spengler, that you made with respect to the school work in Exhibit P-TR-347A. I think if there had been some testimony that the defendant was just copying his schoolwork from some source, or that his schoolwork was sophisticated but not intelligible, I might agree with your concern, or I might have concern, but the testimony in general, and there has been a lot of it from professors and from research assistants and from other students, has been that in general the defendant's written product was good, and that he was in general an excellent student, at least in terms of his written work. So I don't have the concern that, well, this could just be sophisticated or sound sophisticated, but it could be something that's not coherent or intelligible. And the jury would be considering it for the issues raised by the insanity defense and for the culpable mental state elements of the crimes charged. I think when considered in conjunction with the other testimony, that's I'm comfortable that the jury will understand why this has been admitted, and I'm comfortable that whatever inferences, reasonable inferences can be made, the jury will choose which ones they think they should make. But I'm not concerned that they're going to be misled or confused into thinking that this sounds sophisticated and it sounds scientifically complex, but that really it's not something that's intelligible or something that is coherent or something that's logical. There's no basis for me to believe that. So, okay, is there anything we need to talk about before I bring the jury in on behalf of the people? No?
Your Honor, only with regard to logistical planning for the rest of the day. We're still targeting, trying to be done by the end of today, and I wonder if the court would entertain even a partially abbreviated lunch from 1.5 hours to 1 hour and 15 minutes, or whatever the court thinks is appropriate, just so that we can finish up today.
And when you say finish up today, that includes 3:30?
Yes, sir.
Okay, all right, we can do that. Anything from the defense, Mr. King? No. All right, let's bring the jury in, please. Please be seated. The record should reflect that the jury has joined us again. Ms. Allen, I remind you that you're still under oath. And Ms. Brady, you may proceed with your cross-examination of Ms. Allen.
Thank you. Good morning.
Hello.
How are you?
I'm okay. How are you?
I'm good, thank you. I don't have too many questions for you, but I do have some. In general, James seemed to keep to himself. Is that fair to say?
Yes.
And you felt that he was somewhat socially awkward?
That's my opinion. I mean, yes.
Okay. And he was introverted,
Yeah,
a little bit quirky,
yeah,
but he was always nice.
yes,
And that first text that he sent to you on April 9th, you had never texted him before, correct?
correct.
He texted you first, and that was what the jury has seen on April 9th of 2012.
Yes,
And that was completely unexpected on your part. You were very surprised to see that he had texted you.
yes,
Usually you would have to be the one to talk to James, not vice versa.
correct.
And he would be in class with you every day for the school year, basically, and he would not speak to you in class. You would always have to approach him and speak to him.
Initiate a conversation, yes.
Okay. And you thought that it was weird that when you were in class, he wouldn't really talk, but then after class, you would get texts from him.
Yes,
And that one text came about your shorts, and you took that as sort of a flirty text from him.
yes,
And you came to believe that maybe he had a bit of a crush on you?
perhaps, yes.
When you guys went hiking, I think you testified earlier, it was his idea maybe to go hiking?
Correct.
And you thought it would be fun, so you agreed to go?
Yes,
And you said you were more talkative than he was on the hike?
yes,
And he was more talkative once you actually started hiking versus earlier in the car?
yeah,
So after a little bit of time, he came out of his shell a little bit, at least on the hike?
yeah,
You and James never really spoke on the phone. It was either in person or by text?
yes,
And the most common way you guys communicated was by text?
yes,
Even if you would be passing him in the hall, he wouldn't speak unless you spoke first?
from what I remember, yes.
And when you were speaking to him, he wouldn't make very good eye contact, is that fair?
And unless, provoked, I said hello, and then he would look at me.
Okay, and at times, I think you've said he would fidget around and look down and then eventually look at you in the eye.
Yes,
Even when you would run into him at the 24-hour fitness, same thing, you would have to approach him to have any interaction with him,
yes,
even after you went hiking?
yes,
You spoke to Mr. Brockler about the difference between the coursework and the lab work. Is it fair to say in lab, you have to interact with other grad students and the PI and the people in the lab?
yes,
And even though in class there's some discussions, that's mostly listening to lectures or studying, and it's more independent work.
classroom, yes, it's independent, yeah.
And then in the lab, it gets a little more interactive.
I mean, no one in my lab would have my same project, but of course I'd have to, interact with your lab mates. Ideally, you would, like your coworkers, but that's not always the case.
Now, you saw James's third lab presentation, you said.
Yes,
You felt like he used weird jokes during his presentation?
I felt that way during all of them. It was just his style, I guess, of presenting. Yeah.
And you thought his voice sounded a little bit like Kermit the Frog when he was doing presentations?
I guess so. I mean, yeah, maybe.
And it was a little bit awkward?
Well, for me, I mean, I get it. I wouldn't have the confidence to kind of throw jokes around when I was presenting in a formal scientific setting. So it made me nervous, just because it's oh my gosh, I hope. Yeah.
Because you'd be worried that would be an inappropriate setting to have jokes?
Yeah.
And you thought since he could do it, he was confident enough to use those jokes?
Yes.
Okay.
or maybe a nervous tic. I don't know. It was a common theme throughout each presentation.
Okay. And in that last one in particular, you felt that he did not seem to be prepared and seemed uninterested?
Correct.
Now the lab presentation, that's different than the big formal prelim at the end of the year, right?
Yes.
And that's the one where you were not in the room, you could just see him, but you couldn't hear what was going on in the room?
Yes.
Okay. That was the very last time you saw him, was at that prelim where you could see him taking the prelim?
Correct.
And it was the next day where he told you by text that he didn't pass and he was going to quit?
I can look at the dates of the text, but yes, I believe so.
Okay. Go ahead and check if that'll help you remember.
That was in June.
Would it be June 8th?
Oh, yes, June 7th. Yeah.
All right. And you didn't see him again after that?
Nope.
And you didn't run into anyone who had seen him after that? Like other people at the school didn't seem to have run into him after that either?
No, and that's because we're not in classes anymore, so the 6 of us would not really congregate together. We're choosing our labs and kind of having a break at that point.
And you didn't run into him at 24-Hour Fitness or around anywhere?
No.
Now, it was when you were at the gym on July 8th, when you thought of him and thought you would reach out by text and see where he was and what he was doing?
July 8th, yeah. It struck my memory because that's sometimes where I would see him, and I hadn't for a while.
And that's when you got that text back about dysphoric mania?
Yes.
And that he was bad news bears?
Yeah.
And that it was in your best interest to avoid him?
Yeah.
And floodgates open now?
Mm-hmm. Yes.
Yes. Can I get a page 1046-59? It's the very last page of that text, Your Honor. Is that okay if we
Yes,
publish that?
absolutely.
And just go past the yep, please. There you go, thank you. Up just a little bit. Great. Now, Mr. Brockler asked you about where you say, are you okay? I'm not scared of that stuff, referring to the reference to dysphoric mania. I mean, you say, I've been there, believe me, not the exact same, but I can understand. And he writes yep. Now, it's not completely clear what the yep is in reference to in that whole paragraph that you wrote to him, correct?
Yeah, correct.
He could just be acknowledging the comments that you made?
That or answering the question, are you okay? Yeah, in any of those, yeah.
So it's not clear what he's saying yep to, is it?
No, from that, it's just I don't want to talk about it, so.
Okay, all right, thank you. And then that was the last text you got from him?
Correct.
Mr. Brockler asked you if you saw any change in James from August of that school year of 2011 to till June, the last time you saw him in 2012.
Yes.
Is it fair to say he was a little bit more involved in the first semester than the second semester?
I think that's hard for me to say because I didn't know him till second semester. I didn't have more interaction with him until second semester. So, yeah, it's hard for me to say.
Did you get the impression he participated more in the first semester than the second semester?
I don't remember. That first semester was such a hard time. We were just so busy. I mean, I do remember he wasn't hanging out with his normal friends after that. Like, I didn't see him with Gargi anymore.
In the second semester?
Yeah.
And do you remember, and it's been a long time ago, right?
Yes.
This is 2015, and we're trying to remember back to 2011.
Yes.
Do you remember when you spoke to Detective Craig Apple and Detective Todd Frederickson on August 29th of 2012?
I don't recall the names. However, I talked to several.
Do you recognize Detective
Yes.
Apple here?
Yes.
To my right? Do you remember Detective Apple asking you whether you saw any change in him in the months or weeks from when you met him to when you guys stopped talking? And do you remember that you told him just the fact that I never saw him hanging out with anyone second semester?
Yeah, and that's what I just said. Like, I didn't see
Right.
him with Gargi anymore, and that's who I usually saw him with.
And you also
some other
said, so,
gentlemen.
I'm sorry,
Oh, some other, I don't remember their names, but there were 2 other students that he would hang out with as well.
and he was not with them in the second semester.
That I would see, no.
Okay. And do you also remember saying, so he just wouldn't talk or do anything, like he wouldn't participate at all? At least he did a little in the first semester?
I mean, I guess I'm sure I said it. Obviously, it's right there.
And if you said that, would you think, since that was closer in time to the period we're talking about, if you said that, do you think that that was your impression, at least at that time?
Yes.
And Mr. Holmes was never really someone who tried to stand out in a crowd. Is that fair?
Well, I mean, in the presentations that he gave, he stood out in his style. But I mean, like from when I first met him at the orientation that we had, like our interview weekend in February, like I wouldn't pick him out of I didn't really remember him. So
Okay. And what didn't seem like someone who was trying to draw attention to himself in class or socially.
no.
Can I have a moment, Your Honor?
Yes, you may.
I think that's it, Ms. Allen. Thank you.
Is there any redirect, Mr. Brockler?
Yes, Your Honor, thank you. Ma'am, could you put up 54, please? I just want to make sure I'm clear on something. You had been asked by Ms. Brady about when you received a text from the defendant saying that he had failed the prelims, and there had been some discussion about it happening right after the prelims.
Yeah, I was going to say that. It's June 11th. Yeah.
Yeah, can we blow that up, ma'am, where it says that? It looks like this confirmation from the defendant takes place at 11:18 on June the 11th. Is that what you see too?
Yes.
And you didn't get notified either in person, text, or any other means before then that he had failed the prelim?
Correct.
Okay, thank you. Just a couple things to confirm with you. The description that you went through with Ms. Brady about him being quiet and quirky and introverted and a little socially awkward, couple things. One, was that incredibly inconsistent with other guys in the science field that you had had exposure to?
Objection asked and answered.
Overruled.
No.
And was that consistent throughout the time that you knew him, from roughly August 11th through, I guess, May and then July of 2012?
Yes. Yeah.
Do you know if the defendant and Gargi broke up sometime around the end of March, early April?
I did not know.
When you described for Ms. Brady, in reference to a statement that you made to Detective Apple some time ago, that he seemed less involved with those people, is that what you're referring to, him stopping hanging out with Gargi and maybe a tall, kind of really pale guy with light hair?
Yeah, I don't know his name. Yeah, that
Okay.
guy. Yeah.
And that's what you're talking about?
I mean, yes, and I just didn't see them, having coffee or something together.
May I have a moment, Your Honor?
You may.
Your Honor, nothing further, thank you.
Is there any recurrence?
Very briefly.
Okay.
You're almost done. It was, in the second semester, it was more, though, than just not hanging out with Gargi. You said that he wouldn't participate at all. At least he did a little in the first semester. Do you remember saying that to Detective Apple?
I don't recall, but I mean, if it's there, sure. That also might just be from the content of the material. Like, I'm sure I was less participatory in the last two classes just because they didn't interest me as much. But.
And you don't know why, but he did seem to participate a little bit less in the second semester.
Yes.
Thank you. Nothing further.
All right, there appears to be a question from the jury, Ms. Allen, so I'm going to ask you to please give us a moment, okay? And you can wait right there.
Okay.
That's fine. Thank you. Give me just a moment, please. All right, would counsel please approach? I have found on the rules of evidence and other applicable rules of law is appropriate. The question is, did you see James with his dyed red hair? And if so, what was your impression of his changed look?
I did not see him with that until after the event. And I mean, it was surprising.
Okay. Is there a follow-up question from the people? From you, Ms. Brady?
Just to make sure you saw that either on TV or in the newspaper, the picture of James with the red hair.
Correct, in the probably both newspaper and TV.
And that's when you thought it was surprising?
Yes.
Not what he looked like when you knew him?
No, I'd never saw him with red hair before.
Thank you.
May Ms. Allen be released from her subpoena, Mr. Brockler?
Yes, sir.
Is there any objection? No, sir. All right, Ms. Allen, thank you. Please call your next witness.
David Bunch.
Come around this way, please. If I could have you raise your right hand for me so that I can administer an oath. Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Please be seated. Could you please tell us your full name for the record, and would you please spell your first, middle, and last names?
David Lance Bunch, DavidLancebunch.
Mr. Edson, you may proceed.
How are you employed?
I'm employed with 24 Hour Fitness.
What is your job title?
a senior regional loss prevention manager.
What is 24-hour fitness?
It's a fitness company.
Do you have stores here in the local metro area of Denver?
We do.
How long have you been employed by 24-hour fitness?
Approximately 17 months.
What are some of your job responsibilities?
My main focus is to protect the assets of the company.
Are you a records custodian for 24-hour fitness?
I am.
Are you familiar with new membership orientation agreements for 24-hour fitness and new members?
Yes.
Are you familiar with detail usage records for members of 24-hour fitness?
Yes.
Can new members sign up online?
Yes.
How does that work?
It's one of the two main ways that a member or a guest can sign up. They basically can go to the website, and it gives them that option of signing up online. It's very simple. It says web sign up.
If a new member signs up online for membership, are they required to provide information?
Yes, they are.
Are they required to provide an email address?
Yes.
Does 24-hour fitness routinely provide authentic copies of the membership agreements to its members?
Yes, they do, especially if it's web-based. Once that agreement is completed, that agreement is emailed to the email provided by that member.
Does 24-hour fitness also keep an official copy of that particular membership agreement?
Yes,
And do you have access to those types of membership agreements?
I do.
The membership agreements, also referred to as new membership orientation agreements, copies that are provided, are they fair and accurate copies?
They are.
Your Honor, may I approach the witness, please?
You may.
Sir, I've handed you two exhibits, 1094A and 1094B. Are you familiar with those documents?
Yes.
First, we'll start with 1094A. What in general is that document?
This is a standard membership agreement.
Is that a membership agreement that can be done online?
It is.
1094B, what does that refer to?
This is a membership usage gap.
I'm going to start and ask you some questions about 1094A, the new membership orientation agreement. Is there a particular customer membership number associated with 1094A?
There is.
What is that number?
It is a club membership agreement. It is located, I think, on the third page, although it says page 1 on the bottom. It is L as in Lima, D as in Delta, 73516.
Is there a particular member name associated with this document?
There is.
Who is that?
James Holmes.
Is People's Exhibit 1094A a fair and accurate and complete copy of the new membership orientation agreement for that account LD 73516?
Yes.
Have you had an opportunity to compare that particular exhibit against the records of 24-hour fitness for this particular new membership agreement related to LD 73516?
I have.
Explain what you observed.
It's the exact same agreement. The agreement that we have, we keep in our records is the same one that we're emailed, so that they're matching.
Is that an authentic copy?
It is.
Is there any changes or manipulations or anything related to that that you observed?
Not at all.
Some specific questions. People's Exhibit 1094A, is that a computer-generated business record that's created by 24 Hour Fitness?
It is.
And then copies are sent to the members, is that right?
Yes.
Are the computer entries made in the regular course of business?
Yes.
Were those participating in making the records acting in the routine course of business?
Yes.
The input procedures that are used to create People's Exhibit 1094A, are they accurate?
Yes.
Were the entries in People's Exhibit 1094A made within a reasonable time after the transaction involved?
Yes.
Is the information for 1094A transmitted by a reliable person, such as yourself, who has knowledge of that particular document and has access to the original documents at 24 Hour Fitness?
It is.
Does 24 Hour Fitness regularly receive, maintain, and rely upon the information transmitted in the creation of these records?
Absolutely.
The information, and I'll direct your attention, it's the third page, but the page that had the agreement number that you were referring to. It says page 1 at the bottom, but it's actually the third page of 1094A. Do you see where I'm referring to?
Yes.
That information, particularly at the top, who provides that information?
With the guest, the person signing up.
Okay, so that information, the information provided by the guest or the person or the member signing up, is that information used as part of a business relationship between that member and 24 Hour Fitness?
Yes.
Explain how that works, please.
It's the genesis of the business agreement, meaning that we need this information to be able to get paid. So therefore, we rely on the accuracy of this to be able to complete that business arrangement.
Does 24 Hour Fitness substantially rely upon that information contained in the records for a business purpose?
Yes.
Okay. Anything additional aside from being paid as far as the business purpose that you're relying upon that information?
Well, the other part of it is the most important part, of course, is that business relationship. But it's also tied into ensuring that the policies, regulations are also read and agreed to.
And is People's Exhibit 1094A in its totality a fair and accurate and complete new membership agreement for the account LD 73516?
Yes.
Have you turn to People's Exhibit 1094B, please? Do you recognize that exhibit?
Yes.
What is that exhibit?
It is a member usage outline.
What is the usage outline? What are you talking about?
We have a system in all of our clubs which requires a member to check in when they arrive at the club.
Does this document reflect times and dates of check-in?
Yes.
Is there a particular account number associated with People's Exhibit 1094B?
There is.
What is that account number?
It is L as in Lima, D as in Delta, 73516.
Is that the same account number that you read for People's Exhibit 1094A?
Yes.
Is there a particular member associated with People's Exhibit 1094B?
Yes. James Holmes.
Have you had an opportunity to view People's Exhibit 1094B and compare it to the internal records that 24 Hour Fitness has related to the usage document?
Yes.
And what did you find?
They matched.
Any changes or manipulations between the documents?
None.
Is People's Exhibit 1094B a fair, accurate, and complete copy of the detailed usage record for that particular account, LD 73516?
Yes.
Is People's Exhibit 1094B a computer-generated business record created by 24 Hour Fitness?
Yes.
Is that the usage detail, is that something that a customer would be provided a copy of at all?
No, not in normal everyday business. It's used for us to be able to track a member usage.
Okay, you keep that and maintain it within 24-hour fitness regular course of business?
Yes,
Are the computer entries for People's Exhibit 1094B made in the regular course of business?
yes,
Were those participating in making the records acting in the routine course of business?
yes,
Are the input procedures for People's Exhibit 1094B accurate?
yes,
Were the entries made within a reasonable time after the transactions involved?
yes, it's instantaneous.
What do you mean by instantaneous? Go ahead.
What did you say?
It's instantaneous.
Thank you.
Sorry. What do you mean by it's instantaneous?
According to this record, it does show that each visit was done via a bioscan, and a bioscan is instantly tagged to that member, which then tags the time immediately when it's met with that member.
Does it also record the date as well?
It does.
People's Exhibit 1094B is the information transmitted by a reliable person such as yourself that has knowledge of the events in the record reported.
Yes,
Does 24-hour fitness regularly receive, maintain, and rely upon this information that's contained within People's Exhibit 1094B for their record-keeping purposes?
yes,
Is the information provided by the member, as you described in the scan, is that used as part of a business relationship between 24-hour fitness and its members?
yes,
Does 24-hour fitness substantially rely upon the information contained in these records and the detailed usage, and I'm talking about 1094B, do they rely upon that for any business purpose?
yes,
In totality, is People's Exhibit 1094B a fair, accurate, and complete copy of the detailed usage for the particular account LD 73516?
yes,
Judge, pursuant to 401, 402, 901A, 901B, and 8036, we move for admission of 1094A and 1094B.
Is there any objection?
Just under 401 and 403.
Can I see those records, please? All right, would counsel please approach? Here you go, sir. All right, the rules 401 and 403 objection is overruled, and both exhibits are admitted and may be published. That's P-TR-1094A and P-TR-1094B.
If we could please have 1094A3. And just scroll to the top. Sir, do you see, we have on the screens 1094A. Can you see that on your computer screen in front of you?
Yes.
Okay. To the top right, I see a club membership agreement. Is that where you're reading the LD 73516 number?
Yes,
Is that the membership agreement?
it is.
Or otherwise an account number?
Yes.
I see a club of enrollment and some information below that. Describe for the jury, what are we looking at there?
Where it says membership, that's the type of membership that the person is agreeing to or selecting. And when they're selecting a single, that means they're selecting one club.
And was there a particular club selected?
And if you continue on across from the single to the right, it says 00572. That is the club number that was selected.
Are you familiar with that club?
I am.
Where is that located?
It's in the Denver Metro over in Lowry.
If we could scroll down just a little bit, please. Personal information, who does this account belong to?
This account, under personal information, belongs to last name of Holmes, first name of James.
Okay. Fair to say address and phone number is there as well?
Yes,
And then the email address is the dsherlockb@hotmail.com?
yes.
Okay. Let me take that down, thank you. Actually, I'm sorry, can we have 1094A3 up one more time? If we could scroll down just a bit more to beyond the liability section to the membership. So where it says monthly payment membership, does this describe what we're looking at here?
Right underneath there where it says begins on the left, that is the first day of enrollment. That is the first day that they're able to attend or go to that club to work out. The monthly dues, that is what is going to be charged on a monthly basis to be able to use that club, and that is $24.99.
So is it fair to say that this particular membership was created and active as of roughly November 8th, 2011?
Yes.
All right, thank you, we can take that down now. If we could look at 1094B1, please. What are we looking at here?
This is the, as it states on the very top, usage by customer number. And that customer number on the very first column is the LD 73516.
And all of those correspond with James Holmes, is that correct?
Yes,
That Club 572, is that the Lowry Club?
yes,
Fair to say that there's the date and the timestamp?
yes.
When I see that scan flag and it says B, what's that referring to?
Bioscan.
Is that what you were talking about earlier?
Yes, there's only two types of scan. It's either manual with an M or B, a bioscan.
What is the bioscan? What does that mean?
For customer convenience, what we've done is we have a bioscan in each of our clubs, which is tied to that membership. So when someone joins a club, they can then decide that they want to do a bioscan again to expedite the process when they arrive at the club. So they have to go through a quick process where they're at the beginning, when the first time they're at the club, and it'll scan their finger, and that finger is tied directly to the membership. So when they show up at the club, they'll go ahead and enter in a personal access code, but they also do it the very first when they first do the bioscan. Then they'll scan their finger on this bioscan. When they enter in their personal code, that pulls up their membership. Then when they scan their finger, it ties into that membership to speed it up.
Okay. The warning level G, what does that mean?
It means green. There's 3 warning levels. There's a green, yellow, and red. Green means everything's okay with the account.
Okay, if we could have the second page of 1094B, please. Fair to say this is a continuation of the detailed usage for this account?
Yes.
We have it on the screen here, but as of May 10th, 2012, were there additional entries into that Lowry campus 24-hour fitness by Mr. Holmes?
Speaking of the second page, yes, it goes through, the very last one was that July 6th, 2012.
Your Honor, can I have one moment, please?
Yes.
I have nothing further, thank you.
Cross-examination, Ms. Higgs?
Questions, Your Honor, thank you. Sir, I noticed that this customer usage record only goes back to January 10th of 2012. Were there no records from before then, or that's just as long as you keep them?
This is the record that is available with this membership.
Oh, okay,
So all records with this membership are detailed here.
okay. You indicated the last date that somebody went to the Lowry camp, and it would have been Mr. Holmes went to the Lowry gym was on July 6th, is that right?
From this exhibit, it looks like, yeah, the last time it was bioscan was on July 6th, yes.
And a bioscan is you stick your finger in a little device and it reads it, right?
Again, it's tied into that PIN number, which links to membership, then links to the fingerprint, yes.
Right, but when someone goes to the gym, they just kind of stick their finger in a thing and it does a bioscan of your finger or something?
Yes, I think it does 8 points of a fingerprint.
Okay.
And many times, even if it's a little smudgy, it won't even take it. You have to clean it and do it again. It's very accurate. But again, it's very important that they do that their own PIN code first before doing the fingerprint.
Right, like back in November, December, or January when they first opened the account, they would set that up, and then every time you go to the gym to gain entry, you just stick your finger in a little device.
After putting in your entry code, yes.
Yes. Now, just also quickly, the last 5 times that Mr. Holmes went to the gym, the times are what, 11:09 p.m., 10:18 p.m., 11:47 p.m., 10:41 p.m., and 12:44 a.m., being 12:44 in the morning after midnight. Is that right?
Yes.
Okay, thank you. I don't have anything else. Thank you, Your Honor.
Right, is there any redirect?
No, thank you.
And the jury does not appear to have any questions for this witness. May this witness be released from his subpoena?
Yes, Your Honor.
With any objection? Ms. Higgs? No? Okay. Sir, thank you. You can give those back to Mr. Edson. Do you want to call your next witness, or do you want to take a lunch break?
We can call the next witness.
All right?
Louis Perea, Your Honor.
Okay. Good morning, sir. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please be seated. Could you please tell us your full name for the record?
Sure, Louis Perea.
And can you spell your first and last names?
Sure, first name Louie, last spelling Perea.
Mr. Orman, you may proceed.
How are you employed?
I'm employed as the Arapahoe County Undersheriff.
What is the undersheriff?
The Undersheriff has overall responsibility for all activities of the Sheriff's Office.
You like the second in command, the executive officer of the sheriff's office?
Yes, sir.
What was your job back in 2012?
I was a bureau chief for the Detention Administrative Services Bureau.
Would that include the jail, the courthouse, the kind of deputies we see in here?
Yes, sir.
And as the undersheriff and the person in charge of the jail, were you familiar with, and are you familiar with the way that the jail conducts business and does things?
Yes, I am.
And are you also familiar with the way that the jail has overseen the defendant while in custody?
Yes, sir.
I'd like to talk to you a little bit about something called kites. Are you familiar with what a kite is?
Yes, I am.
And I'm not talking about the things that your kids might play with in the park, but in the jail, what is a kite?
A kite is a means for a person incarcerated to communicate with our jail staff.
And what is the way that that happens at the Arapahoe County Jail? And let's actually talk about from, let's say, July of 2012, and if it's changed to the present, how has it changed? How does that work?
We have a system, it's called the ASK system, ASK, stands for Administrative Services Kiosk System.
And how does a person in the jail go about then sending a kite using that ask system?
Sure, when they're enrolled into the ASK system, they then have the opportunity to send kites, electronic document to our jail staff.
Is it like sort of like an email to jail staff?
Yes, that's an easy way to say it is.
And is there a way that the jail has to make sure that it's the particular person in the jail, the particular inmate, and I'm not sure the correct word even for that, but I'll just say person in your custody, to make sure that it's them sending the kite as opposed to just anybody pretending to be them?
Yes, sir. When we first implemented the new system back in April of 2012, from that time to about the first, January of 2013, any person brought into our facility was enrolled and they had to use their fingerprint. We used biometric fingerprinting.
And it's somehow, so from, let's say, July 20th through the end of July of 2012, that would have been the system. You have to use your fingerprint to send a kite?
To access the kiosk system, yes.
And in order to send a kite, you need to access the kiosk system?
Yes, sir.
And then in 2013, did that change?
Yes, it did.
How did that change?
Rather than using biometric fingerprinting, we changed to a unique number, which is a jacket number, plus a password that the inmate would use as well.
Would that be unique to each person in the jail, each inmate in the jail?
The jacket number is yes.
And how about the passcode?
The inmate would create that themselves, yes.
And can you just sort of explain what these kiosks look like and describe what someone would go through to use the kiosk to send a kite?
Sure. A kiosk is located in, at least one kiosk is located in each of our housing units. When a incarcerated person wants to send a kite, they sign on. Once they sign on, they have several options. Kiosk system is used to send a request, send a grievance for an inmate to access their inmate account, inmate handbook.
When a kite is sent, is there a computer record sent of it?
Yes, there's electronic record.
And I'm going to approach you with what's been marked for identification as People's Exhibit 1088.
Thank you.
And please take a look at that and tell me if you're familiar with it.
Yes, I am.
Now, have you looked at your system to see if the defendant in this case sent any kites?
Yes, sir.
And would it be fair to say you're in overall charge of that system as the undersheriff?
Yes, I am.
And in all the administrative work at the jail?
Yes, I am.
And take a look at 1088, and is that a record associated with any particular inmate?
Yes, it is.
Who is that?
That's James Holmes.
And is that the defendant in this case?
Yes, sir.
Is the sheriff's office a government agency?
Yes, it is.
And let's say the information on the top of each page, does that demonstrate the activities of the government agency?
Yes, it does.
And are those computer generated?
They are.
Are they made in the regular course of business?
Yes, sir.
And the people participating in the creation of these, are they acting in the routine course of business?
Yes, sir.
Are the input procedures to create these documents accurate?
Yes, sir.
And are these entries made within a reasonable time after the transaction involved? In other words, after the input is done?
Yes, sir.
Is the information transmitted by reliable people with knowledge of the events contained therein?
Yes, sir.
And does your office regularly receive and maintain and rely upon the information transmitted in these types of kites and reports to do your business as the jail?
We do.
Move to admit 1088, Your Honor.
Is there any objection?
Your Honor, we have no additional objections.
Would counsel approach, please? All right, the objection is overruled, and the exhibit is admitted. That's P-TR-1088.
Your Honor, with the court's permission, what I'd like to do is I have copies for the jury, and I'd like to have them distributed, and then while they have them, I want to put something up on the Elmo, and just so, to put some of these things in context so the jury can understand what the records mean.
All right, that's fine. If you would tender those to Ms. Gerlings, please, so that she can distribute them. Members of the jury will give you a copy of this exhibit, and that'll be a copy for each of you.
If it's okay with the court, I'm going to ask questions from over there while I have this on the machine.
That's fine.
Oh, I'm sorry, actually, we have it in our system. I didn't realize that, Your Honor.
All right.
We can put up the first page, please. And if we could just take a look at this, at the top of it, we have the case number and then an ID number. Is that the ID number for the defendant in the jail?
Yes, it is.
And then over on the right, it says library request. Is there a library at the jail?
There is.
And how many volumes, do you know?
We have approximately 9,000 books.
Can inmates check out and read books?
They can.
How many can they get at a time? How often can they do that?
Generally, we want to limit it to 3 books at any given time.
And can they request specific books?
Yes, they can.
Now, do they get to go to like a big room and browse stacks of books, or how does that work?
Generally, we have what's called a book cart, and it's brought to specific housing units, and inmates have an opportunity to look at what books. If there's a book on the book cart that they want that's not there, they can then request a book through the kiosk system.
And then underneath here, it says status closed, unfounded. What would that mean? I mean, an unfounded request for books. How does that work?
Sure. Status, we have 3: open, pending, and closed, and founded or unfounded. In essence, this kite or this request was answered, and unfounded is generally just used for grievances. Founded, unfounded is there's some merit to their grievance.
So, but this wouldn't be a grievance?
That is correct. It would
So
not.
it's sort of an automatic thing that goes on there?
It is.
If we could go to the next page, please. And go just to the actual message. When it says here to system administrator, obviously it's, we don't need to do that. Where it says system administrator, what does that mean? Is that sort of a general message to the whole jail?
Yes, what it is that particular kite or request is basically put in the kiosk repository.
Your Honor, I don't have any further questions with the document. I don't have any further questions for the witness, and the jury has the exhibit.
Okay. Members of the jury, I'll give you a few moments to review the exhibit, okay? Neither is ours. Neither's, no, not mine's not either. Okay, the record should reflect that the jury just finished reviewing P-TR-1088. Cross-examination, Ms. Higgs?
Yes, and this won't be very long. We'll get out for lunch soon. With regard to the library request process, it says on the first page of this, at the first request, is there like a library book search function available? Do you know if there's some sort of computerized book search function?
There is not, ma'am.
Okay, so the only option an inmate really has is to put a request in through that kiosk system if they want, say, a particular book?
They have a few options. They can put in a request, or they can request for that book to be ordered, and it can be sent to them as well if we don't have it in stock.
Okay, and there's also a request to have some books sent if they're, and they have to be approved books, is that correct?
Yes, ma'am.
You can't just order any book that you want under the sun.
No, it needs to be approved.
Okay. Now, if somebody requests a particular book, it may not actually be in your 9,000 volume library. Is that fair?
That is correct.
And then, is it correct that what the librarian's the person that will physically bring the book cart to the different housing units so that people in your custody can take a book and check it out from that librarian, right?
Yes, ma'am.
Okay. If the particular book is not available, the librarian then may select something else in that same genre or something else she thinks is close to it to offer to the person requesting a book. Is that fair?
They may offer, yes.
Okay. And if they're requesting a general category of books, it's also kind of up to the librarian to, maybe pull a few options and see if one of those will work for the person in your custody.
That's possible.
Okay. And nothing on here actually indicates what book was checked out. Nothing in these records, correct?
Nothing in this record.
Okay, so these are just requests. It doesn't even indicate whether if certain specific books were requested, like Don Quixote, whether that is something that was even in the library. It doesn't tell us that on here, does it?
Not from this record.
Okay. I've given you another set of sort of library requests, and that is marked as, well, is there a number on that sticker? I didn't write it down.
There is. It's D-TR-66.
Thank you. Your Honor, we're going to move for admission of D-TR-66. I don't believe there's objection from the people.
I'll stipulate.
All right, it's admitted by stipulation.
Thank you. Now, to save time, I've already handed that to you, so you could review it while the jury was looking at the People's Exhibit. And is that additional library request made by Mr. Holmes through your kite system?
Yeah, majority of them are. There are several pages that are missing the header from the copies that I have.
Oh, where it sort of prints off, but okay. That's strange. I think that was a photocopy problem that I did not know in your copy. With regard to these requests, I note that in Mr. Holmes' library requests that the people submitted to you, there were a couple requests for sci-fi books, is that right?
Yes, ma'am.
Okay. And the records that I've handed you start in February of 2013 and go through March of 2014?
The first page starts January of 2013.
Okay. And goes through March of
The first page goes from January 3rd, 2013 to May 9th of 2013.
Your Honor, I'm going to ask to recess for lunch. There seems to be a photocopy issue with this particular exhibit that I didn't notice until now. So I'm going to have to reprint that.
All right. Under Sheriff, are you available after lunch?
Yes, I am, Jan.
All right, thank you. All right, members of the jury, let's go ahead and take our lunch break. Before you leave, let me have counsel at the bench, please, so that I can talk about scheduling. All right, members of the jury, I think Ms. Higgs is going to attempt to finish her questioning of the Under Sheriff Perea, and then we'll go to lunch after that, okay? Is everyone okay, by the way, taking a short lunch today, 1 hour? Anybody not okay with 1 hour for lunch? Okay, nobody's raising their hand. Thank you. All right. Ms. Higgs, you may proceed with your cross-examination of Under Sheriff Perea.
Thank you. Under Sheriff Perea, even with regard to the pages here that where the header is missing, the Arapahoe County print message report header is missing, it still has James Holmes listed as the inmate, correct?
Yes, ma'am,
Okay. And it still has the same ID number, correct?
it does.
All right. So you said these start in February of 2013, and what did you say the last date was on the last page?
The first page is from January 3rd, 2013 to May 9th, 2013. The last page, the header is missing.
Right, but the date entered.
The date entered is March 27th, 2014.
Okay. And the date entered on the first page as far as the first request made on that page is February 14th of 2013.
Yes, ma'am.
Okay. That's where I was getting confused in our discussion. Thank you.
Okay.
You have been able to look through these records briefly there at the bench, is that correct? Or in your seat, is that correct?
Briefly, yes.
And it indicates on the first page that even in February of 2013, there was an additional request for sci-fi books, is that right?
Could you ask me that again, ma'am?
That first request there on February 14th of 2013 from Mr. Holmes is also for sci-fi books?
It is.
There's also an additional request for sci-fi books on page 10, which would be September 21st of 2013.
Yes, ma'am.
In the People's Exhibit, it indicates on the second page that there were requests for, I think, philosophical works, works by Klaus, who was a military war theologian, other war stratagem books, things like Plato's Republic, Don Quixote. Do you recall that request from the People's Exhibit?
Yes, ma'am.
Okay. With regard to the library request from, that I have handed you from February 14th of 2013 until March 27th of 2014, there were no similar requests like that for books on philosophy, is that correct?
I don't know specifically. I'd have to go through each one of these.
Yeah, if you could just flip through it pretty quickly, and my next question is, there's also no similar request for books on war stratagem.
Not that I noticed, ma'am.
Okay, thank you. I don't have any other questions.
Is there any redirect?
Thank you. If you could take a look at the one I had handed you earlier, the People's Exhibit 1088. And what was the date of the request for Klaus, and I think he means Clausewitz, Plato's.
I would move to strike prosecution statement. He doesn't know what was meant by this request.
Well, he is a military war theologian, Your Honor. I think actually the court can take judicial notice of who Klaus Clausewitz was.
I'll sustain the objection.
All right, Klaus, philosophical works, Plato's Republic, Machiavelli, Don Quixote, etc. What was the date of that request?
That was entered July 25th of 2012.
Now, we have a reference to Plato, and counsel had asked you if there were any similar requests. Could you go take a look at the request from October 5th, 2012?
In which of their...
In the People's Exhibit.
Okay. Do you know what page that is, sir?
Let me show you my copy. It's actually you know what? It's the
If you would
fourth
be-
from last.
Okay.
Fourth from last, which I think would be the quadrultimate.
Okay, the fourth from last that I have is October 5th.
Yes, and what does that say?
Standing order, books on philosophy.
And what does standing order mean? Do you know?
I do not.
Okay. I have no further questions. Thank you, Your Honor.
All right, is there any recross?
Just to clarify, that was October 5th of 2012, correct?
That is correct.
Nothing further, Your Honor.
All right, there do not appear to be any questions from the jury. May Under Sheriff Perea be released from his subpoena? Mr. Orman,
Yes, Your Honor.
any objection?
Your Honor, we're asking him to keep him under subpoena.
All right, so Under Sheriff, you're free to go for now, but you may be called again as a witness, okay?
Okay, thank you very much, sir.
Thank you. All right, members of the jury, it's 20 after 12. Let's go ahead and take our lunch break at this time. It's actually about 12:21 or so. So let's take an hour, if it's okay with everyone, and let's have you back here in 1 hour. Keep all my advisements in mind during the break, and I'll see you back here after lunch. Thank you. Remember, folks, today is a day when we have to finish early. We're finishing at 3:30 today. The record should reflect that the jury has exited the courtroom. Everyone may be seated. Is there anything we need to take up at this time on behalf of the people?
Your Honor, I've marked for the record what was People's Exhibit 2035 as C-TR-72.
Okay. Anything on behalf of the defense?
No, Your
Okay, enjoy your lunch. I'll see you back here at 1:23.
Please rise.
So good afternoon. I am Phil Tenser here in the 7 News newsroom. We're going to be returning to court, as you heard the judge just say, at 1:23, a shortened lunch to accommodate the fact that we're ending today at 3:30, and that Judge Samore does expect, the prosecution does expect, to rest their case today, which would give us a 5-day weekend and then lead us on to starting the defense case on Thursday, the 25th of next week, and that should last for about 2 weeks. Bear with me for 1 second, folks. Anika, that one. There we go. That one. Sorry about that, folks. We've had some technical issues on our end today, so I know we've been neglecting the chats a little bit. We had a hard drive fail on us earlier, and we were having issues with our lunch plan, but I think that last button push should put us back on track to talk first with Rick Kornfeld and then play some sound for you again. Rick, this is Phil here, and if you can hear me, let's talk about what we're going to expect, knowing that we're going into a 5-day weekend, knowing that there's still work to be done behind the scenes, even though the jury won't be in the courtroom. What kind of things have to happen to transition from the prosecution to the defense case?
Well, both sides are going to be, preparing their witness directs and cross-examinations. But on the defense side, there is a bit of a mental change because, you've been, to the extent you've been cross-examining, you now have to not be asking leading questions. You got to get in the direct questioning mindset, which is the non-leading questions. On the prosecution side, they're used to kind of controlling the pace, making the tactical decisions, and that's a bit of a going from the proactive to a bit of the reactive mindset is a big mindset shift, especially as a prosecutor where you're used to going first and you're used to kind of controlling the order and the pace. So there's a lot of work to be done. The defense, I think, is going to really be spending time and rethinking and reconfirming its strategies in terms of witness order, in terms of some of the questioning, and really tailoring its presentation to what has occurred in the courtroom. What normally happens is in advance of a trial, you put together your outlines for directs and cross-examinations, and you've got witness folders, and you've got an idea of what you're going to do, and then you have to adjust that based on what's actually happened during the trial. So I think that it's going to be a long weekend, a much-needed break for all these lawyers, but they are not going to be working. Hopefully they'll get a little bit of rest, they'll get to decompress a bit, but they're going to have a lot of work to do. And on the prosecution side, they've got to have an idea of what they're going to be doing on their cross-examination, some of which are going to be very, very significant. So that's going to be where their focus lies.
Rick, we know of 2 things that the prosecution still has to do before they rest their case. That is some email records that we've heard debated, and then Ashley Moser's testimony that we've been hearing about for the past 48 hours or so. When the defense starts their case, one of the reasons they wanted to start on the 25th and not earlier was that they're flying in experts. We don't know if that expert's going to be the very first person or somewhere during their 2 weeks or so of presentation. But if you were on the defense on this case, knowing what their goals are, what their presentations are, what would be your checklist of things that the defense has to cover before they're done?
Well, the biggest thing, and in a lot of ways really the only thing I care about on the defense side is evidence with respect to Mr. Holmes's mental state. So I've got to be thinking within that general topic, because that's where the battle lines in this case are drawn. I've got to be thinking about 2 things. Number one, getting my experts up and doing that effectively and getting my evidence on through those experts. That's number one. And number 2, I've got to be thinking about how do I counter some of the punches that I've taken or some of the arguments that I can anticipate from the prosecution that Mr. Holmes was in fact sane on the night of the shootings, and what witnesses do I need to counter those points. So that's really all I'm focused on. You're going to see a much more streamlined presentation from the defense for two reasons. Number one, they don't have the burden of proof. And number two, they're going to be laser focused on this issue. You're not going to spend days and days and days and days on some of these other things. Where they're going to be spending their days is on their experts and on basically attacking the prosecution's expert opinion that Mr. Holmes was not insane on the day of the murder. So that's everything. That's the whole ball game for the defense.
And it is the whole ball game, but it's not the end of the trial. There's still, after the defense finishes, still, I believe, the opportunity for rebuttals and then closings. Is that right?
Yeah, that's exactly right. So to torture the sports metaphors, we talked about the ball game. Well, what this really is in a way is a hockey game. A hockey game, there's 3 periods. We're at the end of the first period. The first period is the government putting on what is called its case in chief, its proof. The second period is the defense putting on its case. Obviously, the defense has no obligation to put a case on because the defense does not have a burden of proof, but the defense is going to put a case on, and that comes as no surprise to anyone. So what we're about to do, again, to torture the hockey metaphor, we're going into the second period. But there is a third period, and it's an important period, and it is the government's rebuttal case. So the scope of the rebuttal case is limited, but it is the government having the opportunity to have the last word and to rebut the defense's case, and the reason they get that opportunity is because they have the burden of proof. So if the defense didn't put on a rebuttal, or excuse me, if the defense didn't put on a case, there would be no rebuttal case, but you can expect to see witnesses, some of whom may be new witnesses, some of them may be recalling the mental health experts to rebut the evidence that the defense is going to put on. You're not going to see, I don't think, victims again. You're not going to see gun clerks and store clerks and bank record custodians and Hotmail and those people, but you are going to see, again, the issues in the case are going to start to get narrowed right down to the battling over the mental state. So we're only a third done. We're not half done. We may be half done in terms of time, but in terms of the trial practice, we've only finished the first period.
Thank you for that. That does help us to put it all into context. Rick, we'll talk to you again next chance we get. In the meantime, during the rest of this shortened lunch hour, which should last until I think 1:20, 1:23 was what the judge said, we're going to play, and fingers crossed that our hard drive stays online this time, we're going to play for you a montage of segments from previous survivors who's testified to remind you all of everything that's occurred, everything that we've heard throughout the course of this case as we await the prosecution wrapping up their case this afternoon.
Martin, if you could please show the jury where you were seated and point out your seat and then the seats of your friends.
Okay, so I was seated somewhere around here. Petra was sitting in between us because Ethan was sitting right there.
Right, please tell the jury about what you witnessed in the theater that night.
Well, we got there probably around 11:30, like in the theater itself. So we sat there and talked. It was a pretty normal night at the movies. And then the previews came on, and I remember, during the previews, I remember distinctly seeing, people who were very excited to see these movies. And I remember seeing a very large gentleman sitting maybe 3 seats in front of us during the Superman preview in particular. This stands out in my mind, and him getting up and just being so excited to be there. But then the movie started, and about 20 minutes into the movie itself, I would say, I remember seeing an object basically pass through my line of sight when I was looking at the screen, and it made this like hissing noise, and I had no idea what it was, but it landed somewhere around here, and as soon as it landed, I remember seeing up here by the emergency exit this flashing light and this very loud noise, like a booming noise, and it sounded to me like fireworks. And so I'm seeing this light. I think it's a prank. I don't really know what's going on. I was very disoriented. But shortly after that, maybe 2 seconds afterwards, I noticed that people were screaming, were getting out of their seats. The room was starting to fill with smoke. And about that same time, I just instinctively held my hands in front of my face. And in that same moment, I felt this immense pressure on my chest and basically my whole upper body. And I fell forward in front of my seat.
Could you describe for the jury how your body was positioned when you fell forward in your seats?
So I just, fell into the, I guess you'd call it a row in front of the seats. And I think I fell on my knees, but I think I then sat backwards, so I was just sitting in front of my seat.
Right? What do you recall happening after that?
Well, the first thing I remember is that I couldn't feel my left arm at all. It was suddenly completely numb, and I actually thought that it had been blown off or something, and I actually had to look at it to confirm that it was still attached to my body. And the other thing I remember more than anything was that my neck was just swelling with blood, and it was bleeding very profusely. And I knew that I had been shot, but I really didn't know the extent of my injuries. I just knew that there was something in my neck. And I was scared to death because I thought, what if my artery has been hit, or, my neck was severely injured. So I just remember sitting there and thinking, this could be it. This might be the end.
What's the next thing you remember happening in the theater?
So while I was sitting there and I guess taking stock of my own injuries, I remember next to me Petra screaming at the top of her lungs, and I remember on her right side Ethan calling 911. He was on the phone. He had the presence of mind to do that right away. And all along there was just that booming noise. It kept going, and to me it was almost like one every second. It sounded methodical to me. And so that was continuing. I was sitting in my own blood, and Petra was screaming. Ethan was screaming as well. And
what do you recall after Petra screaming and hearing all those gunshots?
so at some point the gunshots stopped, and I don't know why they stopped. I didn't know. And in that same moment, I saw light coming from this area of the theater. And I looked to my left, and I didn't realize beforehand that there was an emergency exit there, and people were rushing out of it. And I didn't really think about it. I just got up and went out the exit.
All right, I don't have any further questions for you up at this model. If you could retake your seat on the witness stand. Thank you very much, Mr. Barton. Please tell a jury about what you recall happening after you went through that exit door.
So after I went out that exit, there's a stairway that leads into the lobby. And I remember going down that stairway with a lot of other people, many of whom were covered with blood. And in the lobby, I remember hearing a couple more gunshots and wondering if there was another shooter. But I was just, moving with this whole group of people out into the parking lot.
You didn't see another shooter in the lobby?
No.
What happened after that?
Well, once I got out into the parking lot, there were, maybe 100 people out in the parking lot, sort of confused, milling
Objection,
about.
403, cumulative.
Sustained.
Were you transported for medical treatment?
I was. I was transported first to a triage area in the parking lot, and then to the medical center of Aurora.
How were you transported to the medical center of Aurora?
In the back of a police car.
Was there anyone else in the police car with you?
There was.
Relevance, 403.
Overruled.
You may answer the question, Mr. Barton.
Yes, there was someone else in the police car with me. He had a...
All right, hold on. Next question.
Did you observe any injuries on the person in the police car?
Objection, relevance, 403.
Sustained.
What injuries did you sustain as a result of the shooting?
And just for the record, sustained under Rule 403, cumulative.
Thank you, Your Honor.
I received multiple shotgun wounds. So, do you want me to describe that in further detail?
Please do.
So I had 4 pellets in my face, at least 3 in my neck, 3 in my chest, 3 in my right shoulder, 3 in my forearm, 1 in my right hand, and 1 in my left hand.
Your Honor, if I may approach Mr. Barton with what's been marked as People's Exhibits 4874, 2022, 2023, 4875.
You may.
Thank you, Your Honor.
I have no objection to these exhibits.
All right. Are you moving their admission, Ms. Teach McGuire?
Please, Your Honor.
All right. Without objection, they're all admitted and they may be published.
If I could please have 2021.
Did you say 2021? I think you indicated that you were approaching with 2022 and 2023, but not 2021.
I apologize, Your Honor. If I could have 2022. Great, Mr. Barton, please describe for the jury what we see in this photograph.
So this is my right shoulder, and you can see pieces of gauze that are covering the entry wounds for the shotgun pellets.
If I could have 2023. Please describe for the jury what we see in this photograph.
So you can see my right eye. That's where one of the shotgun pellets entered my head. There's also a spot by my mouth, which is where another shotgun pellet entered and actually fractured my molar and embedded in my right cheek.
Right, if I could please have 4874. Describe for the jury what we're seeing in this photograph.
So the big wound you see is where a shotgun pellet entered my cheek and exited. You can see also the exit wound.
Right, and what is underneath the gauze that we see in that photograph?
So that is from the emergency surgery I had that night at the Medical Center of Aurora to remove some pellets.
Where did they remove those pellets from?
From my neck. So they made 2 large incisions.
If I could please have 4875. And then what else can we see in this photograph?
Once again, there's gauze covering, the small pieces of gauze that are covering the entry wounds. There's also an uncovered one on my left chest, and also the gauze from my neck surgery. And you can also see my chin where another shotgun pellet entered.
Where were they able to remove pellets from your body, Mr. Barton?
Well, that night, just from my neck.
All right, did you subsequently have other pellets removed from your body?
I did.
Please
Yes.
tell the jury about where those were removed.
Those were removed from my left hand, the palm of my hand, my right forearm, and my face. And there was also, I forgot, the one on my shoulder that was removed.
How many pellets still remain in your body, Mr. Barton?
8.
Where do those remain?
There are 3 in my chest, 2 in the muscle, and 1 basically in my sternum. And there are 2 in my neck still.
Did you also have to have oral surgery for the molar that was fractured?
Yes, I did. It was replaced with an implant.
Do you have any lasting injuries as a result of the shooting?
I do. If you remember, I said my left arm went numb that night. That was because of nerve injury to the left side of my torso. And so that is still very weak, and it causes me discomfort pretty much when I'm doing anything, at least some discomfort. And my neck is still very sore and becomes very sore at the end of the day.
I have no further questions for this witness. Thank you, Your Honor.
All right.
All right, could you please tell the jury where you were seated and where Miss Davies was seated?
Sorry. Okay. I was sitting right here in the aisle seat, and she was to my right.
All right, please tell the jury about what you recall happening in the theater that night.
About 15 or 20 minutes into the movie, I heard a loud noise that sounded like either someone like kicking in a door or just like a louder like metal bang. And I looked to my far right corner because there's an exit down there, and I saw the door open and someone walk in that kind of looks like he came from Call of Duty.
What is Call of Duty?
It's a video
I'm going to
game.
object to the characterization.
Hold on, and there's an objection.
403.
Sustained.
Right, could you please just describe what that figure looked like for the jury?
Just all black with a mask and maybe some like body armor.
Anything else that you could see about that figure at that time?
Just, it was really dark in that corner, so it just looked like a big black metalled blob.
What do you recall happening after you saw the figure come into the theater?
Just kind of stood there for a little bit, so I wasn't really sure if it was someone like leaving or coming in. And then I saw a canister kind of fly behind me a couple rows, so I ducked a little bit because I heard like a weird hissing noise coming out of it.
What do you remember happening after the canister?
I remember hearing some people not really screaming, but just kind of like shuffling or like talking just in my back where it landed. So I turned up and looked over my left shoulder to see like what it was or what people were doing behind me. And then I just heard a really loud noise and I blacked out.
What's the next thing you remember after you blacked out?
I woke up and there were people running on top of me. And my friend, because I had fallen into the aisle seat, and I tried to push myself back to like the seat area.
I'm going to interrupt you for a second. I apologize. Could you show the jury on here where you had landed?
Yeah, I just fell like right into this aisle seat, like next to my seat. And then I tried to crawl to like where underneath the seats, like where your feet would be. And my friend was able to help me get underneath there.
What happened after you were able to get back into the aisle and avoid being trampled?
She tried to get me to stand up, and I realized that I couldn't. My entire like right side of my body just wasn't responding. And then I realized that I couldn't breathe. So I just kind of laid there and tried to find a position that I could breathe.
Why were you not able to breathe at the time?
I had been shot in my neck and also in my lung, so I was pretty like choking and drowning on my own blood.
What do you recall while you were down on the ground?
I just remember Stephanie calling 911 when she realized that I couldn't stand up. And then when she saw, I just, like I said, tried to find a position that I could breathe. And then when she turned her attention to me and saw what had happened, she came over and put her hand on my neck because she saw I was bleeding so much.
What do you remember after that?
We just laid there for a couple minutes. I just remember telling myself that I had to keep trying to breathe. Stephanie's hand was just on my neck and she was just staying with me. And then after a while, the lights came on and she just told me that I had to stay there and be quiet.
Could you hear anything in the theater while you were down on the ground?
I kept hearing a lot of noises, but it was really hard because the movie was playing, so it sounded like distant gunfire, but then also the occasional like really close loud gunfire, but it was a little bit hard to distinguish between the two.
What were you thinking while you were down on the ground?
Objection to relevance.
I was just thinking that I had to breathe because it was just such a struggle.
How are you able to get out of the theater?
After a couple of minutes of just lying on the ground, and after the lights came on, a couple of police officers came through the exit right next to us, and they were just telling everyone that we had to get out. So I still couldn't stand, so I kind of had to crawl over to the aisle to this railing to help lift myself up, and then kind of hobble out of the theater through this exit.
What happened when you left through this exit?
We got out to like the lobby area in the theater, and there were just more cops telling us, like ushering us to get out of the theater. So I just kind of had to lean on Stephanie and hobble out to the exit.
All right, at this time I'm going to ask you to retake your seat at the witness stand. Thank you.
Approximately 20 or so minutes into it, there was a scene that included some gunfire and some shooting, and we heard some extra noise, so some louder noises in the theater, which we recognized were not part of the movie. At first we thought they were firecrackers or fireworks, and at that point we realized something was not right in the movie theater.
What do you remember happening after that?
Shortly after we heard the fireworks, or what we later learned were gunshots,
I felt my face get hit on the right side, and immediately my hands cupped under my face like this, and one of my bottom teeth was in my hands, as well as a great amount of blood.
What do you recall happening after that?
I informed Lori and Lisa that were sitting next to me that I had been injured some way, and we needed to get help or get my face cleaned up and try to figure out what happened. And we started to walk down the stairs of our movie theater, and as we approached the 2 double doors to Theater 8, a young man said, "Stay inside the theater because we do not know where the shooter is." And so at that point we did not exit the double doors, and so we tried to exit out the back emergency exit.
What happened when you went out the back emergency exit?
I'm going to object at this point to relevance in 403.
Why don't you ask a more specific question?
Sure, what did you observe when you exited out the back emergency exit of Theater 8?
Same objection.
Sustained.
All right, what did you do in order to try to exit the theater?
We walked to the back exit in order to get somewhere safe, because the movie theater we were in obviously was not. So we walked out of that emergency exit door of Theater 8, and as we walked out of the theater complex, I saw...
I'm going to interject an objection at this point.
Sustained.
Did you, based on what you saw outside, did you stay outside?
No, we did not, because we saw many victims who were bloody.
Sustained.
So what did you do in response to what you saw outside of Theater 8?
We realized it was not a safe environment outside because there were people running.
Your Honor.
And if you could just say what you did and not what you saw outside.
Okay.
So what'd you do in response?
So the objection is sustained. Go ahead.
We tried to enter Theater 8 again through that emergency exit door, but there's no handle on the back. And so we began knocking on the door to get let back in, and someone opened that for us, and we waited in the front of Theater 8 to get hold of someone for help.
What happened when you got back inside Theater 8?
I remember my friend Lori pulling the fire alarm. A young man handed me his jacket in order to wipe up some of the blood on my hands and face, and we were trying to get a hold of 911 operators and trying to figure out the best way to leave the building.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1134.
Yes.
Ms. Six, does this diagram of Theater 8 fairly and accurately represent where you were seated in Theater 8 on July 20th of 2012?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibit 1134.
Is there any objection?
No.
Without objection, it is admitted.
If I could please publish, Your Honor?
Yes, you may.
1134. All right, and Ms. Hicks, there's a little mouse there. It's difficult to use, but if you could point out to the jury where you believe you were seated on July 20th of 2012.
I was sitting in the second seat to the aisle, and there's 2 rows circled because I do not recall which row exactly, but I know I was on the left side of Theater 8, very close to the top of the theater.
Now, if you could move the arrow over towards the right side, do you know that that is the wall between Theater 8 and Theater 9 on the right?
Yes, I do.
So you're actually seated all the way on the other side of Theater 8 when you were shot?
Objection asked.
Yes.
Overruled.
And sorry, you could say that answer again.
Yes, I was.
All right. And did you notice anything in the theater at all when you were in Theater 8 that you observed? Did you notice any smoke? Did you notice any gunshots?
Yes, before I had been injured, before I felt my face get hit, we did see smoke in the bottom right corner of our movie theater.
And could you use that arrow to show the jury where it was that you saw the smoke?
About that area.
Did you observe anything else at all?
No. Since we saw the smoke, that helped us, I guess, understand that it could be fireworks because it was smoking. And so that was our reason for thinking that this was fireworks rather than gunshots.
Your Honor, if I could now have what's been previously admitted as People's Exhibit 4744.
Okay?
May I publish? All right, Ms. Hicks, this is also a diagram of Theater 8. If you can see, there's a red line that goes across the theater. And now if you could take your mouse and show the jury, follow that long red line that goes across the theater. Was that in fact the side of the theater that you were seated in when you were shot?
Yes.
All right, thank you. How are you transported?
I was put into the back of a police car by Officer Hawkins, as well as with one other victim in the front seat of that car.
Do you know who that victim was?
Yes, his name is Michael White.
Sustained?
To strike.
Please tell the jury.
Hold on, the objection is sustained, so the jury knows that when I sustain an objection, you're to disregard any partial answer or any full answer that may have been given in response to the question that I have sustained. All right.
Please tell the jury about the injuries you sustained.
As a result of my injury, I received stitches that night at the hospital to sew up the gums that were opened severely. And they told me that the bullet fragment that was lodged.
Without telling us what you heard, just answer the question in terms of what injuries you sustained.
Okay.
Tell the jury where your bullet was lodged.
Okay. I received, the bullet was lodged in the left side of my face, and later it was removed with one of the bottom teeth that had been damaged. And after that, I had a bone graft put in to replace some of the missing bone. After that healed for about 3 months, I had braces on my bottom teeth to straighten out the teeth in order to later receive implants. After the braces were taken off.
Going to object.
The objection is overruled. It goes to the extent and the nature and extent of the injury, so overruled. Go ahead.
After the braces were taken off, I received another bone graft as well as a gum graft to replace missing gum on my bottom teeth. And I also received a dental implant and later received 2 crowns put on that dental implant to replace my missing teeth.
Ms. Hicks, how old were you on July 20th of 2012?
I was 17 years old.
Your Honor, may I could you please show the jury where you and Mr. Rotman were seated?
So we entered right here, walked up, and honestly I don't know the exact row. It was one of these 3 rows here. Carrie was on the aisle seat, and then I was in the second seat over.
Do you know who was seated on the other side of you?
I do. A girl by the name of Jansen Young, and then next to her was a young man by the name of...
Calls for hearsay.
Sustained.
Your Honor, he knew the identification of the people who were seating next to him.
Why don't you establish foundation?
All right, how did you come to meet the people who were seated next to you?
Well, I sat down, and I sat down next to her and saw her, and then didn't really speak to her, but a couple days after the shooting in the hospital, they were...
object at this point to 401, 402, 403.
Sustained.
All right, so you and Mr. Rotman were seated right here. Please tell the jury about what happened to you in the movie theater that night.
Okay, well, the first thing I saw was the canister go flying across the screen. And I don't know how I knew, but immediately I knew that it was tear gas. I mean, it just seemed so obvious to me. Then immediately my eyes went to see where that came from, and I saw the shooter emerge from here. And he was wearing a gas mask. He was wearing armor from head to toe. He was holding a big gun in his hand, and honestly, I just kind of froze in that second. And I watched him open fire into the front rows there, and he fired a couple rounds, and my immediate thought was, I just got to get down. So I looked over to Carrie and saw that he was looking around kind of to the left, and I could tell he didn't see where the shooter was or anything. I just said, we got to get down, and we laid down in front of our seats. His feet were in the aisle, my feet were pointing this way, and so we were kind of head to head. And the shots got closer and closer. And honestly, in that moment, all I could do was pray. I laid there and I prayed. And
what do you recall after that, Mr. O'Farrell?
so the first shot I took were fragments from a shotgun that hit me in the left toes. and it really felt like it just blew my toes off. And at that point, I kind of curled up in the fetal position, and then Carrie told me that he had been shot.
What did you do in response to what Mr. Rotman had told you?
All right, the objection is sustained. Go ahead, answer the next question.
I told him that I'm shot too, and at that moment, Carrie and I were laying like this, and then I remember looking up and seeing the laser bouncing around.
And could you describe for the jury what you actually saw when you said that you saw a laser bouncing around?
It was like a laser pointer, a little green dot, just bouncing around. I assume it was the sight from his pistol. And then almost instantly, I felt the next shot. He had taken aim and he shot with the pistol round.
Calls for speculation. Sure, objection calls for speculation.
Sustained.
And what did you actually see the shooter doing?
Well, I didn't look up at that moment, but I knew that I had been shot. The bullet entered in my arm, shattered my humerus in half.
And Mr. Roker, can I ask you to roll up your sleeve and show
Yeah.
the jury where it was that you were shot?
So the bullet entered right here. You can see the scar. It shattered my humerus in half, and it actually stayed into my bicep. I still carry that bullet today.
So after you had realized you'd been shot, what do you remember next in the theater?
Honestly, at that moment, it was just complete chaos. I remember round after round after round firing, and I really thought that I was going to die. I laid there, and I'd been shot 3 times at that point. I took another assault rifle round in my same left foot, and it was just round after round after round. It seemed like it was going on for an eternity.
How many shots do you think you heard in the theater that night?
Oh, gosh. I mean, it felt like hundreds. It really did.
At any point in time, did you have an opportunity to look through the seats and see the shooter?
Not after the very first time that I saw him. At that point, I wanted to keep my head down, my eyes closed, and literally just pray. That's all I could do.
And when you saw the shooter in the beginning, could you describe for the jury what the shooter's demeanor was like and what the shooter was doing?
Well, it seemed like slow motion. I mean, he seemed very methodical. Because like I said, I watched him walk in, I watched him fire a couple of rounds, and I never heard him say anything. I never heard anything but the gun going off.
Could you see if the shooter was holding the gun with one hand or two?
He was holding it with 2. I believe it was a shotgun.
Right. So after you were down on the ground, what else do you recall? How did you and Mr. Rotman get out of the theater?
Well, eventually the shots stopped, and Kerry was the first one to peek his head up, and he said, "Let's make a run for it." So we stood up from our spot in the ground, and honestly, gosh, it took all the strength I had just to stand up. And at that point, I believed I'd been shot in the back because the pain just radiated through my entire left side of my body. And I stood up, and Kerry was in front of me, and he made his way down the stairs, and I kind of followed him. But right about this last stair, I just kind of tripped over it and collapsed face first right by the bottom of the stairs there. And honestly, at that point, I didn't have the strength to get up again. And Kerry was shaking me, saying, "Pierce, we got to go. And honestly, in my mind, I thought, man,
Object at this point to 401, 402, 403.
Overruled.
What were you thinking?
And I was thinking, this is it. I mean, I'm going to die here. And I remember thinking, Kerry, you just get out and save yourself. And since I wasn't responsive to him, he exited the theater. And I just laid there. I laid there and I waited. At one point, I felt that dark presence standing over me.
I'm going to object at this point.
Sustained. Stitch McGuire after next.
Did you actually see a figure standing over you?
No, I was laying face down with my eyes closed, and I could hear the sounds.
Sustained.
What sounds could you hear?
People screaming, people calling 911. I could hear the movie still running. I heard someone shout out, "Turn off the movie." And I just laid there.
Were you eventually able to get out of the theater?
I was. When the police officers arrived, the first thing I remember was they kneeled down, they had gas masks on, and they had some kind of wand that I assumed.
Object at this point to cumulative to the other testimony we heard from first responders in 401, 402, 403.
Ask another question. I will sustain it for now. Ask what happened with respect to him.
All right, so could you describe for her how it was that officers got you outside the theater?
Well, first the officers kneeled down, and they turned me around on my back, and I had an officer at my head, an officer at my feet, and they tried to lift me up. But when they lifted me up by this arm, I mean, the arm was split in half, and the pain was so intense that I kind of shouted, "Hold on, drop me," and I think I can try and walk. And so an officer got on each side of me, lifted me up, and I kind of hopped my way out. They carried me this way and out the same exit that the shooter had entered.
What happened when you got on the outside of those doors?
Well, the first thing I'll never forget is the
Judge, I'm going to
the
interject
rifle.
an objection to relevance as to the environment outside the theater.
Sustained.
And were you placed on the sidewalk outside the theater?
I was placed right on the sidewalk.
All right.
Just for the record, it was sustained under Rule 403, not on relevance grounds. Go ahead.
Thank you, Your Honor. I don't have any more questions for you at this time. If you could take your seat back on the witness stand. Thank you. Were you transported for medical attention?
I was.
All right. What hospital did they take you to?
They took me to University Hospital, University of Colorado.
How were you transported to the hospital?
I was transported in the back of a police car.
Do you know who else was in that police car with you?
I do. A girl by the name of Jackie Fry.
What do you remember about that police car ride?
Well, we were driving, and I could see that she had fragments in her
Object to this
face.
point to 403.
Sustained.
What injuries did you sustain as a result of the shooting?
Objection asked and answered. Mr. O'Farrell's already described his injuries and shown them to the jury.
Overruled.
I sustained a fractured humerus in the left arm from a .40 caliber pistol round. I sustained, I guess I'd call it trauma, from shotgun pellets that went into my left toes and cut them up very severely. And then I sustained another wound in the left side of my foot from a assault rifle round.
Did you have any injuries to your chest?
And then I have some fragments of shotgun shrapnel in my chest as well.
Your Honor, if I may approach Mr. O'Farrell with what's been marked as People's Exhibits 2541, 2543, 4587, and 4591.
Yes.
Mr. O'Farrell, do you recognize those photographs?
I do.
Do they fairly and accurately represent the injuries you sustained on July 20th of 2012?
They do.
Your Honor, at this time, I would move for the admission of People's Exhibits 2541, 2543, 4587, and 4591.
Is there any objection, Ms. Spengler?
Your Honor, there is an objection to 4591. In addition to the prior objections made to 4591, we'd also add cumulative to the testimony of Mr. O'Farrell as well.
Can I see those pictures, please? P-TR-2541, 2543, and 4587 are all admitted without objection. Was 4591 subject to amended order D98B?
It was.
All right, for the reasons stated in that order, the objection to P-TR-4591 is overruled. And in terms of the additional objection, I find that the probative value of the evidence is not substantially outweighed by the unnecessary presentation of cumulative evidence. And so that objection is overruled. So P-TR-4591 is also admitted, and all of them may be published. Here you go. Thank
If I could please have 2541. All right, this is a photograph of you in the hospital on July 20th of 2012.
It is.
If I please have 2543. Please describe for the jury what we see here.
That looks like the left side of my leg. It's bandaged up just from extra shrapnel that kind of went in there.
If I could please have 4587. Please describe for the jury what we see here.
And that's my left foot, and that there's shotgun shrapnel. It was more, the damage was more on the bottom side of the foot than it was on the top.
And what happened on the bottom side of the foot?
Just buckshot, a lot of pellets went in there and just tore the foot up. It needed to be bandaged and wrapped, and that skin took a good 4 months to heal.
Point, Your Honor. 4014242.
Sustain.
If I could please have 4591. Right, you could describe for the jury what we see here.
So the bar in my arm was external fixator. They had to drill 2 pins in my elbow, 2 pins in my shoulder in order to put the bone back together. The area got infected about 6 weeks after.
Sustain.
All right, thank you very much. Mr. Rooks, could you please show the jury where you were seated that day?
I was roughly sitting around about right here, I want to say.
Right, and where was your seat?
It was about 4 rows over,
Right, and could you show the jury where Jordan's seat was?
right next to mine, so the seat right here.
Okay. Please tell the jury about what happened in the movie theater that night.
Like I said, it started as a regular night. Me and Jordan were having a conversation, and during our conversation, we were watching the previews of the movie. And prior to the movie starting, we actually had to scoot over at one point. There was a family that was actually coming up to where we were seated at, and they actually sat directly to my left where we were seated. And during the movie, the previews were going, the family was right next to us. We were actually exchanging conversation casually between the two of them. And it was just, it seemed like a regular night at first, and then as the movie got started, about 15 minutes in is when things started to change.
Tell the jury about what happened at that point.
From that point is when the canister was originally thrown. At first, I thought it was just a prank, to tell you the truth. It seemed like it was possibly a cherry bomb, or just some kids just acting out a little bit.
And did you have a chance to actually see that canister?
I did not.
Okay. What do you recall happening after that?
After the canister was thrown, that's actually when the explosion went off from the canister and the loud pop went off. Immediately after that was when the first gunshot went off directly to my right, towards the right side of the screen.
Did you actually see the shooter?
Not physically. I saw a rough silhouette of what this shooter looked like, but I didn't see his face directly.
And were you able to see the direction of where the flash went off in the theater?
I was.
And please show the jury where that was.
I was roughly around this area where the screen was at.
Did you notice anything else about the shooter or the guns at that point in time?
I could definitely tell it needed 2 hands for the gun to be carried, and I saw him physically as far as his outline of what he looked like.
Right? Any other description that you could give the jury about what you saw from the shooter?
Definitely wearing dark clothing. I could tell it was a male, around roughly 5'10", 6 foot, a decent build for sure.
What do you recall happening after you heard that first shot?
The first shot, I was still a little lethargic of what I was seeing, to tell you the truth. I wasn't sure what was going on. It wasn't until the shot directly afterwards when I realized there was actually gunshots going off.
What did you do after you realized gunshots were going off?
The second I realized gunshots were going off is when I actually proceeded to duck behind the actual seats themselves, and that's when I actually noticed Jordan was doing the same thing, and that's when I actually realized that there was something going on in the theater.
Did you show the jury where it was that you were ducking down behind the seats in your...
Oh, so where I was at, I was definitely around this area, ducking behind it, trying to have a good view of what was going on.
Do you recall how your body was positioned and how Jordan's body was positioned at the time?
I was definitely on my knees at that point, in a crawling position, and she was directly behind me doing the same.
What do you recall happening when you were down on the ground?
From that point is when I was kind of looking around to see what was going on. I turned back to see where she was at, and I noticed that she was doing the same thing. I asked if she was okay, and she said she was. And of course, she was crying at the moment. And that's when I said we have to go, and we actually proceeded to make our way towards the aisle.
Please tell the jury about how you physically did that.
So we were ducked down, of course. I was kind of looking up to see what was going on, to kind of get a trace of where the shooter was.
What could you see?
At that point, I saw the flashes. I heard the pops going off at the time, but I was kind of figuring out where he was based off the flashes that I saw.
Where were the flashes at that point in time?
Again, it was around this area.
So after you ducked up or peeked up and saw that, what do you recall doing next?
From that point, we continued to head towards the aisle, and that's actually when I bumped into a young lady and 2 kids.
All right. How young were these kids that you bumped into?
The kid was there was a young boy who was around about 3 or 4 months. The young girl was about 4 years old.
What happened when you bumped into that family?
The second I bumped into him is when the young lady actually turned to me and she told me it was just me and my 2 kids.
All right. So you noticed it was her and her 2 kids.
I did.
What?
Sorry, can you repeat that, please? She's asking
I apologize. What did you do after you noticed the woman and the two children?
From that point, when I noticed them, I was kind of making a split decision from that point. There was a lot going on through my mind at that point, but that's when I actually tried to guard him and lead him towards the aisle, trying to shield him at the same time.
And when you say they, you're talking about the children.
Yes.
What do you recall doing?
At that point, I was, holding on to her and the kids at the same time. We were trying to crawl our way towards the aisle without actually physically being affected by the shootings themselves.
Were you all still on the ground crawling, or
We were.
Okay. What happened while you guys were crawling?
So we were calling at that point. I was trying to keep track of them at the same time as far as the shooting as well. And at one point, once we actually got to the end of the aisles, when I looked up one more time to see where the shooter was at, and we actually tried to make a break for it then.
Were you able to see where the shooter was at when you peeked up that last time?
I was.
And where was the shooter?
Exact same place in this area.
Okay. How was it that you tried to make a break for it?
From that point, I actually tried to lift them up at the same time. She was getting up, holding one of the children while I was holding onto the other one. We were getting up at that point, and before we can actually physically get up, I actually immediately collapsed at that point.
Why did you collapse at that point?
From that point is when I actually turned on my back and realized I was actually shot in my left thigh from there.
On your left thigh, is that what do you recall the feeling of what happened when you got shot?
It was definitely a lot of pain initially. It was a lot of adrenaline going on, so I didn't feel the huge effects of it. I definitely could tell that I was shot. There was a lot of numbness in that leg, so I couldn't feel it.
So what happened physically when you collapsed?
From that point, I just remember turning on my side and just crying out very loudly. And from there, I was just kind of trying to get back into, realizing she was there, helping her out, still trying to get her out to the aisle and to the exit.
And when you said she, who are you talking about?
Patricia.
And is that the woman who was with you next to the two kids?
Yes, it was.
I'm sorry, I didn't hear the answer.
He said yes, it was. Is that correct?
Yes, sir.
What do you recall doing next?
From that point is when I actually turned back onto my knees and proceeded to help her out to the aisle. We went a little bit further, and she actually was able to make it out, but I stayed for a little bit longer.
And why did you stay for a little bit longer?
From that point, she seemed like she had a lot more strength than me at the point, so it was hard for me to actually physically get up. So I waited a little bit longer to see if I could make a break for it when the shots seemed less consistent.
And what were the shots sounding like to you in the theater at the time?
Definitely a lot of loud pops. I can definitely make out the sounds of gunshots for sure.
How were you able to finally get out of the theater?
From that point, is actually when I was in the aisle. From that point, went out the back exit toward the emergency exit into the back, and there was actually some stairs that were in the back leading towards where the projector room was at, and I actually went down those stairs leading to the front exit in the front of the theater.
Was your friend Jordan with you at that point in time?
She was not.
All right, at this point, I don't have any further questions for you at the model. You can go back and take your seat at the witness stand. Thank you. What happened after you made your way down the stairs to the lobby?
Making my way down the stairs was definitely not an easy task. I was shot in my left leg, so it was hard for me to actually physically walk down the stairs. There were people still trying to get down the exact same stairs I was. So as I was walking down the stairs, I was trying to hold on to the railing while not trying to fall or collapse myself.
Did you make it down the stairs?
I did.
What did you do after you got down the stairs?
After I actually physically got down the stairs is when I ran outside the main exit. After I exited the theater, that's when I was actually trying to seek help out to anyone who could notice.
Were you able to get help?
Eventually I did. At one point I actually noticed there was some kids around my age at the time.
Objection 403.
Sustained.
Were you transported to a medical facility?
I was.
All right, how were you transported?
Through an ambulance.
Do you recall if there was anyone else in the ambulance with you?
There was 2 other witnesses and 2 other paramedics.
What hospital did they take you to?
Denver Health.
What injuries did you sustain as a result of the shooting?
There was an injury shot to my left thigh.
And were you able to physically see that wound?
I was.
Please describe for the jury how large your wound was.
It was pretty large. My hand's pretty big, so I can actually physically put my whole hand in my wound.
And could you go ahead, please, and raise your hand and show the jury how big your hand is? All right, thank you. Your Honor, at this time, I would like to approach Mr. Brooks with what's been marked as People's Exhibits 2012 and 2013.
Yes, you may.
I have no objection to these exhibits.
Are you moving their admission, Ms. Teach McGuire?
Your Honor.
All right, without objection, they're both admitted and they may both be published.
If I could please have 2012. This is a picture of you at the hospital on July 20th of 2012.
Yes, it is.
If I could please have 2013. All right, please describe for the jury what you see here.
So that was the night of the shooting that happened, and it was actually the night where I was first in the hospital. And as you can see on my left eye is actually where I was shot, and a little above you can see definitely about 50 to 60 sit-ups a day after that as well.
All right, we don't actually have any pictures of your wound from that night. The police officers were not able to take them underneath the bandages. All right, I have no further questions for this witness. Thank you, Your Honor.
John's leg was on top of my arm, so I started moving, trying to nudge him, saying, all right, come on. And he wouldn't answer. I said, come on. He's gone. Let's go. Let's get out of here. But he still wouldn't get up. So I said, Greg, get his legs. We're not leaving him here. So we picked John up, and we started moving him out of the aisle and into the staircase.
All right. Based on where he was sitting, did you have to step over him to start to move him?
Yes.
And which part of his body did you grab?
His arms.
Okay. And you said Greg McDonald was the other one?
Yes.
And what did he grab?
His legs.
And were you able to move him down the aisle?
Yes, we got him into the staircase.
Was he heavy?
Yes.
What did you do when you got to the staircase?
We started taking him down, and we had to take him over somebody's body. And right when we got to the bottom, someone said he's coming back. So we dove into the front couple rows.
Couple things. Point to where you laid down John's body.
Right here.
Okay. And point to where you and Greg took cover when you thought he was coming back.
Right here.
Okay. What happened?
The gunman was on the other side of the front, or on the side from us, and firing more shots. People were coughing from the gas, thinking that they were going to suffocate. And once the shooting just died down, we decided to move again.
How much of the shooter could you see hunkered down there by those chairs?
The top of his head.
Okay. And could you tell if he had a helmet on or not?
No, I couldn't.
What'd you do?
We got up and tried to move John again, but the police had entered and were telling us to leave.
Where did you leave from?
This aisle, or this entrance.
Did you ever go back in?
No.
Yeah, I don't have anything further. Thank you, sir.
Were you at the Century 16 movie theater on July 19th and 20th of 2012 in Aurora, Colorado?
Yes.
How long prior to July 19th had you purchased tickets to the movie?
Roughly a week and a half, maybe 2 weeks.
What time did you arrive at the theater that night?
Give or take 10:45 p.m.
Who did you arrive with?
Tony and Bryson Billapondo.
Who were you meeting when you got to the theater?
Our other coworkers from Red Robin were already there, and I also had 4 other friends who were joining us later in the evening.
I think we know who the Red Robin crew is at this point. So who were your other friends that you were meeting there?
Mike White Sr., Mike White Jr., Paula, what's her last name? Adams, and Michelle Baker.
And who was Mike White Jr. to you at the time?
We were dating. He was my boyfriend at the time.
What'd you do when you got to the movie theater that night?
Put our stuff down, saved our seats, went to the concession stand 3 times, went outside, hung out, just walked around joking.
All right. And where did you find your seats in the theater?
Up in the stadium seating, Sully was already there and had a row saved, so we had the entire row except for 2 seats on the left side.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 1170.
Yes.
Do you recognize that diagram, Ms. Udani?
Yes.
Does it fairly and accurately represent what you recall happening in the theater on July 20th of 2012?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibits 1170.
Is there any objection?
No, Your Honor.
Without objection, P-TR-1170 is admitted and may be published.
Thank you. And with the court's permission, if I could ask Ms. Udani to approach the 3D model, Your Honor, to describe what she saw in the theater that night.
Yes, please take the handheld microphone. Thank you.
Hello.
Whoa,
sorry.
All right, Ms. Udani, could you please show the jury where you were seated in the theater that night?
Right here, 5th seat in.
All right, and who was seated on the other sides of you?
Mike White Jr., Mike White Sr., Paula, and Michelle. I'm not sure the order of Paula and Michelle, though.
And they were on the very aisle?
On the very end, yes.
Okay, and so then you were 5 seats in. All right, what do you recall happening during the movie that night?
Where do you want me to start?
So when did something happen in your movie that was unusual?
Oh, just a little bit. Yeah, the movie had already started. I don't know what point of the movie we were at. Heather Snyder and I were goofing off, joking about something. But something was launched from the upper right corner of the front is the screen, and it caught my attention mid-air, and then it landed what I thought was to be just a couple of rows below us, but on the left side.
All right, what do you recall happening after seeing that canister?
I saw smoke coming from it, and I started hearing pops. At first, I thought the pops were coming from the canister. Bunch of my friends got...
Please be seated. Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12-CR-1522. The records reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the prosecution is represented again by Mr. Brockler, Mr. Edson, Mr. Orman, Ms. Stitch McGuire, and Ms. Pearson. We're outside the presence of the jury. Are you ready for the jury, Mr. Edson?
Yes, one thing briefly, Judge. On the Hotmail emails, we'll be requesting publication the same way of giving to the jury, but we would request the court put a 15-minute time restraint just because of the hour and such. If the court has seen it, I don't think they need more than that time.
Okay. Mr. King, anything from you?
No, sir.
Okay. That's with respect to Exhibit P-TR-347A, correct?
Yes, sir.
All right. Let's bring the jury in, please. Yes.
So the court's aware, my intention is to recall Detective Apple and to publish some parts of 423A and 424A. The court had limited Mr. Madonna's testimony on those. I'm going to show some of them to Detective Apple. That is my plan, and that's what the nature of his testimony is going to be.
Okay. Please be seated, everyone. The record should reflect that the jury has joined us again. I hope you had a good lunch, folks. Welcome back. All right, call your next witness, please.
Recall Detective Apple, Your Honor.
Detective, do you solemnly swear or affirm on a penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please be seated.
Detective-
You've testified a couple of times already, but I'll have you state your full name for the record, please.
Okay. Craig John Apple, Appel, CraigJohn.
Mr. Orman, you may proceed.
Thank you. Detective, what I'd like to do is to publish a few pages of a couple of exhibits that have previously been admitted but not published and ask you some questions about them. The first one is Exhibit 423A, which were the screenshots from the Firefox bookmarks that were noted in 423B. So if we could please put up 423A 5. And I think it's just under 423.5. Detective, do you recognize this as a map of any part of the United States?
Yes, I do.
And do you know what date the bookmark for this was?
I believe this was June 24th, 2012.
And are you familiar with what those, markers represent?
Yes, I am.
And what state is this?
This is state of Colorado.
And what do those markers represent?
Those markers are Division of Wildlife shooting ranges we have in the state.
And this would be from the defendant's computer and the bookmarks, correct?
Yes, sir.
I'd like to, and this was something that was introduced when Detective Madonna was testifying?
Yes, he did search on these.
I'd like to show you another one from 423. If we could please put up 423.13. And if we could zoom in on the image there. Yeah, that's good. Actually, if we could get the whole thing in there, I'm sorry. 423.13. Just so that we can get the, that's perfect, thank you. Okay, do you know the date that this was accessed, the bookmark?
I believe it was July 2nd, 2012.
And what does it say at the top of this?
How to make book 1.
Thank you. I want to go to the artifacts that Detective Madonna testified about. Now, do these have a date associated with them?
No, they don't.
Okay, so let's go to a few of those. I just want to ask you about them. If we could have 424, and this is from Exhibit 424A, 424.18, please. And if we could zoom in on that, yes, thank you. And this would be, what does it say at the top of that?
Colorado laws regarding auto glass window tinting.
And did we hear testimony in this case about tinted windows?
Yes, we did.
If we could please put up 424.25. And so we can, if we can show what the search was for there. Actually, there you go. What's the search for there?
This was a Bing search for firing systems for fireworks.
And now, if we can go to the next page, please, 424.26. What does it say at the top of that?
This was the website for remotefiringsystems.com. It's their homepage.
And if we could please put up 424.28. And this says YouTube, and everybody probably knows this, but if you could just explain what YouTube is.
YouTube would be, we use it all the time just for self-help, watching videos or watching a video to learn a process or a method or repair something.
Okay, 424.31, please. And is that also for remote firing systems?
Yes, that's one of their, I guess their website, their contact information.
Now take a look at that item in there, and I want to show you 424.37. do you see that?
Yes.
And are both of these items, are they similar to any piece of evidence that was collected from the defendant's apartment?
Yes.
What?
The launch control system, the panel that was on the top of the refrigerator.
If we could please put up 42445. And if we go to the search and then the first couple of things. And what's the search here for?
This is a Bing search for launch control transmitter setup.
If we could go to 42450, please. And again, the search in the first couple of items. What is this a search for?
A Bing search for potassium permanganate and gasoline. These were the ingredients found in his apartment.
If we could go to 42453, and again, the search in the first few items. And what does that say?
This was kind of like a general search, Bing search for sound, maximum public. Has to do, if you read on.
I think that's enough, thank you. If we could go to 42459, please. And this is a page from Wikipedia, and I know everybody knows this, but lawyers have to ask questions like this. What is Wikipedia?
Online encyclopedia.
And what is this entry for that he looked up here?
Military tactics.
And if we could go to 42461, another Wikipedia page. What is this one for?
Military strategy.
Couple more for you. 424-104. And what is this?
This would be a YouTube concerning, it's going to be a video of a smoke grenade or a red smoke grenade going off.
424-113. And again, yes, thank you.
Another Bing search on pipe bombs, PVC.
And then the last one I want to show you is 424-114.
This would be another Bing search for black powder.
Thank you. I don't have anything further, Your Honor. Thank you.
Is there any cross-examination, Ms. Spengler?
No.
All right. And the jury does not appear to have any questions. Detective, thank you. Call your next witness, please.
Jeremy Phelps?
You solemnly swear or affirm in a penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Please be seated. You've testified before, but I'll have you state your full name again for the record, please.
Yes, Judge. My name is Jeremy William Phelps, Jeremy William Phelps.
Mr. Edson, you may proceed.
Thank you. Just so we're all, we can all recall, tell us how you're employed.
I'm employed with the Federal Bureau of Investigation.
Are you a special agent?
Yes, I am.
Your Honor, can I approach to grab an item of evidence, please?
Yes.
Thank you. Placed before you People's Exhibit 1227. It's already been admitted into evidence. First of all, have you been here through the course of this trial?
I have.
Listened to all the testimony in the trial to date?
Yes, I have.
Do you recall the testimony about the CU emails?
I do.
So the second to last email that's contained in People's Exhibit 1227, can I just have you go over with the jury the response from the defendant and give us the date, please?
The date of the email is June 12th, 2012 at 10:35 p.m. It's an email to the defendant's father, also used previously as Bobo. It says, hi, or hey, Bobo. Alternate emails you can reach me at are dsherlockb@hotmail.com or dsherlockb@gmail.com. It's your moolah. Do what you want with it, Jimmy.
Thank you. May I approach the witness, Your Honor?
Yes.
I've handed you what's been previously marked but not admitted, People's Exhibit 347. Do you recognize that?
I do.
What is that?
It's the CD containing the Hotmail records.
Were you here during the testimony from the representative from Microsoft and Hotmail pertaining that particular email account, dsherlockb@hotmail.com?
I was.
Subsequent to that testimony, did you have an opportunity to view the emails in People's Exhibit 347?
I have.
At some point after or even during your review of People's Exhibit 347, did you select any emails out of that particular exhibit pertaining this case?
Correct. I pulled out emails deemed relevant to this investigation.
Characterization.
All right, members of the jury, I'll give you a clarifying instruction. When he says deemed relevant, that's based on what he felt was relevant to this investigation. But you're not bound by that testimony. And so that does not refer to any determinations of legal relevance. Those are determinations that only I make. And his testimony also does not control your determinations of what you believe is relevant to the determinations or to the findings of fact that you will be making, okay? All right, Mr. Edson, you may proceed.
Go ahead, sir.
And those emails ranged from April 2011 to July of 2012.
You also testified about viewing the Gmails from the Gmail account, is that correct?
I did.
Were these emails in the Hotmail account set up differently than Gmail?
They were a lot different in reviewing this record. The Gmails were able to use a viewer and look at them as if they were, most people are familiar with Outlook and easy to go through. This particular set of records, it's almost in a Excel type spreadsheet with links on the far right hand side, which would include related attachments, content, and header information.
Was it able to be part of your work to actually put the Excel portion that may contain a date and a time, for example, on a page right before the actual contents of the emails?
Correct. So with each email, I have the individual information related to that email, the to, from, date, and then any related information, if there's content, pictures, attachments, etc.
Your Honor, may I approach the witness, please?
Yes.
I've handed you what's been previously marked as People's Exhibit 347A. Do you recognize that exhibit?
Yes, these are the emails that I pulled out from the CD.
Okay, what email addresses are those emails specifically related to?
dsherlockb@hotmail.com.
Have you had an opportunity to view People's Exhibit 347A prior to your testimony today?
I have.
Did you have an opportunity to go through each of the emails associated with that exhibit?
I did.
Is that exhibit set up with the header information as the first page followed by the email?
Yes. So you, For just frame of reference, you have a few different sections. You have the folder in which the email was located, a message ID, a from, to, state, which is usually blank, message type, subject, and a date.
Do some of the emails have attachments associated with them?
They do.
Are those reflected in some of these emails as well?
They are.
Your Honor, at this time, I would move for admission of People's Exhibit 347A.
Is there any additional objection?
No.
All right, would counsel please approach for a moment? All right, based on my previous ruling, which includes comments at two different junctures in the proceeding, as well as my comments just now, the exhibit is admitted. That's People's Exhibit P-DR-347A. And Mr. Edson, are you asking to publish it?
Yes, this is what I'd like to do, Judge. I'd like to show two specific emails on the screens and then permission to publish the way we've been doing it by handing the copies to the jurors.
All right, you may proceed.
We could please have 347A, the first page one. And Special Agent, actually, I misspoke. This is not the actual first page of that exhibit, is that correct?
That's correct.
This is further into People's Exhibit 347A, is that correct?
Correct, towards the end.
So what I'd like to do here is, can I have you, I don't necessarily need you to read this exhibit that we have up here. But what I'd like you to do is just put some context to it, but specifically give us a date and a response that starts with "Hey, Bobo."
You have an email from Robert Holmes, the defendant's father, sending an email to the defendant, asking how he's doing, what his plans were for the 4th of July. And then you have a response from the defendant, "Hey, Bobo, Colorado has essentially banned all use of fireworks and canceled all fireworks shows due to Colorado Springs wildfires. Not much else going on. Have a happy 4th of July, Jimmy."
Do you still have People's Exhibit 34A in front of you?
I do.
I neglected to have you do this ahead of time, but can you go ahead and look at the head sheet information and tell us the date that this email was sent by the defendant, please?
I think you said 34A. Did you mean 347A?
I did, my apologies, 347A.
So on the header information, the date is July 4th, 2012 at 11:28 a.m.
If we could have 347A2, please. Do you recognize this email?
I do.
So I'll let you go ahead and look through the exhibit in front of you and tell us the date and time of this email and have you do the same thing.
So on the header information, this email is July 12th, 2012 at 10:20 p.m.
And give us the context and the response from the defendant, please.
You have another email from the defendant's father asking to visit during the weekend of August 10th through 12th, asking if he's available and if he has anything else planned. The defendant responds by saying, "Hey, Bobo, don't have any plans for that weekend, Jimmy."
Thank you. We can take that down. Judge, I would request to publish now to the jury.
All right, members of the jury, we're going to publish this in the same way that we've done with other exhibits. And so we're going to give each of you a copy, and then I'll give you a little time to review it.
Your Honor, may we approach briefly while they're being handed out?
Yes.
Thank you.
You start reviewing those, let me give you an instruction. The statements contained in these emails or in this exhibit, this entire exhibit that's being distributed to you right now, that are statements that were allegedly made by someone other than the defendant, have been admitted for a limited purpose. They have been admitted for the limited purpose of placing the defendant's statements in context and making them intelligible. You cannot consider those statements for any other purpose. Does everybody understand that? And everybody's saying yes and nodding their head yes. All right, thank you.
And Judge, I apologize. I'm not going to have any additional questions for Special Agent Phelps. I'm not sure if the defense does, but at least during the reading, if he could be allowed to step off the stand, we would have no objection to that.
All right, Ms. Spengler, do you know if you're going to have any cross-examination?
I don't have any cross-examination.
All right. Thank you, sir.
Thank you.
If the jury has any questions, we'll call you back out.
Yes.
Yes. Yes. Rockler, please call your next witness.
Your Honor, the people call Ashley Moser, and if the court will permit me a moment to discuss with her what we talked about at the bench.
Yes. Good afternoon. Could I have you raise your right hand, please? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Could you please tell us your full name and spell your first, middle, and last names?
Ashley Veronica Moser, ASHLEY-VERONICAMOSER.
Mr. Brockler, you may proceed with your direct examination.
Thank you. And ma'am, you're a bit soft-spoken to the extent that you can. Thank you so
Okay.
much for doing that.
Yep.
Would you tell us what you do for a living these days?
I'm not working right now. I was in school, but I took this semester off. So
Are you going to be going back to school?
yeah, I go back in the fall.
Okay. What are you studying?
Now I'm studying social work.
Okay. I want to ask you about July the 19th and 20th of 2012. Can you tell us if you went and saw a movie that night at the Century 16 Theater?
Yes, I did.
I'm going to ask you to tell us who you were with, and then we're going to backtrack a little bit and talk about how you got there, okay?
Okay.
Tell us who was with you at the movie that night.
Jameson, Toes, which was my boyfriend at the time, Veronica, my daughter, Kaylin, Jameson's cousin, and Haley, her friend.
All right. How old were you back then?
25.
How old was Veronica?
6.5.
Was Veronica your only child?
Yes.
The other two girls that you named, how are they related to you, or how did they come to be there with you? And let me back up then. Earlier that day, what had brought Veronica together with Haley and Kaylin?
Well, I needed somebody to babysit Veronica for my ultrasound earlier that day.
Why did you need an ultrasound?
Because I had just recently found out that I was pregnant. So we were going for ultrasound, and there was no kids allowed back there. So we dropped Veronica off at Kaylin's so that she could babysit.
Did you go to the appointment?
Yes.
Did you get good news?
Yes, I did.
And did you come back to be with Veronica and Kaylin and Haley?
Yes. Yeah.
Did you share that news with them?
Yes.
What ensued? What happened as a result?
I'm sorry.
What did you do after you shared the good news with them? Was it, did you take steps to celebrate?
Yeah. We had stopped at Papa Murphy's to grab a pizza, came back and ate pizza, and we had thought about going to the movies that night, and Kaylin had mentioned that the Batman premiere was that evening, so we decided to go ahead and see that movie.
Was the mood pretty light and excited?
Yeah.
That's late to go see a movie with a little one.
Yeah.
Did you know what kind of movie it was when you talked about it and agreed to it?
No, I did not.
Sorry.
Okay.
No, I didn't. I thought when Kaylin had said the new Batman movie, I don't know, I remember the Batman movies when I was younger, and I just had assumed that it was going to be like a family movie.
Not as dark
Not
and
as
graphic.
dark as and graphic as I thought it was.
Nonetheless, did you guys go a little early
We did, yes.
to get seats?
Yes.
What time do you think you got there?
Probably like 10:15, 10:30.
And who saved seats?
I did.
And when you saved seats, where did everybody else go?
To the arcade.
Your Honor, may I approach the witness with what has been previously marked as People's Exhibit 1146?
Yes.
Oh, yeah, of course, yeah. Thank you. Sure. Thank you. Ma'am, I'm handing you what has been marked as People's Exhibit 1146. Do you recognize what that is?
Yes.
Tell us what it is.
The design of the theater.
The theater that you saw the Batman movie in that night?
Yes. Mm-hmm.
Does it have indications where you and everyone were sitting?
Yes.
And does that still remind you of where everyone sat from way back when?
Yes. Mm-hmm.
And is that a fair and accurate copy or a fair and accurate representation of what took place that night, at least in the limited fashion that's on there?
Yeah.
What I'd like to do, Your Honor, if I could, is to describe the action. I'd like to have Miss Moser come up to the exhibit if I could.
Okay.
And ma'am, I'm gonna, this right here, I'll grab that. I will, Jesus. Mhm. Ma'am, so that we can hear you, I'm going to give you this microphone. Can you hold that and still point to stuff if we do that?
Yeah.
Okay, let me give you that. Now, if you could, if you can reach, can you show us where you were sitting that you recall back on the 19th of July before the movie started?
Yeah, I believe it was in this fourth row right here, like in the middle.
Towards the middle, and I'm
Yeah.
pointing where I think the middle is. Am I close to one of the seats?
Yeah.
All right, now from where you were there, and let me ask this. Did you walk into the theater that night?
Yes. Uh-huh.
From where I'm pointing, approximately where you were sitting, who was seated to your left?
Jameson was on my left.
Was anyone else to the left of Jameson?
Yeah, but we didn't know who was not with our group.
Yes, and thank you. I should have asked a better question. Who was to the right of you?
Veronica.
Who was to the right of Veronica?
Kaylin.
Who was to the right of Kaylin?
Haley.
And again, these are approximations. I may not be touching the right seats. Is that fair?
Right.
Okay. And they're indicated on that People's Exhibit that we just talked about?
Yes.
All right, after the arcade, all those kids in Jameson come back?
Yes.
And the movie starts? Yes?
Yes.
Do you have concerns that the movie now is not quite the family-friendly flick you thought it might be?
Yeah, during the previews, I kind of figured it was going to be a little more R-rated than I had thought.
What happened while you were watching the movie?
Well, I had all of a sudden during the previews, I heard something explode like to the back left of me.
And forgive me for saying, if you say back left, I'm pointing in a general area. Do you mean back in this area here?
Yeah.
Okay. And do you know what it was or where it came from?
No, I didn't see where it came from, and I didn't know what it was at the time. I just had heard something explode and then a bunch of gas coming out, and I don't know, I assumed it was a stink bong from when I was like in high school, but I recognized it didn't have this smell. So.
Then what happened?
And then as soon as because I had turned my head, as soon as I heard it explode, and then right when I went to turn my head forward, I saw a flashing light in the sky, which I thought was or not the sky, in the air, and I thought it was a firework.
Do you know where in the theater the firework thing seemed to come from?
Yeah, it seemed to come from like upper left.
I would give you the pointer, but are you talking about in this area where I'm pointing here or somewhere else? Tell me where.
Well, I guess a little like more towards the middle front, like, yeah.
And you thought you saw something that was fireworks?
That looked like fireworks to me.
Now, before all that happened,
Mhm.
before the movie starts, without going into any words that were spoken,
Mhm.
where was Veronica at first sitting before you moved her?
During the previews, she was sitting on my lap.
Did you move her to that seat that you've indicated?
Yes, I did.
And why?
Just, she was, because I had just found out I was pregnant, and it just kind of hurt my stomach a little, and she was a very tall, bony child, so I had her move to the seat next to me.
Okay. So you hear that thing hit behind you and explode, the gas. You talked about the fireworks thing that you think up here. By the way, at that point, do you have any idea that it's gunfire?
No. I had no idea.
What did you do?
Well, I assumed it was just kids playing pranks. So my first thought was to leave the theater, but I went to stand up to reach for her hand to try to exit.
When you say her hand, you mean Veronica?
Veronica's hand, yeah.
Okay. Did her hand reach back?
No, I couldn't feel it. Like, just it slipped through my hand.
Were you able to stand up?
As soon as I stood up, I just remember getting a hit in my chest. And I remember falling, then landing on top of her.
Do you know what hit you in the chest?
No, I thought it was a firework at the time.
When you fell on top of her, could you feel her moving?
No.
Could you feel her breathing?
No.
Could you get off of her?
No. I tried, but I couldn't move.
Do you hear anything going on around you?
Yeah, I hear the movie still playing and people crying and screaming and yeah.
Were you scared?
Yes.
What happened?
Well, the next thing I know is I was getting carried out, which I vaguely remember, out of the theater.
Do you know who carried you out?
No.
Do you know which direction they carried you out?
I mean, I kind of felt like it was down that way and out.
Out the aisle this way, and I'm using my finger.
Yeah.
And down as you're facing the screen, the right steps, and out the door that I'm pointing to towards the parking thingy?
Yes.
Did you see your daughter get carried out?
No.
When you got to the hospital, And you know what, ma'am, let's do this. We don't need to talk about this part anymore. Do you want to go back?
Yeah.
Let me take that.
Mr. Bruckler, is your microphone on? Okay.
Yes, sir. When they took you to the hospital, did you have any surgery?
Yes. I think I had two, one right away. I'm not really sure what the first surgery was when I got to the hospital. But then I did have a second one like a week later, I believe.
After the first surgery,
Uh-huh.
did you know what your physical health was at the time?
I don't believe so, no.
Could you move?
No.
Did any medical people tell you that you'd been shot?
Yes.
Did they tell you? I'm sorry, ma'am. Go ahead.
Yeah, I think they had.
Did they tell you how you were shot?
Um,
And I should ask, do you know where you were shot and where the bullet went?
yes.
Tell us.
I have, well, I guess I got shot 3 times, one in my thigh and twice on my back. One went all the way through my chest, and the other one ricocheted off of my shoulder blade and into my spinal cord onto my C7.
Talk about that in just a moment. Your Honor, may I approach the witness?
You may.
Ma'am, I am handing you what has been marked as People's Exhibit 4852, 2041, 4884, and 4880. Would you take a look at those and tell me if you recognize what's in them?
Yes. It's me in the hospital.
If you could do me the favor of looking at the number on the bottom of that,
Mm-hmm.
saying what the number is, and telling us what that is a picture of?
It's 4852. It's a picture of me with a breathing tube.
Can you go to the next one, please, ma'am?
Mm-hmm.
Tell us what the number is and what you see.
2041. It's the exit wound through the chest, where the bullet went through.
Thank you. Can we look at the next one too, please?
4884. You can barely see, but in my back of my shoulder, that's where the entrance went, the gunshot entrance went in.
Ma'am, forgive me for asking you to speak up just a little bit more. I'm sorry.
Oh, that's fine. That's where I got. That was the entry, where I got shot.
Did the bullet, as you understand it, go through your back and into your front?
Yes.
Okay. And can you look at the last one?
Last one is 4880, and it's one where I got shot in my thigh.
Do those exhibits, ma'am, do those fairly and accurately capture the injuries that you received at the theater that night?
No, they look a lot cleaned up to me, so especially with my exit wound from the chest.
Did you see them before a lot worse than that?
Well, while I was in the hospital getting wound care quite a bit, yes, I did, and it looked a lot worse than when it was bandaged.
Besides that, are there any other photos that you're aware of that better represent the injuries that you sustained at the theater that night?
I don't think I have any, no.
Your Honor, I'm going to move for the admission of those 4 exhibits into evidence.
Is there any objection to P-TR-2041, 4852, 4880, and 4884.
No, sir.
All right, without objection, they're all admitted, and they may be published.
Your Honor, may I just stand here to read the numbers to Amber?
Yes.
Ma'am, would you please put up there 4852 for me? Is this you in the hospital?
Yes.
Can you get us, please, 2041? Now, what are we looking at here, ma'am? Can you tell us?
That is the exit wound from the gunshot.
Thank you. 4884, please. This isn't the best view of this, I imagine, but what is this showing us?
It's showing where the entrance was in the back of my shoulder.
4880, please. What's that right there?
Picture of where I got shot in my thigh.
Okay, thank you. So, after the surgery, were you told of another injury, specifically about your pregnancy?
Yeah.
Tell us.
I was told that I had miscarried during my surgery, so that I had loss.
Were you told, and again, this is Thursday night, Friday morning that this thing happens, were you told on Sunday, finally, something about your daughter?
Yes, I was.
What were you told?
I was told that she didn't make it, that she had passed away.
I want to talk to you a little bit about the permanence of some of the injuries that you suffered, okay?
Okay.
First off, you told us that a bullet had ricocheted off of part of your shoulder and went into your spine. Do you remember that?
Yes.
Can you tell us where in your spine that was?
The bullet is lodged in my C7 of my spinal cord.
Did they remove it?
No, they said it would cause more damage if they were to remove it.
Is it in your body right now as you sit here?
Yes.
As a result of that bullet lodged in there at C7, did you lose the use of your arms and your legs?
I did, yes.
Now, did you ultimately go to some place for rehabilitation?
Yes, eventually I went to Craig Hospital.
And can you just tell us the dates that you were at Craig Hospital?
I think I got there like August 20th.
Of 2012?
Of 2012. And I got out late December 2012.
2013 or 2012?
2012. I was there 4 months.
Okay. And then after that, what happened? Did you go home?
No, I couldn't go back to where I was staying because I was staying in my dad's basement and I wouldn't have been able to get down the stairs, so I stayed in a hotel until I found a place.
During the time that you were at Craig Rehab, were you able to regain some use of your arms?
I was, yes. I became very fortunate, yeah.
Do you remain paralyzed and unable to walk?
Yes.
Does that include depriving you of the ability to control bodily functions?
Yes.
Is that permanent?
Yes.
As a result of that bullet lodged at C7, do you have ongoing nerve pain?
Yes.
Where?
Throughout my legs.
There was something else I forgot to ask you about, and I'm sorry. as a result of one of the surgeries that you had from that exit wound that we looked at, did you have to have some part of your internal organs removed?
Yes, I had to have my upper left of my lobe, or I'm sorry, upper left lobe of my lung removed because it had the bullet had punctured that lobe of my lung.
As a result of having that lobe, that portion of the lobe of your lung removed, have you had to be on ongoing oxygen?
Yes, they didn't think that I would be able to get off of oxygen, but I'm still on it at night.
Have you been told that that's also going to be forever?
I get checked every year, but I'm not sure. It might be, yeah.
There's one other thing I want to ask you that's directly related to the permanence of that injury to your lungs. What are quad coughs?
Quad coughs are because I don't have the strength my lungs don't have the strength enough to cough, or clear my throat even, so I have to bend over and basically kind of give myself like the Heimlich maneuver to get anything out of my throat or my lungs.
You still do that today?
Yes.
We've talked about what took place in the theater. I want to show you just one more picture, okay?
Okay.
No. May I approach the witness, Your Honor?
You may.
Ma'am, I'm handing you what's been marked as People's Exhibit 4731. You recognize that?
Yes.
What's that a picture of?
That's a picture of Veronica.
How soon before her death was that taken?
Not long, because it was her kindergarten graduation.
Your Honor, I'd like permission under the limits the court has imposed to publish that picture.
Yes.
Ma'am. Is that Veronica?
Yes.
I don't have anything further. Thank you.
Mr. Bruckler, are you moving the admission of P-TR-1146?
Yes, sir, thank you.
Is there any objection, Ms. Brady?
No, sir.
All right, that's admitted. Ms. Brady, do you have any cross-examination for Ms. Moser?
No, sir.
And the jury does not appear to have any questions. May Ms. Moser be released from her subpoena?
Yes, sir.
Is there any objection?
No, sir.
All right, Ms. Moser, thank you. Call your next witness, please, Mr. Bruckler.
Your Honor, the people of the state of Colorado rest.
All right, members of the jury, it's 2:35. Today's a day when we were planning on stopping at 3:30, but you just heard that the prosecution has rested, so I think it makes sense to stop now. There are some things that the attorneys and I have to work on that we're required to do at this juncture in the proceedings outside your presence, and so we'll do that. As I mentioned before, we're gonna take Monday, Tuesday, and Wednesday off, and we'll be working during that time. And the work we do now hopefully will save us some time later on down the road. Since I'm about to release you for 5 days, including the weekend, I'm gonna give you the advisement. We have 19 of you at this time, so that's 7 alternates. And so I wanna make sure that I emphasize for you the importance of all these advisements. I know that you've heard me say it before, but I can't emphasize enough how careful you have to be to make sure that you comply with each and every one of these. Sometimes, even if you're being careful and really attempting to do your best to comply with all the advisements, inadvertently it can happen. And so the more careful you are, the better off I think you're going to be. I've mentioned before that, for example, there is media coverage of the trial, and that the best thing to do is just to avoid watching or listening to any news and reading any news if you can. So I'm going to go through these now. Number one, please remember that you may not talk about the case, any aspect of the case, with each other through any means. You're free to talk to each other about anything else. You just cannot say anything about the case or about the proceedings or about your service as a juror in this trial. Number two, please do not discuss the case with anyone else through any means. That includes your spouse or significant other. I know that's a difficult thing I'm asking of you, but it's something that you're required to do. You're required to abstain from talking to anyone else about the case, and you must tell other people to make sure that they refrain from talking to you about the case. So if it's someone who's a relative or a friend, just tell them in advance, don't say anything about the case. I can't talk to you about the case, can't hear anything about the case. All you can tell people is you're on a jury in Arapahoe County, and we're anticipating that the trial will last through no later than sometime in early September. That's at least the hope. That's what we're aiming for. Number three, you may not have any contact or communications with any jurors who have been dismissed. I've mentioned that there was a juror here yesterday and today watching the proceedings, and she's a member of the public. She's welcome to do that, but you cannot have any contact with her, and she understands that she cannot have any contact with you. Next, please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. To make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse grounds, and that it is visible to everyone around you. Your juror badge will reduce the risk that people will talk to you, will talk about the case around you. So if you hear anyone talking about the case, please remove yourself from that location immediately. If despite your best efforts, you nevertheless hear something about the case, regardless of who's saying it, whether it's a member of the public, another juror, an attorney, a witness, anyone, then please let my staff know that you need to talk to me. All you have to do is tell them that you want to talk to me. Don't tell them what it's about. And then once I hear that you need to talk to me, I'll bring you in alone and we'll chat. Next, please do not talk to any members of the media about anything. Please remember that I have issued some orders that relate to the media. And so for that reason, it's important that they know if you're a juror. That's another reason to have your juror badge on at all times, to allow the members of the media to comply with all my orders. You must not read, view, or listen to any news or media reports that may refer in any way to the case. As I mentioned before, there is media coverage of the trial. Sometimes there is news coverage about things that you may have witnessed here in the proceedings, but there are other times when there may be news coverage of discussions that the lawyers and I are having. This is still a public proceeding, and so there may be reports about things that you are not allowed to hear and things that we're discussing outside your presence. But regardless of what it is, whether it's something that you were here for or something that you were not here for, you're not allowed to read or hear or view anything from any media report about the case. And so you have to be particularly careful with respect to this advisement so that you avoid any issues. Again, I mentioned before, we started off with 12 alternates. Now at this point we have 7. So please be very careful. Next, you cannot visit any locations mentioned in the case or conduct your own investigation outside the courtroom. That includes looking terms up in a dictionary, on the internet, looking up treatises, perhaps looking up medical terms, legal terms, looking up or consulting religious books, or scientific books or technical books or computer books. You just can't refer to any source outside the courtroom. We need to make sure that you're not getting information outside the courtroom that you're going to use to make any decisions in this case. You cannot visit any locations mentioned in the case. I mentioned that before, so now you heard it twice. Next, all your verdicts in this trial have to be based only on the evidence presented in the courtroom and the instructions of law that I give you. Again, I know that I've phrased this particular advisement in different ways, and to the extent that I've said before that you must make all your decisions in this case based on the evidence, based only on the evidence and information presented in the courtroom, I'm referring to the evidence presented in the courtroom, and then, of course, the instructions of law that I give you. You cannot start forming any opinions about the case until I tell you that you can start deliberating. You have to keep an open mind throughout the trial. You cannot internally start thinking about any decisions that you may have to make in this case. Only when I tell you that it's okay for you to start deliberating may you do that. Neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. And please remember that the attorneys have a job to do that requires sometimes to make objections or to seek bench conferences. Don't hold it against them when they do that. Similarly, please keep in mind that I'm neutral in these proceedings. I'm not for one side or for the other. I'm just doing my best to apply the rules of evidence and other applicable rules of law. Please don't take an attitude of nobody's going to find out if I just do this one thing, or it's not a big deal if I just tell my husband or my wife about this because he or she's not going to tell anyone and nobody will find out. We rely on you, we trust you to follow each and every one of these advisements, not because someone's watching over you or because you think you're going to get caught, but because you have taken an oath to follow all my advisements. And you have said to me that you will do these things. And so do them for that reason. Don't take an attitude of it's not a big deal if we just violate something one time or who's going to find out, because those are the kinds of attitudes that will get you in trouble in terms of creating issues for us here, all right? Okay, with that then, please get some rest over the next 5 days. Let's have you back here on Thursday of next week. So we'll take Monday, Tuesday, Wednesday off. The lawyers and I will be working, but then we'll have you back here on Thursday morning at the usual time, okay? All right, thank you, folks. Have a great weekend, great Father's Day weekend, and then great 3 days after that. Thank you. Please be seated, everyone. The record should reflect that the jury has left the courtroom. I would like to briefly keep counsel here just so that we can talk about scheduling for next week. So there are 3 things that I have on my list of things to do. Number 1 is whether the defense wants to make a motion for judgment of acquittal. Number 2 is the court's advisement. I at least would like to make the first part of that advisement for the defendant. And number 3 is having at least some discussion about the instructions. I understand that the defense may not be ready to take a final position on all instructions, but I think it would be very productive to start talking about instructions. Now, I don't need all of you here. If you don't all want to be here, I need to have the defendant here, and I need to have at least one attorney per side. So I'll leave it up to you. So we have to decide what day we come in. And I'm pretty open in terms of whether we do it on Monday, or we do it on Tuesday, or we do it on Wednesday. Do you have a preference, Ms. Nelson?
Your Honor, I discussed this briefly with Mr. Orman and Ms. Pearson this morning, and what I was thinking was perhaps it would be helpful if I could submit to the court on Tuesday, maybe by noon, some initial instructions, defense proposed instructions, and I can do that. I think Rule 30 requires me to submit those, actually file those with the clerk, and I can give you a disc or else email a Word version of those if that would be helpful.
That would be great. That would be very helpful, in fact. So I would appreciate you doing that. So if you can do that on Tuesday, perhaps we could meet on Wednesday?
That's what we were thinking, Your Honor, in the morning,
Okay.
perhaps. And then we will have some additional instructions, probably a theory of the case instruction and some other instructions at the close of all of the evidence, but these will be, sort of the basic ones that we can get started with, and I think we're all available to do that begin that discussion on Wednesday morning, if that would work for the court.
That would work for me. To the extent that you're thinking along the lines of requesting lesser included offenses, and I'm not saying that you are or that you're not, but the more notice you can give me with respect to those, the better off we're gonna be. And again, I'm not making any rulings at this time as to whether I think any lesser included offenses would be either requested or allowed by the court, but to the extent that that's something that you're gonna be interested in, I think we should start talking about it sooner rather than later.
Understood, Your Honor.
All right. Mr. Orman.
Wednesday's fine with us, Your Honor, and we appreciate counsel's offer to get those jury instructions us the day before. Regarding the first issue that the court raised, the mid-trial motion, my preference would be to do that this afternoon. We still have some victims here. They might want to see that rather than us talk about jury instructions and a Curtis advisement and things of that nature. I'm ready for any defense motion for judgment of acquittal.
All right. Is that okay with you, Ms. Nelson? I'm assuming you're the one who's going to be making it.
That's fine, Your Honor. It'll be very brief.
Okay. All right. Do you folks want to take a short break?
That's fine with us, Your Honor.
All right. Why don't we take like a 15-minute break and then we'll proceed. Okay. The court will be in recess. Thank you.
I know it's been a while. Marshall Zellinger here in the 7 Newsroom with Phil Tenser and Anika Padilla. Your Honor, the people of the state of Colorado rests. The prosecution is done with their case as we expected with the testimony of Ashley Moser. And if you've been following along, you basically had heard the testimony from the judge when they were talking about what she would be allowed to testify about and what she would not be allowed to testify about. But Ashley Moser, the final witness of the prosecution, and then there will be a 3-day break before the defense starts its case. There is still more to be heard today, along with scheduling and some housekeeping inside the courtroom. We will get you back there, but right now we want to play for you the most impactful testimony probably of any of the survivors, and likely purposefully the last survivor and the last witness to take the stand for the jury to be left with this over a long weekend. Here is Ashley Moser's testimony of her experience on July 20th, 2012.
Ma'am, so that we can hear you, I'm going to give you this microphone. Can you hold that and still point to stuff if we do that?
Yeah.
Okay, let me give you that. Now, if you could, if you can reach, can you show us where you were sitting that you recall back on the 19th of July before the movie started?
Yeah, I believe it was in this 4th row right here, like in the middle.
Towards the middle, and I'm pointing where I think the middle is. Am I close to one of the seats?
Yeah.
All right, now from where you were there, and let me ask this. Did you walk into the theater that night?
Yes.
From where I'm pointing, approximately where you were sitting, who was seated to your left?
Jameson was on my left.
Was anyone else to the left of Jameson?
Yeah, but we didn't know who was not with our group.
Yes, thank you. I should have asked a better question. Who was to the right of you?
Veronica.
Who was to the right of Veronica?
Kaylin.
Who was to the right of Kaylin?
Haley.
And again, these are approximations. I may not be touching the right seats. Is that fair?
Right.
Okay. And they're indicated on that people's exhibit that we just talked about?
Yes.
All right, after the arcade, all those kids in Jameson come back?
Yes.
And the movie starts? Yes?
Yes.
Do you have concerns that the movie now is not quite the family-friendly flick you thought it might be?
Yeah, during the previews, I kind of figured it was going to be a little more R-rated than I had thought.
What happened while you were watching the movie?
Well, I had all of a sudden during the previews, I heard something explode like to the back left of me.
And forgive me for saying, if you say back left, I'm pointing in a general area. Do you mean back in this area here?
Yeah.
Okay. And do you know what it was or where it came from?
No, I didn't see where it came from, and I didn't know what it was at the time. I just had heard something explode and then a bunch of gas coming out, and I don't know, I assumed it was a stink bomb from when I was like in high school, but I recognized it didn't have this smell. So.
Then what happened?
And then as soon as because I had turned my head, as soon as I heard it explode, and then right when I went to turn my head forward, I saw a flashing light in the sky, which I thought was or not in the sky, in the air, and I thought it was a firework.
Do you know where in the theater the firework thing seemed to come from?
Yeah, it seemed to come from like upper left.
I would give you the pointer, but are you talking about in this area where I'm pointing here or somewhere else? Tell me where.
Well, I guess a little like more towards the middle front, like, yeah.
And you thought you saw something that was fireworks?
That looked like fireworks to me.
Now, before all that happened,
Mhm.
before the movie starts, without going into any words that were spoken,
Mhm.
where was Veronica at first sitting before you moved her?
During the previews, she was sitting on my lap.
Did you move her to that seat that you've indicated?
Yes, I did.
And why?
Just, she was, because I had just found out I was pregnant, and it just kind of hurt my stomach a little, and she was a very tall, bony child, so I had her move to the seat next to me.
Okay. So you hear that thing hit behind you and explode, the gas. You talked about the fireworks thing that you think up here. By the way, at that point, do you have any idea that it's gunfire?
No. I had no idea.
What did you do?
Well, I assumed it was just kids playing pranks. So my first thought was to leave the theater, but I went to stand up to reach for her hand to try to exit.
When you say her hand, you mean Veronica?
Veronica's hand, yeah.
Okay. Did her hand reach back?
No, I couldn't feel it. Like, it slipped through my hand.
Were you able to stand up?
As soon as I stood up, I just remember getting a hit in my chest. And I remember falling, then landing on top of her.
Do you know what hit you in the chest?
No, I thought it was a firework at the time.
When you fell on top of her, could you feel her moving?
No.
Could you feel her breathing?
No.
Could you get off of her?
No. I tried, but I couldn't move.
Do you hear anything going on around you?
Yeah, I hear the movie still playing and people crying and screaming and yeah.
Were you scared?
Yes.
What happened?
Well, the next thing I know is I was getting carried out, which I vaguely remember, out of the theater.
Do you know who carried you out?
No.
Do you know which direction they carried you out?
I mean, I kind of felt like it was down that way and out.
Out the aisle this way, and I'm using my finger.
Yeah.
And down as you're facing the screen, the right steps, and out the door that I'm pointing to towards the parking thingy?
Yes.
Did you see your daughter get carried out?
No.
When you got to the hospital, and you know what, ma'am, let's do this. We don't need to talk about this part anymore. Do you want to go back there?
Yeah.
Let me take that.
Marshall, we've been covering this case, working on this project now for almost 3 years, and this is a big day on the project for everyone who's been following it from day one, but certainly for the survivors as well. Don't worry about it.
I know.
It's live. Don't worry about it. But, I mean, this is a milestone in the case. What is your impression of the people that you've been able to talk to, the survivors and families and victims that you know?
That this is too long of a process, for sure. It was interesting when the defense was questioning Hillary Allen today. Tamara Brady said, "I know we're going back so far. It's hard. It's 2015, and we're asking you questions about 2011."
Right.
And sarcastically in my head, if I was on the stand, I would have been like, "Yeah, you guys took forever to get this case going." Like, yeah, it's almost 3 years. If 2 weeks go for the defense, I mean, we could be looking at a 3-year anniversary around the time that the decision from the jury has been made,
right,
or that they'll still be deliberating, or we've moved into sentencing perhaps. But I know from the family members, there are family members of the victims that were killed that have uprooted their lives, and they live here part-time to be here throughout the weeks.
Right.
And those are just the ones that are able to do that. And they do it to remember their family member that was killed. But I'm sure they'd rather be doing something else besides sitting in a courtroom looking at the person that killed their family member.
Terribly. I mean, it's terribly emotional, and you can see on the stand not just someone like Ashley Moser tearing up when they see that, but just the way that they avoid looking at the defense table.
Mm-hmm.
It's something that we've seen very consistently, and who could blame them?
And I was actually wondering during Ashley Moser's testimony just now, what it takes to prepare her, and the professionals that have to prepare her for the day that's going to come, which was today,
right,
that has probably been weighing on her. I'm sure this is not, maybe this is part of the healing process, but from whatever help she's getting, I wonder, it's like, okay, it's out there in the distance, kind of like the start of the trial for us. It's like we knew it was going to come, but maybe it really wasn't going to. Here it is. You're eventually going to have to testify. I know you're going to be emotional. We're trying to get you to a healthy place. This is going to take you back to a place where you don't necessarily want to relive. And it can't be easy for any of the survivors, let alone Ashley Moser. And I don't know if you saw on the bottom, Craig Apple, who sits, he's the one that took the stand again today.
Right.
And he sits closest to the podium. in the back row. I saw him as she was giving her testimony. He doesn't wear glasses, but as she was giving her testimony, you know, he was going like this. Right. And he's read every report.
And he's interviewed a lot of these people before.
Mm-hmm.
Yes. And now, well, starting next week, they're going to have to start to hear people saying that this was not someone who can be legally faulted. This is someone who's legally insane, and they're going to start having to sit through these arguments. They're not arguments about this man is guilty, the arguments that obviously so many of the survivors want to see, because that's one of the reasons they've cited for pursuing the death penalty. They're going to have to sit through and hear the opposite side now.
This is where it gets technical, pretty much from a medical standpoint. And I know, I've learned a lot about case law and trials, what's
Over the last
allowed.
couple years.
Yeah, what's allowed, what's not allowed. I didn't know emotional testimony was not allowed, except as it pertains to what the person experienced.
It's very different than television. I mean, right now it is, in a way, television, but it's not that kind of television stereotype that you have in your head. I agree.
And now you're going to see a complete 180. If the prosecution's pseudo intent was to reveal some emotion to the jury and get the jury thinking emotional, which is very limited by the judge, picture what's going to happen with the defense being very clinical, very scientific, very medical about everything to let them know. Now we're going to focus on the part that we keep saying, it's the insanity part, and that's all the defense is going to focus on.
Right, and that's why their case is going to be so much shorter, but they also need to focus on their own experts, and of course their own experts had very different interactions with the defendant than the state-appointed experts, and they had limited time, and it was in a jail, not in a hospital, and there's lots of things that it's going to be very difficult for them to overcome these two experts, even though one was pushed aside in a way and said incomplete and inadequate, but he still came to essentially the same conclusion, at least the same pertinent conclusions, and now they're going to have to overcome that. It's a tall mountain for them to climb.
You're going to see a lot, I believe, from both sides. You're going to see the defense questioning their experts as saying, you determine this. We heard from this person. Why did you do it this way? And maybe we won't hear that from the defense, but we're definitely going to hear that from the prosecution in cross-examination. Well, we had a guy videotape 22 hours. You met him for 5 hours and didn't video. Why did you do that? Why should we believe? Things like that.
Right.
And it's really going to come down to trust. And who do you believe the most? That's maybe what it really comes down to, the jury. Who do you believe? Which doctor do you believe the most?
And the way that they question those witnesses, those defense-hired experts, is going to be very different. They're now, we've learned from our legal experts, our legal team, they're now going to be able to be more offensive in the way that they ask their questions. And I don't mean that in the, in that way. I mean in the way that they're going to be able to be on the offensive when they do their cross-examination. And, court is back, so we're going to send you back in the courtroom as they finish up these discussions.
This is the people of the state of Colorado versus James Eagan Holmes, 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. All right, Ms. Nelson.
Your Honor, at this time, the defense moves for a judgment of acquittal on all counts charged in the complaint. The defense submits that the evidence, when viewed as a whole in the light most favorable to the prosecution, is not substantial and sufficient to support a conclusion by a reasonable jury that Mr. Holmes formed the requisite mental state for each of the charged offenses. With respect to the counts alleging after deliberation and with intent, counts 1 through 12, 25 through 82, 143, 145, 147, 149.
Hold on, let me keep up with you.
It's okay. It's just all the intentional counts, but
Okay.
149, 151, 153, 155, 157, 159, 161, 163, and 165. The defense submits that the evidence, when viewed as a whole in the light most favorable to the prosecution, is not sufficient to support a conclusion by a reasonable jury that Mr. Holmes possessed the specific intent to cause the death of any particular victim. Other than that, Your Honor, we stand on the record and cite to Mr. Holmes' state and federal constitutional right to due process pursuant to the 5th Amendment, 14th Amendment, and Colorado Constitution, Article 2, Section 25. In addition, because this is a case in which the prosecution is seeking the death penalty, the defense maintains that a heightened standard of reliability applies to this and all stages of the proceedings. We cite to Beck versus Alabama, as well as the Eighth Amendment and Colorado Constitution, Article 2, Section 20. And that's all the argument that I have.
All right, thank you. Mr. Orman?
Your Honor, regarding the culpable mental state for, well, I guess this can be divided into a few different groups of charges. There's start with the charge at the apartment, the incendiary explosive device. I think that people have presented ample evidence that the defendant formed the requisite culpable mental state for that offense. He put all that together. The court saw that he did research on how to make bombs. There's additional screen captures that show that I did not publish but are in evidence that show that he was looking on numerous searches how to make pipe bombs, various combinations of incendiary materials, and I don't think any further discussion of that is warranted unless the court has questions on that.
The culpable mental state element of that offense is knowingly, correct?
That is correct, Your Honor. Regarding there's then other types of charges in this case. We have, for the 12 deceased victims, we have 2 counts of murder each, one under after deliberation with intent and the other under the extreme indifference theory. Same for all of the victims of the various counts of attempted murder charged under both theories. I will spend most of my time, and I'm going to try to be brief, but I want to be also, I just want to get out what I need to say here. For the charges of attempted murder after deliberation and first-degree murder after deliberation, I think the court can look at all of the facts and show that we have shown overwhelming evidence of the requisite culpable mental state of after deliberation with intent. In fact, I doubt there's ever been a case presented in the state of Colorado that has had more evidence of deliberation and intent than we have presented in this case. And frankly, I doubt there's been many in the United States.
I think there was an argument that there's not sufficient evidence that the defendant possessed the specific intent to cause the death of any particular person.
Well, yeah, I heard that argument, Your Honor, and I will address that. Look at the weaponry that he acquired. Serious machinery of death and mayhem. And when I say mayhem, I mean that in the sense that Blackstone, the common law sense, not the colloquial sense of the word mayhem. And he, in fact, did cause mayhem in the common law sense, as Blackstone would have known it. He had a tactical pump-action shotgun that he went in that theater loaded with 6 rounds. Each of those rounds containing, as Dale Higashi said, 100 pellets. A semi-automatic assault rifle with a 100-round drum magazine. I submit to the court that shows he went in there with the intent to kill everyone in the theater. We have a handgun with, I think the evidence shows, probably had 16 rounds in it. In the theater were found 65 spent .223 casings, 6 spent shotgun shells that contain 100 pellets apiece, 5 spent .40 caliber casings, 218 live .223 rounds, and 16 live .40 caliber rounds. Outside the theater, the rifle had 31 rounds in it. The Glock on the roof of his car had 16 rounds in it. So he went into the theater with at least 314 .223 rounds. And but for the malfunctioning of the drum magazine and the other facts and circumstances, he would have killed a lot more people. We have the ammunition outside the theater, Your Honor. There were 13 .40 caliber magazines with a total of 240 rounds. There was a .223 magazine with 31 rounds in it. Plus there were 2 .223 magazines in the car. Now they didn't count the bullets in those, but they appeared to be full 30-round magazines. And 2 stray .223 rounds in the car. And in the car were 6 buckshot shotgun shells with 8 pellets each. So adding up what was in the theater and what was found outside, the defendant drove to the theater with more than 400 .223 rounds. I think 407 is the exact count. More than 275 .40 caliber rounds. I think 277 is the exact count. And 12 shotgun shells. In other words, and each of those had 100 pellets in it. But even without counting those as 100 pellets each, he went to the theater with close to 700 rounds of ammunition and 4 guns. I think it's also important to note the testimony of Dale Higashi that the .223 rounds were steel penetrator rounds. These rounds, Your Honor, went through the theater seats and the wall to Theater 8 as a hot knife goes through butter. We have testimony of witnesses that show the defendant aiming into the places in that theater where people were located. We have testimony of victims indicating that as they were fleeing, the defendant shot at them. We heard from Ashley Moser today that as she stood up, she was shot. We had testimony that this is a semi-automatic .223 and that the shotgun required a pump action between each shot and that the handgun required an individual pull of the trigger to fire each bullet. Every time the defendant pulled the trigger of any of those guns, his intent, and I don't even think I need to talk about deliberation, it was so much evidence of that. His intent was to kill whatever person, and he saw particular people and aimed at particular people, was in the path of that bullet. So he went into the theater with malice aforethought, with long and extensive planning. He had bought targets, he had gone to a shooting range. He searched for shooting ranges on the internet. He went to that theater, stepped out feigning a phone call, and his car was parked right outside. He came back into the theater, and the evidence shows that what his intent was to make a corpse of every living soul in that theater. That's what he went in there to do. That he did it with 12 people, and he tried to do it with everybody else. I could see, and I appreciate counsel not belaboring this in her argument, I could see an argument for a differentiation between the people in Theater 8 and Theater 9, and I imagine Your Honor would ask me about that. So unless Your Honor doesn't want me to argue that, I have some thoughts on that.
Go ahead.
I think it's important for the Theater 8 victims to remember the testimony about the steel penetrator rounds and the visual evidence that Your Honor saw about how those rounds went through that wall and people got shot in that other room. The defendant picked a round of ammunition that would do that, pulled the trigger on that gun over 60 times. He intended to kill what was ever in the path of those bullets. So I think if you look at the statute on criminal attempt, he had the requisite culpable mental state, and he took a substantial step towards killing people in Theater 8. And we charged 3 of them as victims. We could have charged everyone in there as a victim of attempted murder. We could have charged everyone in Theater 9 as a victim of attempted murder because the defendant went in there to kill all of them. That was his intent, and he took a substantial step towards doing that. We limited our charging because, frankly, we knew that the evidence in this case would be voluminous, and we knew how long a trial would take. We called every victim charged as a victim of attempted murder, or listed in one of those charges, and imagine how much longer this trial would have taken with 400 people or so charged. The other, I guess, theory that we could proceed under on Theater 8, and this is a little bit more esoteric, in addition to what I said, and I think that establishes enough evidence for the charges in Theater 8.
Well, before you move on from Theater 8,
my understanding of Colorado law is that you don't have to prove that the defendant intended to kill one of the specific victims who was killed, that the proof that's required is
that the defendant intended to kill a person and then ended up killing someone, whether it's that person or someone else. Is that right?
That is absolutely correct, Your Honor. That is drafted into the statute for first-degree murder. And you require to intend to kill a person and another person, or that person gets killed. It doesn't matter who, or multiple people get killed.
So in terms of Theater 8, there doesn't have to be intent to kill anyone in Theater 8 as long as you prove beyond a reasonable doubt that after deliberation, he had the intent to kill someone in Theater 9, and then someone in Theater 8, let's say, was killed. Then your position is you could still charge first-degree murder after deliberation and with intent with respect to that victim in Theater 8.
I have two theories on that, Your Honor. That is one of them. That's the one I was actually about to get to. The first one is he intended to kill whoever was in the path of that bullet, and he knew people would be there. He picked crowded places where he knew people would be. And that, we don't even need the transferred intent argument. But I would say also, Your Honor, yes. I mean, under the statute, I think Colorado has adopted, per se, what the common law would have called transferred intent in a homicide case. And I think Colorado has actually expanded it and made it more certain as to what is meant by that. A lot of states still have common law murder, and they just have courts deciding about transferred intent. But Colorado has made it clear, and I think if you look at the statutes, this fits. The Theater 8 people fit within what the statute says. But even if we were just going under common law transferred intent, I could not find a specific Colorado case applying the concept of transferred intent to attempted first-degree murder after deliberation, and I looked. I did look in other states, and I can, if the court is interested in what other states have said on this point, I can provide some citations to the court. If the court doesn't need that, I don't want to waste the court's time.
You can give me a summary if you want.
Your Honor, there's a number of states. I'll just cite to a case from Oklahoma. Short versus State, 980 Pacific 2nd, 1081, which is from the Oklahoma Court of Criminal Appeals in 1999. And it's sort of a similar situation to this, although not as many victims. And it's a very long case, Your Honor, specifically pages 1097 to 1099, long discussion, finding that transferred intent applies to attempted murder. Also in favor of that concept would be People versus Ephraim, EPHRAIM, from the Illinois Intermediate Appellate Court in 2011. The citation there is 753 Northeast 486, with a long discussion on page 496. Also supportive of this concept, Your Honor, would be People versus Backdash, BACKDASH, which is at 890 Northwest 2nd, 906, Minnesota Intermediate Court of Appeals, and I'm not exactly sure what that's called, but it's Minnesota App 2013. So it is, I think, a recognized concept of transferred intent, even in attempted murder after deliberation. So I think the people have shown sufficient evidence to submit this case to the jury on each and every count charge, and unless Your Honor has any questions for me, I'm done talking.
Just going back to your other theory, not the transferred intent theory, but the one that says he intended to kill anyone in the path of the bullet, your position would be that with respect to the folks in Theater 8, that he shot at the wall in Theater 9, knowing the power of the bullets, and his intent was to kill anyone in the path of that bullet or those bullets that went through the wall that divided Theater 8 from Theater 9.
That's right. That's right.
All right. Anything else?
Just one thing, Your Honor. I would cite to the court a Colorado case that says we can proceed under both theories of extreme indifference and after deliberation, and we don't have to, and there's nothing impermissible about submitting both of those to the jury and having them reach verdicts on both of those. And they are not mutually exclusive or contrary. And that would be Candelaria versus the People. And that's CANDELARIA, 148 Pacific 3rd, 178 from the Colorado Supreme Court, 2006.
I believe that's an opinion by Justice Coates, right?
Your Honor, you got that on me. I don't remember what justice wrote that.
It is, Your Honor.
All right, thank you, Ms. Nelson. In terms of the extreme indifference count, your position is that the mental state element required, or the culpable mental state element required, is knowingly, and that there is sufficient evidence here with respect to the deceased victims in Theater 9 as well as the surviving victims in Theater 9 and Theater 8.
Yes, Your Honor.
All right. And by the way, I know that there are no deceased victims in Theater 8. My discussion earlier with Mr. Orman was just for purposes of understanding his position. So, all right. Anything else, Mr. Orman?
Not unless you have any questions for me, Your Honor.
I do not.
Thank you.
Thank you. All right. The case that set the standard governing motions for judgment of acquittal is People versus Bennett, Bennett. That's a Colorado Supreme Court case from 1973, and it's published at 183 Colorado 125, 515 Pacific 2nd 466. In that case, the court said that when a trial judge is confronted with a motion for a judgment of acquittal at either the close of the prosecution's case or the close of all the evidence, he must determine whether the evidence before the jury is sufficient in both quantity and quality to submit the issue of the defendant's guilt or innocence to the jury. To withstand the motion for a judgment of acquittal, the prosecution has the burden of establishing a prima facie case of guilt and must introduce sufficient evidence to establish guilt beyond a reasonable doubt, no more, no less. In passing upon a motion for judgment of acquittal, the trial judge should not attempt to serve as a 13th juror or to invade the province of the jury, but should prevent a case from being submitted to the jury when the prosecution has failed to meet its burden of proof. The issue before the trial judge is whether the relevant evidence, both direct and circumstantial, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. And I'm reading from different portions of the opinion in Bennett. Finally, the Bennett court said that in passing on the motion for a judgment of acquittal, the trial judge is required to give full consideration to the right of the jury to determine the credibility of witnesses, the weight to be afforded the evidence, as well as the right to draw all justifiable inferences of fact from the evidence. When viewing the evidence in that light, the trial judge must determine whether a reasonable mind would conclude that the defendant's guilt as to each material element of the offense was proven beyond a reasonable doubt. If the evidence is such that reasonable jurors must necessarily have a reasonable doubt, the judge must direct an acquittal because no other result is permissible within the scope of the jury's function. So in this case, given the relevant evidence, both direct and circumstantial, when I view it as a whole and in the light most favorable to the prosecution, which I'm required to do at this juncture in the proceedings, I find that it is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of all the charges beyond a reasonable doubt. I agree with Mr. Orman that the culpable mental state element required by all the counts related to the deceased victims that have charged the defendant with first-degree murder after deliberation and with intent is after deliberation and with intent. That's the culpable mental state. And but it doesn't relate to any particular victim. In other words, the prosecution doesn't have to prove that the defendant, after deliberation, intended to kill a particular victim in that theater. For example, let's say that John Doe was at the theater among hundreds of people. The prosecution doesn't have to prove that he intended to kill John Doe. The prosecution has to prove beyond a reasonable doubt that after deliberation, the defendant intended to kill a person, and that the defendant then killed a person. So in this case, the evidence is both substantial and sufficient, at least when viewed in the light most favorable to the people, to support a conclusion that the defendant, after deliberation, intended to kill a person, and that he caused the death of the particular victims who are listed in all the charges that deal with first-degree murder after deliberation and with intent. In terms of the charges that deal with attempt to commit first-degree murder after deliberation and with intent, the prosecution has proven, the prosecution has presented sufficient and substantial evidence, at least when viewed in the light most favorable to the prosecution, that the defendant acted after deliberation and with intent, and that he took a substantial step toward causing the death of a person, the person listed in each of the attempted murder, first-degree murder charges. So there is substantial and sufficient evidence when viewed in the light most favorable to the people that the defendant engaged in conduct that constituted a substantial step toward the commission of the crime of first-degree murder with respect to all the attempted murder after deliberation and with intent counts. In terms of the extreme indifference first-degree murder counts, the culpable mental state element required is knowingly. And again, I find that when viewed in the light most favorable to the people, there is substantial and sufficient evidence to support a conclusion by a reasonable mind that the defendant acted knowingly in terms of all those counts. And I'm focusing on the culpable mental state elements because that's what the defense focused on in its argument. But I am finding that the relevant evidence, both direct and circumstantial, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charges of first-degree murder, extreme indifference. The same thing is true for all the charges related to criminal attempt to commit first-degree murder, extreme indifference, all those counts. And then finally, we have the one count of possession of incendiary devices. And the culpable mental state element required there is knowingly. I agree with Mr. Orman that when the evidence, both direct and circumstantial, is viewed as a whole and in the light most favorable to the prosecution, it is substantial and sufficient to support a conclusion by a reasonable mind that the defendant acted knowingly in possessing the incendiary devices recovered from his apartment and that he is guilty of that charge. And so at this time, the motion for judgment of acquittal is denied. Is there any other record that the people want me to make?
No, Your Honor, thank you.
Is there any other record that the defense wants me to make?
No, Your Honor.
Okay. How about if we meet at 9 o'clock on Monday? Or do you want,
Wednesday.
or excuse me, Wednesday? Or do you want to do something later than 9?
I think 9 o'clock is good with us. There's one other matter I think I should just raise with the court.
Hold on, let me just make sure 9 is okay with Ms. Nelson.
9 is fine, Your Honor. We can do earlier too if you want, but 9 is fine.
All right, let's do 9.
I got in my email that I think the Denver Post, I'm not sure if it was other companies, had filed a motion with the court today regarding access to the admitted exhibits. And I don't know what the court is going to want, if anything, from the parties, but I don't know if you want to discuss that Wednesday when we're here.
That was my next note. Mr. Zandsberg apparently filed a motion. So how much time do the parties need to respond to Mr. Zandsberg's motion? I was thinking 6 weeks.
That would be sufficient, Your Honor.
That works for me too.
All right, that's what we'll do. Parties are busy, so is the court. All right, anything else on behalf of the people?
Thank you, Judge. Real quickly, I have 3 court trial exhibits. CTR 7-3, This is the, from yesterday, the hot mail that was pulled out, and then CTR 74. These are the additional 4 pages from the bench conference this morning, so I've marked all of those. And then People's Exhibit 347, which was the DVD from Microsoft. Was never introduced into evidence. I've marked that as CTR 75.
Okay, thank you. Ms. Spengler?
Thank you, Judge. I have one brief matter.
Yes.
Months ago, before we knew we'd have a break on June 22nd, this coming Monday, we had issued a subpoena, served a subpoena for a lay witness. So I expect that if they appear on the subpoena to return on Monday morning at 8:15, and I was hoping that the court or a court would be available to continue the subpoena until later in the week.
As long as there's somebody from your office available.
I'll be here.
Will you be here?
Mhm.
And somebody from the DA's office available? You want to be here? All right. I'll make arrangements and I'll communicate through my staff with both of you as to what courtroom, okay?
Okay.
All right.
Thank
you for letting me know. All right, anything else? No? Okay, I'll see you, some of you I'll see on Wednesday and the rest on Thursday. All right, the court will be in recess. Thanks, everyone.
"8 weeks on the button," which is what the prosecution had estimated it would take for its case. On day 35, the prosecution rests. A motion for acquittal is denied, and we'll have a 3-day break before Thursday comes back with the jury and the first day of the defense. Although, Phil, Wednesday we will have coverage of whatever they do in court. 9 a.m. on Wednesday, we will be black off the air. With the slate up Monday and Tuesday. There probably won't even be a link to click on necessarily. But Wednesday at 9 a.m., probably a little before that, we will continue our coverage and take you into the courtroom for whatever is happening on Wednesday as they discuss scheduling and what the defense plans to do over the next 2 weeks. They'll likely be discussing the instructions, the very lengthy instructions that the jury will get as soon as the defense is done. When the 12 jurors find out 12 of the 19 remaining jurors will find out which ones are actually going into the deliberating room. So we're going to leave it at that. It was a very powerful day of testimony. We already replayed for you Ashley Moser's testimony, the final witness, and I forgot to pull up the number of witnesses, but we'll definitely get that in our web story. But it was close to 200, if not more than 200. But the defense will start its case on Thursday, and we will be back here on Wednesday. So for Phil Tenser, Kim Wynn, who happens to be over here right now, Anika Padilla, and Brian Hernandez, who is spending his last day with us at 7 News. He's moving onward, so he won't be on Scribble next week. I'm Marshall Zellinger. We'll see you next week.